Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button for me. There's a PayPal link down there for anybody who wants to share some love. And of course, the StreamYard link is down there for anybody who wants to join the panel. And we do have Russ and Christopher with us already. Good to see you guys. We're going to be talking about the Trading with the Enemy Act today. But before we get into it, there's a couple other things we need to touch on real quick. First of all, it has to do with the birthright citizenship. Trading with the enemy. Where were you born? Were you born in an allied country or in a enemy country? And that relates to the birth registration, as I've been discussing for the last 8 years, and the identification that stems there from it. This birth certification is a false birthright. A false birthright, and the birth certificate is actually evidence of eligibility for American citizenship rather than United States citizenship. There is a distinct difference. One is a corporate entity. The other is reference to the soil. This is jus soli and jus sanguini. In other words, you're of the soil and of the blood. Jus soli and jus sanguini. Soil and blood. That is the problem with the birthright and the birth certification process. And one of the things I've discussed and done videos on was a minimum birth registration standards. And I've shown clearly that it does not meet the minimum birth registration standards. And in that means something is not completed. And as the process says, the United States Code says that a person's birth must be registered in the United States. Now, it doesn't say where, and there is no place where it is registered in the United States. And that is clear. They will tell you that the births are registered in the states. So it's sitting in one place and needs to be transferred somewhere. Okay? So we're going to talk about that high school diploma or the equivalency, because that diploma, the word diploma, has to do with diplomacy and being a diplomat and having diplomatic etiquette. In other words, being able to speak of sound mind intelligently so others can comprehend what you're saying. Greetings, Dunwit. How you doing today, brother?
I'm good. How are you?
Good, good. Glad to have you up. Just getting into the Trading with the Enemy Act and what it has to do with the birth registration, identification, and all that, and how it's a false birthright. Does that make sense to you?
Yeah.
Okay. And I think that's the main thing that's confusing people, is that 14th Amendment, how it brought in that false citizenship. So the first thing I want to look at, I've got this here. Now, President Trump tried to do something about it, and the courts turned it down. But he's spot on. So let's listen to what this gal's saying.
You realize that the first draft of the 14th Amendment, this federal judge stops President Trump's birthright citizenship order. And he says, how could any licensed attorney sit here and say that the 14th Amendment doesn't mean birthright citizenship for everybody?
Okay. So we know that they agree, and we should agree with them, because that is their intent and that is how they use it. The 14th Amendment is a birthright citizenship. Is that birthright citizenship valid? No. He is no respecter of persons. That is a birthright citizenship of a person, a legal entity of which has civil rights in commercial and political venues. That's it. Okay? Hope you understand that. Replay that part that I just said if you need to understand it as many times as you want, as many times as you need to. It's a false birthright.
Well, how about the attorney who helped write the 14th Amendment? Do you realize that the first draft of the 14th Amendment does just say all people born in the United States are citizens? And then Senator Jacob Howard,
all people born in the United States, the language is specific, and when you say you are born in the United States, you are in fact been deceived and are talking babble. You cannot be born in the United States. The United States being a fictional, special, maritime, territorial jurisdiction and nothing more.
introduces a second draft where it says all persons born in the United States and subject to the jurisdiction thereof.
And those prepositions are a motherfucker. And means one with the other. It does not mean independently this or that, but and. So the birthright citizenship born in the United States and subject to the jurisdiction thereof.
Are citizens. And this former state attorney general, he doesn't seem to think that it covered literally everyone present in the United States under all circumstances.
No, because it didn't. Until they added the and subject to the jurisdiction thereof. Okay? So when they added the and subject to the jurisdiction thereof, it denotes that there's something else in there that needs to be qualified. Okay? Not just being born in a certain place, which is already impossible because it's America, not United States. United States under 32 U.S. Code 15, or excuse me, 32 U.S. Code 3002, subpart 15, says United States is a corporation and not a federal government. And then 5 CFR 575.102 says federal government means all entities, legal and commercial is what they're talking about there, all entities of the government of the United States.
Oh, he says this means those people who are subject to the full and complete jurisdiction of the United States. That is to say, the same jurisdiction to which citizens are subject to. So
the distinction that we need to make here, in my opinion, is the citizen, because they keep talking about citizen, but they don't talk about United States citizen, American citizen, which are two different things. Exactly, Dean. Hit the link and come on up, brother. How does an equal man become a subject? Well, the thing here is and subject to the jurisdiction of the United States. Okay, so let's listen to the very last part she said here again.
Jurisdiction of the United States, that is to say, the same jurisdiction to which citizens are subject to. So
the same jurisdiction that citizens are subject to. Depends on what kind of citizen you're talking about there, because as an American citizen, the jurisdiction I'm subject of is John 1:1. In the beginning was the Word, and the Word was God, Word was God. And Jeremiah 1:5. Before I formed you in the belly, coming from God, I knew thee. It's when he wrote the word of his truth and his love on your heart with the index finger of his right hand, according to those same scriptures. And before thou camest forth from the womb, I sanctified thee and I ordained thee. This is the ordinances that they use to sanction your activities in the legal and commercial entities. a prophet unto the nations. How can I be a prophet unto the nation, the American nation, and its people, if the United States keeps taking from me for its own profit? Greetings, Dean. How you doing today, brother?
Doing well. Thanks for having me.
Awesome, awesome. Glad you're here. Lowrider says, Keith, you're killing it, bro. No, I'm bringing life to the bullshit that you need to see, because that's the glory of God. He provides everything I see. Anyway, so what we've got here today is, and I'll let everybody know, Dean here is one of those lions of the house of Judah. He's standing strong in the same word. I believe he's going to follow along with this real well and have some good input here today. And Dunwit, it looks like your device disconnected, so please feel free to jump back up, and we're going to get into the material shortly. But Dean has been going through a lot of the things on or in life, and he's been expressing what's going on in that stuff through Lawful Living, another community that I'm involved in, and I want to plug them real quick. LawfulLiving.com. Get over there and check them out, or you can go to freedomfromgovernment.org, and it's all merged today. Trent James Goodbody used to do freedomfromgovernment.org, and our friend Malika has now taken over that and merged that with her Lawful Living unit. And there, folks, we're getting a lot of successes, minor and major, from just little traffic citations to kidnapping at the international level, where they kidnap your children and try to say, no, we have custody, we have the authority over your child. No, you don't. That's Deuteronomy 24:7. That's kidnapping. So it is about the birthright citizenship, folks. And when it comes down to it, we're talking about acquiring things in life. And as it goes to acquiring things in life, it's relative to the federal acquisitions regulations. This is why they have a Trading with the Enemy Act for their acquisitions. Anything they acquisition for the government or for the government's beneficiaries or agents, they have to make sure that they're operating in good faith and good dealings. Good faith and fair dealings. And so they fomented this Trading with the Enemy Act prior to World War I. And World War I was, in case you didn't understand, and I'm not going to get into it any deeper than what I mentioned here today, but Germany was a system of member states of the Holy Roman Empire. Okay, when people think that Rome died, it didn't die. It was converted to, I think, 12 German states. Okay, that's why we have German, Roman Catholic, and such a large portion of population in America as Germans. I'm German myself. Understand the history and realize you've been duped, because at the time of World War I, they had already dissipated 10 German states, and there were only 2 German states left. Guess who they were? Okay, Germany and Austria. Now, they killed Duke Ferdinand. Now there's only one. So why do you think Germany stood up? They saw themselves being wiped off the map. And just them being together with Austria after they already tried to already successfully destroyed the 8 or 10 other member states. World War I was about taking out the Germans. It wasn't necessarily about genocide. They were going to let them live, but it was about taking out the Germans so they couldn't have power. Who do you think wants that power? Germany just wanted to be left alone, folks. I don't care what kind of story you got. So let's take a look at 48 CFR 4.2301 definitions. This is in relation to the Federal Acquisitions Security Council, which is subpart 4.23 of Title 48 of the Code of Federal Regulations. As used in this subpart, covered article. This is the birth registration. This is the birth certificate. That's what an article is. It's a documentation using words and terms of art of the legal system. Information technology, as defined in 40 U.S.C. 11-101, including cloud computing services of all types. This is modern definition now. The very thing that we're sitting on doing this stream on. Telecommunications equipment or telecommunications service. And guys, anytime you have a question or anything, stop me. Because otherwise I'm just going to keep on going.
I don't know if Chris is aware that he's muted, but I know he did have a question for you before you started here.
Oh, okay. Yeah, is that a valid question for the current time and position, Chris? Or is that something you wanted to ask in private?
Oh, no, that was, I was just gonna, I didn't know that you were actually, I've been seeing a lot of your stuff pop up on Pastor of the Way's, Telegram group. So nice to meet you, Keith. Now to see your face and
just, yeah, absolutely. I've been doing this 8 years solid at least, but I've got other things in my history of experience from independent contracting and running my own business and stuff that I've run across in the previous years. And then finally I got tired 20 years ago and said, I'm done paying taxes. And then I realized child support's along the same thing. And so it just kind of kept building until I finally said I'm done about 8 years ago and started doing the traveling thing too.
Okay.
And that's when I realized everything is about that identification and Social Security, which relates to the birth registration. It's all identification. It's a false one.
Yes. Identity is the lens that filters everything we see.
Yep.
I'm also dealing with child support as well. So this is very helpful. So I appreciate it.
Cool. Yeah, we'll help you figure that out and let them see. That's a Title 4D contract that you're supposed to be a within the foster care and adoption system taking care of a child. Are they charging you child support for your biological heir?
Yes, sir.
Oh, goodness gracious. Then where's the foster care contract to take care of a child of unknown parentage? Oops.
Exactly. Yeah.
So,
and one of my child is I actually live with and have been living with her since she was born. So still paying child support even though she lives with me, and we've, kind of crazy how all that gets tied in and how I didn't understand it at first until I started looking into this. So very interesting to learn and understand.
Yep. And I think it's imperative that we start bringing about this teaching above and beyond. The public education system itself, folks, is fine. It can help take care of some basic, simple duties to enhance an education that otherwise wouldn't be there. In other words, when I was growing up, I suffered the public education system, but when I was adopted in that foster care system, the people that adopted me also homeschooled me with that public education. So it's a way to enhance a homeschooling. It's not something people should be giving up the homeschooling for totally so that they can go about in this hedonistic way of life. That's the problem. People, every nation in the history of mankind that has fallen due to being so successful that the population turned hedonistic. Okay. So telecommunications equipment or telecommunications service, as those terms are defined in Section 3 of the Communications Act of 1934. Now, again, this is modern terminology, as this device I'm on right now is a telecommunications device. Okay? The processing of information on a federal or non-federal information system subject to the requirements of the Controlled Unclassified Information Program. Hardware systems, devices, software, services that include embedded or incidental information technology. FAFSA order means any of the following orders under the Federal Acquisition, Supply Chain Security Act. So what we're talking about here is a chain of title that has changed the supply chain, and therefore your demand is not being carried out, or the command, his command is not being carried out, and you will never prosper in abundance. Requiring the removal of covered articles from executive agency information systems, or the exclusion of one or more named sources, such as the informant. The informant's information and its source were deceptive. Mom was induced herself as an informant when they gathered that information. If she was of sound mind, she'd have let them know, no, he will make that choice, she will make that choice upon age of majority as to whether or not to be subject to the jurisdiction of the United States by coherently making a decision himself of whether he wants to be an American citizen or a United States citizen, as we bring him up in the ways of the Lord, teaching him that you cannot serve two masters. You must pick one or the other. And like I said, those scriptures also say he is no respecter of persons. So if you bring your children up in the ways of the Lord, it will only be the heathens that you are able to put in place of government, and then they will know you are their boss. No other way. The Secretary of Homeland Security may issue FAFSA orders applicable to civilian agencies. No one else. Don't ever pretend that it means anything other than civilian agencies. To the extent not covered by paragraph 2 or 3 of this definition, this type of FAFSA order may be referred to as Department of Homeland Security FAFSA order. Okay? Who do we address in a redress petition of the government? Anybody know? Russ, Christopher?
Who do we redress?
Yeah, who do we present it to as a matter of redress?
I'd say the clerk. The local level.
Many times. I've mentioned it many times, and my sister Malika on Lawful Living is one of the ones that brought me onto this. Homeland Security. Look it up. Let me pull it up real quick. Homeland Security Redress Program. Now, when I punch in Homeland, Homeland Security Redress Program, It brings up Traveler Redress Inquiry Program. Guess who this applies to, folks? Such individuals as has been misidentified. What do you do when you graduate high school and get that diploma showing that you've been diplomatically trained in diplomacy? Where you learn the English language and how to speak and be polite about it. And of course, along the way, you picked up some extracurricular cuss terms, but those are supposed to be left aside, right? So anyway, you got this diploma. But instead of following up on the diploma and acting diplomatically, we're all induced into going and get that state ID or the driver's license.
Right.
Oops. Got to stop it. We've got to teach the younger generations the difference. You cannot serve two masters. You cannot say you're a child of God and walk around with a fucking state ID in your pocket. You have to be able to get over the fear and tell these people, you're not my daddy. Fuck off.
So I do have a daughter who's getting ready to, well, she wants to go and get her driver's license. What would it, how would I be able to explain to her? Because I've already talked to my children.
We're going to go over that. We're going to go over that. Everything's going to be done from now on, in my opinion, and this is where I'm moving to, is Department of State. Okay? It's the Department of State that deals with diplomats. So as a high school graduate that has his diploma, rather than going to the state for a driver's license or an ID, I go to the Department of State. You have on record a file assigning a social security number to this individual. At age of majority, that individual does not wish to accept your offer. I remain an American citizen. I do not wish to undertake United States citizenship, which means a United States business, which means taxes, surety, and other obligations and liabilities that I am not competent of, as I have not been elected, nor appointed or assigned, nor do I wish to. The Department of Homeland Security Traveler Redress Inquiry Program is a single point of contact for individuals who have had difficulties during travel screenings at transportation hubs.
That's a D.U.M.B and stuff, isn't it?
Oh, what's this?
This is, well,
Is this not a transportation
it is.
hub? Are we not using a vehicular language? Are these not the portways, the streets, the paths that our communications follow? Such as airports or U.S. borders. United States borders, commercial borders. Is this a legal entity or a commercial entity? This is operating right now in a legal entity capacity. Now, if somebody wants to hit that PayPal link, I'll remind you again, it's down in the details section. All love is greatly appreciated. If somebody wants to hit that, then that becomes a commercial venue. That's within the United States borders. That's that special maritime territorial jurisdiction. These difficulties include denied or delayed airline boarding, repeated additional screening, or denied or delayed entry into the United States via airport, border crossing, or seaport. In June 2024, following up from the October 2023 initial release of Spanish, DHS TRIP has expanded the multilingual support tool of the Arabic, Simplified Chinese, and Taiwanese speaking communities. Travelers may now view the application resources in Arabic, Spanish, Simplified Chinese, and Taiwanese by toggling their preferred language at the top of the website. Topics: privacy, preventing terrorism and targeted violence. Can I see your ID? Sorry, sir. I don't carry ID. You don't? No, I don't. I do carry private diplomatic credentials, though. Oh, can we see those? Sure. And there's no photo ID. There's biological properties known as fingerprints. Think about this stuff, people, and understand. You really need to start doing your research. And like I've said many times, don't believe me, don't believe the neighbor, don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. Let's take a quick break. What do you guys got? What do you think so far?
So for what you said, Keith, whenever you said, who do we address or present for redress, that would be Homeland Security Redress Program, correct?
Correct.
Okay.
And you're going to do it coincidingly with Department of State at the same time. You can give them notice, hey, I found out that I've made an error. It's caused a lot of accidents, mutual mistakes, but it does need to be corrected as it goes to the integrity of the record, as well as the integrity of my well-being. It has caused irreparable harm and damage, and I can no longer suffer it.
Okay. And you said that would be Department of State and who else?
Homeland Security and Department of State.
Okay.
Okay, so let's get back to it here.
And that's hey Keith, I just want to say that's right on point, because these days we're trying to figure out how to get down to Mexico to get some affordable dental work and still get back without having any of that nonsense.
And who do you communicate with in those situations? The embassy, Department of State, Bureau of Consular Affairs. They're the ones that have to do with diplomatic details. Well, what's a diplomatic detail? Well, that's somebody that's working for the United States that has to do with another foreign embassy. What about foreign service? Okay, well, same thing. You've got an agent instead of an official of an office. He's operating in a foreign country as an agent, and the same thing. Well, what about the right of a private people to conduct their affairs with the same protections? That's the problem.
Right.
This is fomenting that it's going to protect you, when in fact it's targeting you. That's what the ID is. It's targeting you. You're not a qualified United States citizen. Department of State hasn't had any notice. It's only a presumption. And then if you give them notice, you can't take upon American citizenship because you gave that up in exchange for the United States citizenship. So as the presumption lies, you're a United States citizen because that's what you presume. The record doesn't reflect that unless you say so.
Certainly no oath on file.
Exactly. So,
and Keith, how do we attain these private diplomatic credentials that you were speaking of?
Didn't you get high school education credits?
Yes.
Okay, that's credits. Now you've got a diploma, right? Aren't those diplomatic credit? Isn't that diplomatic accreditation already?
Yes.
Okay. I'm already accredited. You got a diploma on the record. What do you think diploma means?
Okay, so
you can't deny it. You're the ones that accredited me. Let me show you something. We're gonna look at. I didn't want to do the Lieber Code thing because it ties in directly, of course, but at the same time, that's
Hey,
something
Keith?
I want to do separately. Go ahead.
Before you go to that, though, when you're talking about diplomas, it probably doesn't matter, no difference whether it's high school, college, whatever.
Yeah, none. They're all educational credits as
All
a
right.
matter of diplomacy, language etiquette. Okay, so as we look at the Lieber Code, this is Article 9, okay? And it says the functions of ambassadors, ministers, or other diplomatic agents accredited by neutral powers to the hostile government. Cease, so far as regards the displaced government, but the conquering or occupying power usually recognizes them as temporarily accredited to itself. The United States is the occupying power that accredits you through the public education system when you get that high school diploma. Does that make sense, guys?
Yes.
Okay. So let's go back here. The Secretary of Defense may issue facts or orders applicable to the Department of Defense and national security issues or systems, excuse me, and other than sensitive compartmented information systems. The birth registration is a minimum standard under the Department of Defense 5 U.S.C.O.W.A.R.D.S departmental regulations. And the reason that they're supposed to issue a birth certificate is because the men that enter the Army have to have certain documentation in regards to inheritance if they die in foreign soil and are never returned. There's a birth certificate then that is on file that has those accreditations and a value stuck in there that can be passed on to that legacy heir. It's the only reason.
So would that mean that anyone who holds a birth certificate is under the occupation of the military?
It lays that presumption, yes.
Okay.
It can. And so what it is definitely a military document. And while you're in possession of it, it would make a presumption that you must be in the military in order to possess military property. However, because it's an imperfect usufruct, and it is in fact a document of title, you can use that as evidence of the birthright. Does that make sense?
Sort of, yes. I guess my question would be if their presumption is that we are in the military or hold an occupation in the military, how would we fix that? How would we reverse?
Same thing. It's all gonna be fixed with the Department of State Homeland Security as a matter of redress for misidentification.
Okay, redress.
Ever since I was a wee little boy, and they took me to the doctor the first time, they placed some kind of information into a system in relations to myself as an adult now, and you can still go back and look at that minor record, and it's going to be all that information in there. All my hospital records, all my education records, all my employment records, tax records, everything. Social Security. It's the estate record through Social Security. Health and Human Services, each state has to have a state recovery program, and it is operated through the Health and Human Services, the birth registration of Social Security.
Okay.
And I've showed the vital statistics, and I'll show it again here, just for your sake. Let me blow it up a little bit. This is page 7 of the vital statistics thing. It says vital records and vital statistics in the United States, uses, users, systems, and sources of revenue. So it's an information system that we're talking about now. It says current birth registration process for a state, vital records jurisdiction. This is the original jurisdiction. Shows you how the birth registration is monetized.
Wow.
Used throughout their system. What happens when you die? You get a death certificate, and it tells you how that record is settled for the National Archives. It's a matter of national importance. It's got a historical value. Historical value. Yeah, it may have a historical value, but it damn well better have integrity to maintain that value. And in order to maintain that value, that integrity has to be there. And I'm telling you, folks, that the that the whole shit and kabang and caboodle is not worth a fuck, because it's all done in the wrong manner. In other words, it's done when you're born rather than waiting until your age of majority and you get to make that choice yourself. It's done presumptively.
So my mother passed away 8 years ago, Keith. And I guess she never knew anything about this. Wasn't informed about this information. What can I do?
Settle the estate. That's the actual estate that belongs to you. It's never been settled. Home or Health and Human Services went in and got everything that's owed and was due and owing to them according to that. But that's supposed to have been transferred to you in a will. It doesn't happen in probate courts because it's a parentage, unknown parentage. So they're not going to look for you.
Ah, okay.
But you have record a death certificate saying that she passed on, and it's my opinion that you take that to Health and Human Services Estate Recovery Program and say, hey, I need to check the record to find out if there's any value in there that was supposed to have been transferred as a matter of credits. Insurance credits, tax credits, educational credits, or anything that were supposed to be transferred to any heirs. Is there any surplus?
Okay. Do you mind if I get with you after this live and maybe go over that some more? Because my brothers and sisters didn't want anything to do with it, so I made it a priority of mine to kind of settle that estate. Just didn't really have the information on it.
Okay, yeah, that's fine. But I'm going for 12 hours today, guys. I got a lot of information here, and I can tie all of it together for you.
Okay.
So it's going to be 12-hour stream. And then if I don't get it all covered today, I'll be back tomorrow to finish it up or whatever. But yeah, we can get together.
Thank you.
Now, the Director of National Intelligence. So we have Homeland Security, Department of Defense, and National Intelligence. Applicable to the intelligence community. What is the intelligence community? Think about that, folks. We're gonna see that later. And sensitive compartmented information system to the extent not covered by paragraph da. Federal Acquisition Security Council means the council established pursuant to 41 U.S.C. 1322A. Intelligence community, as defined, 50 U.S.C. 3003 section subsection or subpart 4. Now this is the National Security Code. Okay. So it has to do with national security. And 50 U.S.C. 4305 is the trading, or 4300, 4301 starts the Trading with the Enemy Act, which is what we're working on. So this there says intelligence community as defined by 50 U.S.C. 3003 subpart 4 means the following: the Office of the Director of National Intelligence, the Central Intelligence Agency, the National Security Agency, the Defense Intelligence Agency, the National Geospatial Intelligence Agency, the National Reconnaissance Office, other offices within the Department of Defense for the collection of specialized national intelligence through reconnaissance programs, the intelligence elements of the Army, Navy, Air Force, Marine, Coast Guard, Federal Bureau of Investigation, Drug Enforcement Administration, and the Department of Energy as it relates to your labor and hypothecation of customer securities and agriculture, animal means or includes but is not limited to man. Conversion of man's labor through a hypothecation of a security that they sign, known as an employment application. The Bureau of Intelligence and Research of the Department of State, the Office of Intelligence and Analysis of the Department of Treasury, the Office of Intelligence and Analysis of the Department of Homeland Security. Such other elements. What are elements? Hey, Russ, you know that one, don't you? Would that be the data elements?
Certainly would seem to.
Wouldn't data be the information data? And
Absolutely, in the design.
So under 19 CFR 149.3, we have data elements, folks. And this is under customs duties. Customs and Border Protection, Department of Homeland Security, Department of the Treasury, Importer Security Filing. Data elements. When it comes to a seller, a buyer, or a ship to party, every last one of them, name and address of the last known entity by whom the goods are sold or agreed to be sold. If the goods are to be imported otherwise than in pursuance of a purchase, the name and address of the owner of the goods must be provided. In pursuance of a purchase. If the goods are to be imported otherwise than in pursuance of a purchase, the name and address of the owner must be provided. So if it's in the pursuance of a purchase, then it doesn't have to be provided. Understand the language. A widely recognized commercially accepted identification number for this party may be provided in lieu of the name and address. This is why I talk about the Postal Service. Buyer, a widely recognized commercially accepted identification number for this party may be provided in lieu of the name and address. And though you may not be the seller and you may not be the buyer, you may merely be the one at the other end of the line, the final destination where the party is to have the shipment received, the ship to party. A widely recognized commercially accepted identification number for this party may be provided in lieu of the name and address. So why has everybody been induced to believe that they have to give a name and address? That clearly says if the goods are to be imported otherwise than in pursuance of a purchase. So if you're purchasing it, you can give a number in lieu of the name and address. But instead, everybody's giving an ID, and they've been induced to believe that they have to give an ID. You go to that counter and you check out, and you swipe that card, or want to write a check or something, or you want to buy alcohol or tobacco item, and that clerk wants to see that damn ID. Sorry, this isn't in the. This was imported otherwise than in pursuance of a purchase. I'm not purchasing this, ma'am. Then what are you doing, sir?
You know, I got it directly from the state attorney general's office that of the records, the many records they don't have to provide to you when you do a records request. It's anything with a birth date on it, anything with a picture, any other sort, any form of ID. They don't have to give you that of their employees. And I'm out here thinking, well, why the hell do I have to do it to get, to buy stuff at stores? I mean,
Exactly.
It got so bad. They wanted that to buy a lighter fluid at one store. It was like, are you kidding me?
Exactly. It's just profound how backwards it all is. So anyway, I'm going to drop the StreamYard link once again for anybody that might want to stop up. We got Paul Newcomb down there, Captain Action. Greetings, Laura, Bear Jew, a lowrider, Tarab Spence says until we form our common law courts and common law grand juries, along with a good sheriff and militia, we are only talking. Yep, I agree. I agree. Numbers are needed. And so let's continue on with this, because now you see such other elements of any department or agency as may be designated by the president or designated jointly by the director of national intelligence and head of department or agency concerned as an element of the intelligence community. So we're dealing with the purchasing of items or otherwise imported otherwise than for purchase. And that's to do with the Department of State, Department of Homeland Security, and the Treasury. That's what all those data elements are for, broken down. That's what it is. And you're misidentified. You've been taught, pull up the screen here. We've all been taught in school. One of the first things we learn. What is it, guys? What's one of the first things they learn us in school? Way down in kindergarten.
With liberty and justice for all. The biggest fucking lie I've ever heard.
Close. I'm thinking more along the name and address. That's the first thing they tell you. Well, we want to make sure we get you home to mom and dad real safe. So what's your name? So we can
Yes.
match up their name. And where do they live?
Exactly.
And it just falls right in line. It seems so reasonable and logic. However, I will tell you that is a national address format for the United States. Remember, federal government means all entities of the government of the United States, including the United States Postal Service, who is in fact the registered agent for the Postal Regulatory and the Postal Regulatory Commission, which is the Universal Postal Union, the trademark holder of which that commission embodies. See, the Constitution of the United States isn't supported by anything other than the Constitution of the Universal Postal Union. It is a subcontract of the international contract. So, the address we've been induced into believing is our name and address. It's not our name, it's a legal name. That's a person. And we've been induced into believing that the address that we put down before us is merely an address, when in fact it's an expression of a trust. You have the legal entity at the top as the agent. Then you have the principals in contract, the street name, which was named by the municipality that has a ongoing contract of special maritime territorial jurisdiction through the United States and carried out by the most common carrier, the Postal Service. So you have a street name with a bonded number given out by the Postal Service. That's their contract. And you are the agent under that principle. You are the surety, they are the principal. And then they have the city, state, and zip. That's an expression of a trust. Very simple. So, the first name and last name is not your given name and family name. So when I put my address out, let me show you. We're going to do it red so you can see it real clear. And go ahead and fill up the silence here while I write this out.
And this is how we should be writing our name, correct?
In my opinion, yes.
Okay.
And the address is not, you keep saying address, but we don't, you didn't address the actual definition of the word address, which is, how would you address me? You wouldn't say it's on some street. It's not, you know what I mean?
Correct. And that's
You would
why
say,
we're going to show. That's why we're going to show you the correct address.
Well, and I'm wondering of the wisdom of actually just going to the border. And if I'm only planning to go into the other side for, only so far and back within a day, why can't I say to the guy in charge, hey, you, trustee, I'm going to need you to make sure I get my ass back where I need to be at the end of the day. So
Right.
what's that going to take?
Right. And you know what to do is you give them information like, tell you what, I know the law, and I know that if I don't return within a certain amount of time, you're going to issue a warrant for my arrest. I agree to those terms and conditions. I agree if I don't return and cross back into America within 30 days, you have permission to issue a warrant. Come look for me.
That's awesome.
Agree to it. Let them know you know the law.
Yeah.
Why would I need to go above and beyond that? I'm letting you know I know the law just like you do. And it says that if I don't return within 30 days, you're going to issue a warrant. Feel free because I'm going to be back in 29 days. That's my assurance. I don't need your insurance. Okay?
Right.
So when it comes to that address format, when it comes to that address format, this is what we're looking at. And I'll pull myself up front screen, guys. But notice, Brother Keith, care of Joyce. Notice they're on separate lines. Notice the full colon stops. 123 Bop Street, Waterloo, Iowa, 50701. Notice I don't need to worry about no fucking brackets or anything. It says United States of America. You notice there's 5 lines there. That is outside the format of the national address format, which is 3 lines. Agent name, principals contracted, expression of the trust.
Can you hold
Totally
that back?
different. Sure. And notice there's no last names on there, folks. So it cannot possibly be construed as a legal entity or a commercial entity conducting the affairs within. Cannot.
So Keith, brother Keith, care of Joyce. What is the Joyce? Is that your middle name?
No, that's my companion. I'm using somebody else's information, and she can do the same at the same address, showing that it's not the address, the street, but how you address each other.
Okay.
We
And
don't address each other with last names. I don't call her Joyce Schmidt. She doesn't call me Keith Little. She, in fact, calls me Honey, and I call her Choice. Not Joyce, Choice, Choyce. I gave her a name. For the rest of the world, they use the public source.
okay. And what if we don't have a companion?
Care of the address. Care of Postal Service at this address.
Okay.
Okay. And let's get back into it then. So the other elements, that's the problem, the public education system, the elements and how they present it to us. Okay? Birth registration, assignment of Social Security account number to an individual identified as a legal entity. National security system, as defined in 44 U.S.C. 3552, means any information system used or operated by an agency or by a contractor of an agency or other organization on behalf of an agency. That's you. That's you. All lowercase or other organization. Christopher,
Yes.
you're part of a family, right?
Yes.
You would like to think that family is kind of organized in a way, don't you? I mean, it's got a father, a mother, and children.
Yes.
You're an organization. You're part of the statistics, the vital statistics through the enumeration at birth. You are or other organization on behalf of an agency. This is the ambiguity in the English language that you have to learn how to read into. You have to be able to read what it's saying without knowing what it's saying, because it's using totally different terms. Or other state family. Or other state family.
Agency.
That's that marriage license as well, right? Right, guys? Ladies? Yeah. The function. What is a function? Performance of the functions of a public office. The very definition of trade or business in Title 26. So the functions of public office would be signing.
Communications.
Yep, communications, all the way from oral, verbal, sign language, cigars under the desk. You got it, baby. The functions of public office.
Hey, Keith, about that organization, I've heard it also suggested you could argue you're an organization of cells, like just
Yeah.
in yourself.
Yep. Yep. Absolutely. My cells are organized in a certain fashion, and they're not duplicated in any way anywhere else. You cannot find it an exact duplicate. So, where were we? Here we are. Operation or use of which involves intelligence activities or use. Remember, I said this is an imperfect usufruct. And what we have today is a document of title known as an entitlement, birth registration, in an imperfect usufruct with a bad chain of title.
Would use also be management?
Well, yeah, it'd be anything. Well, you're talking function, operation, and use. Management would be the
Would be
operation.
the management of that office.
Yeah, the management would be the operation. Use of it would be whether it be the operation be for motor vehicles, then it would be motor vehicle use. If it's for education, then it would be educational use, which involves intelligence. So whatever activity would go to the use, and then whoever's operating it, and of course the functions of that operation, where they have to sign documentations and pass laws and regulations and or if they actually have to get out there and operate the actual motor vehicle, and then they're at a lower level of that functioning office. Same thing. So anyway, it says operation or use of which involves intelligence activities, involves cryptologic activities related to national security, involves command and control of military forces. It's a military ID. Whether you want to believe it or not, it's a military government. Involves equipment that is an integral part of weapon or weapons system, or is critical to the direct fulfillment of military or intelligence missions. If the American people have a reading and comprehension of average of grade 8, I urge people to step up and start becoming more a larger part of the intelligence community by using your critical thinking for intellectual conversations such as this. I hope it turns out to be a greater conversation than most of the drama panels we see on these metaverses. But does not include a system that is to be used for routine administrative and business applications. So my laptop is not a part of the national security system. However, the data elements that I put into it are. It's going into a statistical element or statistical memory system somewhere. and therefore they become part of it. Okay? Is protected at all times by procedures established for information that have been specifically authorized under criteria established by an executive order or an act of Congress to be kept classified in interest of national defense or foreign policy. Or foreign policy. See, we're the ones that are on domestic oil or domestic soil. They are foreign. So there is a foreign policy. They are foreign bankers. It is a foreign government. Okay? We are the domestic people. Reasonable injury means an inquiry designed to uncover any information in the entity's possession about the identity of any covered articles or any products or services produced or provided by a source. This applies when the covered article or source is subject to an applicable FAFSA order. A reasonable inquiry includes the need to include an internal or third-party audit. A reasonable inquiry excludes the need to include an internal or third-party audit. Excludes the need to include an internal or third-party audit. Why? Because the internal would be second person, and of course the third-party audit would be a third party who has no interest in it. But I, as the first person, have firsthand knowledge that there's some certain errors. And I think that's about it. Oh, supply chain risk. Supply chain risk means the risk that any person may sabotage, maliciously introduce unwanted functionality, extract data, or otherwise manipulate the design, integrity, manufacturing, production, distribution, installation, operation, maintenance, disposition, or retirement of covered articles, so as to surveil, deny, disrupt, or otherwise manipulate the function, use, or operation of the covered articles or information stored or transmitted on the covered articles. So the birth registration is, in fact, one of those supply chain risks that cause irreparable harm and damage and needs to be transferred from the Department of State at the state level to the Department of State at the federal level with proper communications with Homeland Security redress program for certain misidentifications. Does that make sense, Christopher?
Yes, it does.
Okay. The birth registration or birth certificate does not need to be authenticated, folks. It is, in fact, already stamped as authentic. Okay. The next one I got. Go ahead.
So I've tried to get my certificate of live birth, but was told that they no longer have this document. What can I do to attain that document? I do have a certified copy of the birth certificate, just no certificate of live.
After you're older than 20 years, you're older than 20 years of age, right?
Yes, I'm 32.
Yeah, it no longer exists.
What does that mean for me?
Nothing. It means that you still have a birth certificate, which is still evidence of eligibility of American citizenship, saying that you've been classified as a United States citizen rather than an American citizen. And you just need to present that document to the right people with the right information. Say, hey, this is a misidentification. I demand American citizenship birthright.
Okay.
Yeah, we just got to learn to not make too much of this stuff anymore.
Okay.
Simplify.
Yeah, there's a lot of going around whenever I started learning about this, about the certificate of live birth, and having to make sure that you have this information or else you couldn't do certain processes. But I understand that a lot of gurus and teachers that were teaching this are not of the firsthand knowledge that was needed to understand what was really needed for certain.
Well, yeah, you've got people out here doing research, trying to do things, being autodidactic, which is what I consider myself, self-learning. And instead of being very particular about the information, they pick up on information from this guy, and they think they're learning, and they are. But what happens is they confuse this guy and what he's doing with this guy and what he's doing, and they try to merge things, and it don't work like that. You can't do that. There's a process for everything, and not every process is all supposed to be sewn together and used all at once. You can't throw things at a wall and hope something will stick. It's a bad way. Now, as we just went over that, that's what, like I said, it was the Federal Acquisition Security Council, and that's for everything they acquire under the Trading with the Enemy Act, Fifth Amendment, Takings Clause, anything. And this is something that's, again, plain writing that's going to show you what's going on here when we think about these statutes and codes and stuff. And it clearly and succinctly says 48 CFR 52.212-5. Again, this is acquisition regulations, Federal Acquisition Regulations System, clauses and forms, solicitation provisions and contract clauses, text of provisions and clauses. And it says, contract terms and conditions required to, love those prepositions, it means it's required to implement. So in order for them to implement statutes or executive orders that are connected to commercial products and commercial services, they are required to have contract terms and conditions attached. So when you go to that traffic court and they want to charge you fines, fees, and penalties, which is a commercial product or commercial service known as fiat money, then they are required to have contract terms and conditions. And so when you go to that court, it is a constructive contract under constructive trust. So when they ask you at the border how long you're going to be, you're actually involved at that time while you're speaking with them in a constructive contract. You construct the contract as you go. Okay? Does that make sense, guys?
Well, of course,
does to me.
public service is a public trust, so therefore, every time you talk to them, that's what it is.
Yep. Greetings, tribe. Welcome, brother. Hit that link. Come on up. So let's get into this this next part. And I'm not going to go too deep into this because, like I said, this is about the Trading with the Enemy Act. But in order for them to foment that, it's trading, you know. So they're trying to acquisition things. So we went over these acquisitions and of course the need for the identification in those trades. So contract terms and conditions, and it says links to amendments, and then it's got the various different contract terms and conditions that they're talking about. See, this is a federal statute, and all these things here are contract terms and conditions. Now, if I go over here to 17 CFR 240.8C-1, hypothecation of customer securities, these two are contract terms and conditions. It's telling us under this that contract terms and conditions are required to implement statutes or executive orders. Therefore, the statutes or executive orders themselves are the contract terms and conditions that they're wanting to implement in relation to those commercial services and products. And they're saying because you presented them with a legal entity, that identification, upon their offer, that you accepted their offer to perform under that contract. that is already in play. That driver's license, okay? Says the contractor shall comply with the following federal acquisition regulation FAR clauses, which are incorporated in this contract by reference to implement provisions of law or executive orders. So we have to implement statutes or executive orders. And now instead of using statutes, they're using provisions of law. So we now know that as relates to a jusdem generis, that statutes are equivalent to merely provisions of law. They're not law, they're provisions of law or executive orders applicable to acquisitions of commercial products and commercial services. This is your personal services that you're signing up for. And this is why I refused to sign the last time they arrested me and took me into jail. And then when they tried to release me and said I had to sign this release paperwork, sorry, I'm not signing. That's your job. If anything needs to be signed, that's your function. You're supposed to do the signing. By telling me I got to sign, you're implying that I'm of the same status as you, a bitch-ass slave. Sorry, ain't going to do it. So anyway, consequently, I did have that document in my pocket that said discharge as ordered by the court. And I just asked, are you willing, you're telling me you're going to violate the court's discharge order? And I was out of there quicker than I'd been out of there in 30 years, folks. Yes. Yes, there we go. Must have provenance. Law doesn't recognize American citizenship. It has no meaningful significance. I identify as a unicorn. Exactly. You must have provenance. What is the provenance? The provenance is what we're talking about, that birth certificate that's in the state's hands that is evidence of your eligibility of American citizenship, which needs to be transferred over to the right people, the Department of State at the federal level, for its diplomatic value, along with that high school diploma, proving that not only were you born on the soil, you were educated on the soil, and then accredited by the same sources that require that identification. You're already accredited. The credits are already there. You don't believe me? That's fine. That's why I tell you, don't believe me. Don't believe the neighbor. Don't believe the government. And for crying out loud, don't believe your mother. Do your research so you know. Come on up, Mitch. That link is down there. Let me pull it. Let me put it down there again in case you don't have it. But that's your provenance, is submitting that document to the Department of State as evidence of your yay is your yay, your nay is your nay. You didn't take upon the United States citizenship. It was actually a conference, and you actually are an American citizen, as the record reflects. You were born on this soil. 52.203-9, prohibition on requiring certain internal confidentiality agreements. So when it comes to the NDAs, you're not going to get one on me, because that would be an internal confidentiality agreement. And if there's anything going to be held confidential from now on, it's going to be you keep my name out your mouth. Okay. And it goes down and it talks about prohibition on contracting for hardware, software, prohibition on contracting for different things. Da-da-da-da. We get down here to number 7. It says applicable law for breach of contract claim. October 2004, Public Laws 108-77 and 108-78. It says 19 U.S. Code 3805. Remember, 19 U.S. Code and 19 CFR is customs duties. That's the internal stuff. It's already custom for them and their duties to do certain things, and they are lined out in 19 U.S.C. So let's take a look at 19 U.S.C. 3805, and it says implementation of trade agreements. This is your provenance. This is the thing that I'm talking about with the diploma and education and Department of State and how everything's been charged against you when you're already accredited and you are in fact just operating under unconscionable trade agreement. And now that you're conscious and you are able to discern the differences and transfer that document of title to the proper hands and explain to them and implement your own trade agreements, you have to learn how to contract yourself. You have to learn the contract language and let them know in etiquette the proper order of things. It isn't United States citizen and American citizenship. The United States citizenship is actual dual citizenship, which is duality that, again, you can't serve two masters. But that's also the thing about being distracted from the American citizenship. And again, even when it comes to that, I'm not going to sit there and say that I'm an American citizen either, because that's wrong as well. I'm a citizen of heaven, and I was born on American soil as that's defined according to that Mammon code. Otherwise, it's Leviticus 25 verses 25 or 23. The land shall not be sold forever, for it is mine, and ye are strangers and sojourners with me. So don't ever misconstrue it that I'm going to portray that I'm one of those nouns. Not going to do it. So 19 U.S. Code 3805, implementation of trade agreements. Notification and submission in general. Any agreement entered into under Section 3803 of this title shall enter into force with respect to the United States if and only if the president, at least 90 calendar days before the day on which the president enters into the trade agreement. So you see, we're going to be communicating through this trade agreement with the president, not just Congress, the president. You'll see that we're going to be dealing with House and Senate as well, but president notifies the House of Representatives and the Senate of the president's intention to enter into the agreement and promptly thereafter publishes notice of such intention in the Federal Register. Okay, you want national and historical value for your presence and your qualifications? I think it would be paramount that it be on the Federal Register. Otherwise, it goes into the National Archives as a nobody, just a statistical element. Remember, letting your communications be in your yay be yay and your nay be nay. So you can read 3805, and it's going to tell you all kinds of stuff, right? But when we go back, where is it? To this, and we see 19 U.S. Code 3805, note. You still with me, guys?
I'm here.
Awesome.
I'm here.
Okay. So we got 19 U.S. Code 3805, right? And it says note. Oops, I went to the wrong one. Okay, 3805, implementation of trade agreements. And it says U.S. Code and notes. So let's hit this note. It says note, editorial notes. The Bipartisan Trade Promotion Authority Act of 2002. The Bipartisan Trade Promotion Authority Act, 2002. See Section 3801A of this title. This chapter may be cited as Bipartisan Trade Promotion Authority Act of 2002. Findings. The Congress makes the following findings. The expansion of international trade is vital to the national security of the United States. So, if the expansion of international trade is vital to the national security of the United States, I would pose and agree with that it be pertinent to correct the, quote, United States citizen versus American citizen, as each American citizen would have his own international trade and would help foment and procure and enforce the national security of the United States through a proper intelligence. What's going on in chat, guys? Oh, come on. Why you do that, tribe? You know I don't like them ad hominems. Anyway, back to it. Trade is critical to the economic growth and strength of the United States and to its leadership in the world. Stable trading relationships promote security and prosperity. Trade agreements today serve the same purposes that security pacts played during the Cold War, binding nations together through a series of mutual rights and obligations. In order to hold the government to their duties and enforce it, you have to be able to enforce your own responsibilities. This is why I say taking upon that public education system is one of the biggest fallacies the American people ever took upon. We shouldn't be doing that. At least not in that sense. Again, public education system would be a fine enhancement to homeschooling. But when we take it upon as undertaking the whole thing as if though it's going to qualify for the education of our children, we have duped ourselves and fucked our children. Leadership by the United States in international trade fosters open markets, democracy, and peace throughout the world. I don't think so. I think any nation as a leader in international trade could foster those. And I think it's actually the United States and the Trading with the Enemy Act that goes beyond the scope of the field of war during times of peace on domestic soil that is fucking egregious. And that's why we need to stand up here locally. So let's take a look at the next one. Oops. '28 U.S. Code 2201, creation of remedy. And like I said, this Trading with the Enemies Act has caused irreparable harm, whereas it's destroyed the value system of many people and their families. And so the creation of remedy is needed. It says in a case of actual controversy within its jurisdiction, except with respect to federal taxes, other than actions brought under Section 7428 of the Internal Revenue Code of 1986, a proceeding under Section 505 or 1146 of Title 11, which is bankruptcy. So you got taxes or bankruptcy so far, or in any civil action involving an anti-dumping or countervailing duty proceeding regarding a class or kind of merchandise of a free trade area country, as determined by the administering authority, any court of the United States, upon the filing of an appropriate pleading, may declare the rights of the other legal relations of any interested party seeking such declaration, whether or not further relief is or could be sought. What do you see there, Dean? You see the declaration?
Say that again.
What do you see right there in my highlight? May declare the rights and other legal relations of any interested party seeking such declaration, whether or not further relief is or could be sought. Do you see the declaration?
Looks like a declaratory judgment.
Yep. A declaratory judgment is also relative to the injunction, which we were speaking about with power inherent in the people yesterday. The injunction is for irreparable harm and damage. Any such declaration shall have the force and effect of a final judgment or decree and shall be reviewable as such.
And that's to clear up the rights and duties of the parties, if you will.
Correct. The legal relations and rights of any interested party. That's what's not handled. That's why I object to the personal jurisdiction, because you're not going to presume that I'm just going to show up in court and all of a sudden you have personal jurisdiction because I showed up. I'm going to speak my piece and I'm going to do so right from here. I'm going to do it on a piece of paper and send it to you through the mail. You don't like it? Come get me if you think you got that power. See, that would be kidnapping. And they ain't going to do that. Greetings, Mitch. How you doing today, brother?
Hey, man. Thanks for having me. I'm doing good. Thank you.
Good, good. Don't know what the hell's up with Tribe, but you can see he starts with ad hominems. I love you, brother, but you got to stay off the ad hominems. So anyway.
Yeah. Goes both ways. Yeah. I mean, he obviously has a clear agenda anytime I bring up the state citizenship. He tries to distract, to manipulate the perceptions of others because he knows what it's about. He knows that there is a resolution there that folks are seemingly unaware of. And I think it's important to understand that concept of what would reestablish the de jure American Republic. So
Yeah, exactly. And that's what we were talking about earlier with the common law and all that. We have a lot of people that need to come together and really start thinking comprehensively of what the process is in fact. Because a lot of these people that are in these offices and stuff are incompetent and they're just doing their job, and their boss before them and their boss before them and their boss. These people don't know it. They've just been told by their boss, and as the law changes, they take the simple language as if though it's colloquial and don't even bother looking up the actual legal definitions of what's going on. And that's a big problem. Again, that goes with the population. Sorry, John, didn't see you there.
hey, how you doing?
Good, good. The population itself really needs to upgrade its intellect and teaching and learning. That's a big problem. People are becoming very hedonistic and enjoyable, and they think that their kids are going to be okay growing up in this society if they have that basic education. And that's the biggest mistake we can make. So how's it going in your area, John? Good weather over there yet?
Well, it's 40, so I guess I'm drunk because it's been 10.
Yeah, we're hitting 25 here. It's been in the teens, negative teens.
But I am on a special and limited appearance today on your show. I just thought I'd tell you that.
Absolutely, not subjecting yourself to the general jurisdiction. Absolutely.
There you go. All right.
So we see that the creation of remedy is for the countervailing duties. We have a countervailing duty ourselves to do better than what we've been doing. And it takes an intelligence community, and we really have to step it up here, folks. Now, one of the things that they mentioned back here in this federal acquisitions regulations, we get down here, where is it? And they mention, and I was surprised to see this. Where you at? Where you at? Where you at? They've got Title 42. There it is. Title 42 of the U.S. Code as to estimate of percentage of recovered material content for EPA designated Environmental Protection Agency. You know, I told you it's about the agriculture and protecting the natural world as it relates to the conversions of certain things to commodities so that they can provide those protections. And we see here they talk about items under 42 U.S. Code 6962, and then they're also going to talk about them in 8259B. Let me find that one. They've got one down here, ozone depleting, 42 U.S. Code 7671. And right here, sustainable products and services. That's your personnel services, your personal services. Your sustainable product is yourself. The sustainable service is the function that you perform in any operation that they need you to for any agency, such as signing paperwork. You know, release paperwork, where you release your personal services to do their fucking paperwork. Not going to do it. Not anymore. Nope, nope, nope. And then they have privacy training. Oh, look. That's 5 U.S.C. 552A. Let me ask you, Dean. Did they ever give you any privacy training?
Absolutely not. Well, they might have said they did when they put me in isolation, but other than that.
Yeah. So it's all relative to that public record. And we're going to drop in here and show you guys, because you guys may not see this, but we're quite familiar with this one. 5 U.S.C. 552A is records maintained on individuals. Guess who the individual is? That's you. That's you. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. Listen, if you think I'm going to be a permanent resident, you're the one that's insane. I'm going to die someday, and you know it just like I do. I cannot possibly be a permanent resident. I live in this world, but I am not of this world. Go ahead, Dean.
And where's that approval by the board anyway?
Exactly. For resident. Federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board. The board being the Secretary of Commerce, being the executive chair and member, and the Secretary of Treasury. Funny, I ain't never met none of them. The term maintain includes maintain, collect, use, or disseminate. So when you use that legal name, that's their creation in an imperfect usufruct with an imperfect title with an unbound chain. Okay. So let's continue on with the next, let's do the 42 U.S. codes to show you what they are consisting of. And 42 U.S. Code 6962 is the federal procurement. Now, federal procurement goes to the federal acquisitions, because that's what they're doing. An acquisition is an acquisition through procurement. Application of section. Except as provided in subsection B, a procuring agency, as it relates to data elements, the Social Security Administration, vital statistics, shall comply with the requirements set forth in this section and any regulations issued under this section with respect to any purchase or acquisition of a procurement item. Purchase or acquisition. See, that's where they're supposed to give a name and address unless it's in the pursuance otherwise. See, they're given a number in these purchases, and we've been induced to give the name and address. See, when I go to that court and they have that name down there and it says L-I-T-T, all uppercase, but it doesn't have the L-E on there and it says firm name, they're using that along with a numerical identifier known as the Social Security number without dashes that they call the obligor. And it's the obligor that is liable for all payments. And if the obligor is liable for all payments and identified by a number, it ain't me.
Yep. Legal title, liable party.
Yep.
Yeah, the whole system is designed to make you lie about that and subordinate your perjury by telling you, what is your number? And that's how they say it all the damn time.
Yep.
I'm tired of, I'm getting tired of correcting those people. Not my number. How can I own a number? And if it was mine, why am I begging you for what's in it?
Now this one here says procurement subject to other law. Any procurement by any procuring agency which is subject to regulations of the administrator. Who's the administrator? Means the administrator of the Environmental Protection Agency. This is under 42. Social Security Administrator means Environmental Protection Agency. Okay? Which is subject to the regulations of the administrator under section 6964 of this title, shall not be subject to the requirements of this section to the extent that such requirements are inconsistent with such regulation. So when we have a otherwise than the purchase, then that's what we're talking about here. Procurement subject to other laws. So let's look at it. Applicability of solid waste disposal guidelines to executive agencies. What are we talking about solid waste disposal guidelines for? Because every last one of us needs to take a shit. They don't want any of us taking a shit just anywhere. So the convenience provided by a society through a plumbing system that they use to get rid of your defecation, understand they have to condemn the land of its natural use in order to do that. Oops. Anyway, why it's talking about that, I don't know. I haven't made the connection. But it seems to be garbage collection. So let's take a look at the next one under 42 U.S. Code. It says federal procurement of energy efficient products. How efficient are you at that job? Are you the energy that you put out down at McDonald's as you're flipping burgers and stuff? Are you better than the next guy? Is your energy being more efficiently used because he only has to pay you $7.50 an hour to flip 20 burgers, where this guy only flips 10 burgers and he's getting paid $7? He's going to get rid of this guy, and he's going to use your energy efficiency as a hypothecation of a customer security. Guarantee you. They're going to take advantage of everything you don't know about. Like I said, it's a personal service. You've been contracted for personal services. At least that's the presumption. And when it comes to that customer security, it's a hypothecation of customer security. This is security, commodity and securities exchanges. And in the Commodities Act, you will find a term reasonably believed to be an eligible contract participant. And that is the presumption. A simple presumption that you're reasonably believed to be an eligible contract participant, but you're not. You don't know what the contract terms and conditions are, let alone do you even care to fucking read them. Caveat, buyer beware. Oh, well, I'm going to buy it anyway, and if there's a problem with it, I'll look at those beware things later, see if I fucked up then. Without worrying about that, you fucked up just by buying it without paying attention to the buyer beware. Do it every day, all day long. In general provisions, no member of a national securities exchange and no broker or dealer who transacts a business in securities through the medium of any such member, directly or indirectly. Through the medium. What is your medium? What if I'm the member? What's the medium? The person, the presentation of the identification. Through the medium, not through me, through the medium, not me, through the ID. And listen, if you don't have said ID, guess what? They can't abuse you in those securities mechanisms. Hypothecate or arrange for or permit the continued hypothecation of any securities carried for the account of any customer under circumstances that will permit the commingling of securities. See, that's the problem. You have a commodity money and a fiat money. The fiat money is the securities, and they're getting commingled. Carried for the account of any such customer, with securities carried for the account of any other customer, without first obtaining the written consent of each customer to such hypothecation. What is hypothecation? Hypothecate means to pledge something as security for a loan. Without the actual delivery of the item pledged. So the court takes out a loan in the name of Keith Orland Little and has secured that loan by pledging my name without actually delivery of the pledged item, the record. They pledged the name on record as a security for a loan for them. Pledged it in their name because they took all those cases along that same day. You go to court, all those cases in the same day, they all get pooled together in one investment. That investment gets renamed because they can't put it in the name of all the people that are in that investment itself. Say you got a traffic case, you go into court, and there's 100 people in that traffic court that day. They bind all those people together in one pledge and pledge it in the name of the court. In the name of the court, it goes to the federal court registry investment system to sit there until each case is adjudicated. It's an investment scheme, and they're using your name to invest for that loan for them. Without the actual delivery of the item pledged, for example, a car may be collateral for a car loan, although possession remains with the borrower. Hypothecation creates a right by the creditor to liquidate the property to satisfy the debt. Now, why are they calling somebody else the creditor? A creditor is someone or an entity to whom an obligation is owed. So if they're the ones taking all these securities and pledging them in their name, then the obligation is owed to them, according to the record. And they're saying you owe them the obligation, when in fact the obligation is owed to you by them. See the subrogation? See the flip? See why Jesus flipped the tables? Most commonly, the obligation owed is an obligation to pay money for some prior services or to pay off a loan. The person who owes a creditor an obligation is known as the debtor. Nowhere else in law will you find them naming anybody else as a debtor other than H under UCC 9-307, location of United States? The United States is located in the District of Columbia, and this is UCC 9-307, location of the debtor. Now, this correlates with 18 U.S.C. 8, obligations and other securities of the United States, naming them as the debtor. Now, if you find a document that's got a name that looks like yours, saying that is a debtor, oh well, not me. It's not me. That's a United States citizen, and it belongs to the United States, and it is, in fact, an obligation or other security of the United States. Not me.
Yeah, I'm not in receivership. You are.
Exactly. So, that's the commingling. It's not a matter that they're commingling funds internally. They're allowed to do so. The commingling is they've brought you into a system that you don't belong in. You ain't qualified and never will be until you learn above and beyond what they've taught you. And when you do, you don't want to be qualified, even though you may be better qualified than most. We got Christopher trying to get back up, says device not connected. And Trading Brigade, welcome, says device is not connected. Please try again. I'm going to take a short break. I've got to go grab me something to drink real quick, and I'll be right back and let the dog out. Yes, court registry investment system is crooked, John. And so please, what do you mean it doesn't effectively rebut their long-standing presumptions? Tell you what, tribe, come on up. Let's talk about the long-standing presumptions that I'm rebutting right here and now. I'm showing you information, and it's amazing how people will sit there and say that, you know, it doesn't effectively rebut their long-standing presumptions. It does rebut their long-standing presumptions, and now that the ball is in their court, what it does is show that they're not competent. The facts themselves do, in fact, rebut their long-standing presumptions. So, welcome back, Chris.
Hey, I don't know what happened. It just kind of kicked me out, so I'm back. Thanks.
You bet, anytime. So let's see here. I think that's all I wanted to do on that. And like I said, you guys can go back and look this stuff up and do your further research. Do not believe me. Do not believe the neighbor. Do not believe the government. And for crying out loud, do not believe your mother. Do your research. And with that, I'm going to bring it to 50 U.S. Code 1801 as it relates to national security, national defense. And I'm going to go let the dog out and grab me a drink. I'll be right back, folks.
We could spend all day in court just arguing over what the definitions are. Wouldn't want to do it though.
So what we're doing here, are we surrendering these things? Is that the proper terminology to use? Just throwing that out there.
Yeah, I surrendered my driver's license, but I don't know if Keith has other ideas. I don't know.
I have, oh, Keith's back.
All
I
right.
have a perspective. I don't know if it's a popular one, but I think that until we have reestablished the de jure American Republic, there is no enforcement for what's written and memorialized in law. So, as right as Keith is, I feel like the appropriate solution, what I've done is I've gotten the driver's license as the beneficiary. I just don't identify as that. It's their driver's license. It's not mine.
Right, and
And
that's why we're talking about the credentials, and that's I'm going to be live for probably 12 hours today, going through all this information and trying to help people understand that high school diploma that you got, you already have a diplomatic accreditation because of that. And that's your private credentials. But everybody's been duped into believing that they need a state ID or driver's license with that name and address. And that's the wrong way to go about it. I am positive that we're supposed to be dealing with the Department of State at the international level. And that's just what my research has shown me through my discernment. So not saying that it is or isn't, but it is the way I'm working it. So
and I think that's, oh, sorry.
No,
I was just going to agree with you. Ultimately, I think that's definitely correct. It's just, how do we get them to acknowledge what's correct? That's the hard part.
Yep. And so one of the important things I want people to comprehend in all of this is definitions. And trading brigade, if you're still there, it says your device is not connected. So I'm going to go ahead and kick you for now and see if you can come back and try again. Would certainly appreciate your presence. I always appreciate what you have to put in. So the important thing here is definitions. And so I've got a bunch of sections pulled up in the National Defense Code, Title 50. And this is 50 U.S.C. 1801. And when we see definitions here, it says foreign power. Foreign power. That's that provenance you were talking about earlier, Mitch. That provenance. That provenance is something that is substantiated, something that is true, real, patent, cannot possibly be denied. And that provenance we're talking about here in that foreign power is the power of God, the providence and grace that he shines on us to even be able to speak. The power of language comes from him. So the foreign power means a foreign government or any component thereof, whether or not recognized by the United States, the tribe. Get up here. Lost Christopher again. They operate under presumption, not law. It won't work like that. It will if you enforce it. And I'm telling you, ain't too many people run across this stuff and have the balls like I do that will stand on it. Say, no, you're going to have to come kidnap me. This is the way it says in your word. So whether you recognize it or not, I don't give a fuck. And that's what I'm talking about, folks. They tell you right here, they don't care. A foreign power means a foreign government or any component thereof, whether or not recognized by the United States. You damn well do recognize motherfucking God. That's where I get my power. And when it comes to foreign government, government, govern. What is a govern? It's something that controls the speed. It's a control mechanism. It's mental control. Your own mental control. A foreign government. You guys understand that independently? Each one of you is a foreign government? Give me yes or no.
Yeah, I think
Yes.
foreign to them. Oh, sorry, you wanted a yes or no? Yes.
Yeah, well, we're foreign to each other, even. We're foreign. We are a foreign government to all else because we control our own mind. Whether we do that by acquiescing to somebody else's definitions and fear, but we still control our own mind. Too many people living today on compulsive decisions rather than making logical, thought out, good choices.
I just wanted to make a point of clarity, not to be confused with their foreign occupation.
Correct. Yeah, we're domestic to the soil, foreign to each other, and foreign to any occupation.
Correct. Yeah.
And that's the only one I wanted to look at in here, I think. Agent of a foreign power, any person, international terrorism, sabotage. I don't think electronic surveillance. United States person means a United States citizen or an alien lawfully admitted for permanent residence. Again, I'm not. How can I apply for permanent residence if I'm going to die someday and no longer reside? United States, when used in a geographic sense, means all areas under the territorial sovereignty of the United States and the trust territory of the Pacific Islands. Here you go, Mitch. Aggrieved person. The aggrieved person means a person who is the target of an electronic surveillance or any other person whose communications or activities were subject to electronic surveillance. Look at your ID, guys. I don't know if yours is going to have it on there, Mitch. You've got a state national ID. But look on your ID. Does it have an electronic strip cord on it?
Oh, interesting. Yeah, it has they have a magnetic barcode on the back.
That's
Like-
target of an electronic surveillance, Mitch. I'm telling you, the state national isn't any good either. I know you don't like hearing that, but
No, I don't have a state national ID.
okay.
But what
I thought you had. My apologies.
I personally, I'd be happy to entertain any ideas as to why they're no good, because I do recognize their position. However, I'm not going to be a state citizen or a state national. I think, like
Right.
you have established, my citizenship is with God.
Absolutely. And
My loyalty or obligation is to God, not to any nation.
Exactly. And if I can't let my yay be my yay and my nay be my nay without somebody else's input, then what good is my yay and my yay? Well, you can't say you're that because this guy over here says he's that. I don't give a fuck what he says. My yay is my yay and his yay is his yay. If we both say the same thing, then hey, we got two yays in agreement.
I just want to say or state that I think it's important for folks to realize, from my perspective, I could be wrong on this, but what I believe I've learned is that the state citizenship is necessary to have enforcement over the U.S. government, because they're the ones who created them, and so he who creates controls. So without the reestablishment of that de jure Republican form of government, there will be no control, or there will be no way to enforce the U.S. government, laws upon them. They have a monopoly on force. So
Yeah, and that's the record, and that's what D.O.L.O.V.F.M. The substance is in equity. The fiction is legal, the Holy Ghost. There is no ownership in equity. There is use and fiduciary duty. The name refers to an estate the beneficiary has use of. Correct. And as use of the United States estate, which is the false birthright and is a targeted individual used in a trading with the enemy program of economic warfare against that individual, when in fact he is an American citizen, and it is a misidentification. The imperfect usufruct of a legal title. So let's see here. I think that's it for that. The next one, we've got a bunch of sets of definitions in here. And this one says, in general, this is 1881. In general, in this subchapter, the terms agent of foreign power, attorney general, contents, electric surveillance, foreign intelligence information, foreign power, person, United States, and United States person have the meanings given to such terms in section 1801 of this title, which we just read. Additional definitions in this subchapter. Congressional intelligence committees. Remember, I told you earlier, we're supposed to be talking to Congress and the president in relation to American citizenship through the Department of State and Homeland Security redress. The First Amendment, right to petition the government for redress of grievance against for the aggrieved person that has suffered irreparable harm and damage due to false birthright citizenship.
can you show me where the American citizen exists? That term is throwing me off, and I just think that, because I think you're onto something, but I think it's a conflation of terms, maybe not intentionally, but I just think it's important to get clarity on this, because that's where I think you're ultimately right. You're onto something. I don't know what we would call it. I mean, for me personally, I would probably claim, like my tribe to be my family or whatever outside of God. If I had to claim something to show provenance here in this realm, but the point I think I'm trying to make is I don't think the American citizen thing exists. So I think you're ultimately correct on the solution to all of this, but how do we get there? I think that would be the state citizens.
Well, and this is why. Can you read that? Is that big enough for you? Okay. And this is from Protocol for the Modern Diplomat. The ambassador of the United States of America requests the pleasure of your company. And that's what we're talking about, is diplomats, right? And it says, when referring to a U.S. post, remember I always talk about the post office because that's what it's about. When referring to a U.S. post, the Embassy of the United States of America is preferred over the American Embassy, as references to America can be ambiguous, especially in the Western Hemisphere. Avoid using terms such as American ambassador or American citizen. Similarly, to be clear and to avoid offending others by suggesting that the U.S. constitutes the entire continent, use United States in references to this country. It's because they tell those people that they don't want you using American citizen and American bastard. They want you using United States.
Yeah, but how I interpret that is so that U.S. citizens don't identify as Americans, essentially.
Right.
Not so much to prevent Americans from identifying appropriately, like, because I think it is an ambiguous term, and that's what the point I'm actually trying to make is there's no way to really define that. I mean, because to me it's actually an oxymoron. Because if you were just a non-citizen American, I would find that to be an acceptable terminology for what we're describing.
Yeah.
But to call yourself an American citizen means that you have an obligation to America. So that term is very ambiguous and is like it states, it's the whole continent of North America, essentially.
Yep. And here's and the term, even though you got a good point about the term American citizen, and this is an article just brought up 6 days ago. Protecting the meaning and value of American citizenship. Executive Order, January 20th, 2025. This is the Trump thing that he was talking about, the 14th Amendment and the birthright. And this is what the only thing we're trying to distinguish here is the difference between the fact that not only were we born on the soil, but we were born without any obligations and duties to the government as an American. That's it.
But that inherently is what the meaning of citizenship is like that. That's how I would define citizenship, is your obligation to that, whatever you're.
Correct. And that's why I say, and I appreciate your agreement with it earlier about the I'm not an American citizen. That would be the best classification to try to classify as close as may be to a prophet unto the nations according to the scripture. Because I'm not supposed to take upon the nationality. I'm supposed to be a prophet unto, according to my interpretation.
Yeah, and that's why be aware of Anne rights too. She wants you to be a state national. That keeps you a corporate citizen.
State national does not. There's a clear distinction between state citizen and a state national. There's a clear distinction between a state citizen and a state national. So that
correct.
That's really what I mean. You can find this in the books. It's not my opinion. So
right. And this is, and we have to understand too, Mitch, the thing about the citizen and national, there's not a difference there either.
Well, I think there is. I think the citizen has an obligation. The state citizen has an obligation to the de jure republic, because before the 14th Amendment, U.S. citizen, there was people were citizens of their state.
Right.
So,
which today, again, understand the term state. Iowa is its own country. It's its own.
Well, nation. It was until it ceded its sovereignty to the Fed, to Washington D.C. essentially, and when it became the state of.
Right, but the only reason the states did that, understand this, people. The only reason the states did that is because there are places within the country that are not navigable to by water. So you have to go across a foreign nation to get to it. So they brought their sovereignty together in one by giving up them individually so they would all protect it together. So the sovereignty is still there. It's just that the corporate overlay is what's structured to help foment the admiralty maritime across it for that sovereignty. Because otherwise you have landlocked states that wouldn't be applicable for the protections of admiralty maritime international protections. See what I'm saying?
I do see what you're saying, but I also think it has more than one purpose, apparently. I mean, I do see legitimacy to what you're describing. However, I think it also is what is creating this confusion where the solution is right there in front of our face from my perspective, and it's very simple, but we can't we can't come to a mutual understanding on it. But I really think that the 14th Amendment state citizenship, I mean, basically the elimination of state citizens to convert them to U.S. citizens is an important factor in all of this, because what that did is that eliminated their boss. And they no longer have a boss, right? So, because he who creates controls. So there is no enforcement for them, because they've all fallen asleep essentially. And that's where I think that it's important to reestablish the American Republic through state citizenship, through the having the legitimate states called into session and getting their sovereignty back. That's, I think, an important part of this process, to be able to have enforcement, to enforce what you are discovering is legitimate written law, but it's not enforceable. It's
Well, yeah, and that's why contract is law, and that's what gets enforced. And so what we're doing here is showing that there's a way to create a remedy, and the remedy is through the misidentification that subjected you to false trade agreements. You have the remedy of writing up your own trade agreement, and that's an international venue where you get to express it and let it trickle down just like any other nation would. That's that foreign power. It's a foreign government. Yeah, I myself am a foreign government.
Yeah, I just see that there's a lot of propaganda that's being placed against the solutions that, say, Anna von Reitz she's the most popular for bringing this awareness, but it's not like she created this process. This process has been memorialized in law far before she was born. So it's not like she's reinventing the wheel. This isn't her process. This is her doing really deep research and being able to present it. And so, she catches a lot of flack, but there's no way to substantiate that her process makes you some sort of corporate slave, because what she's encouraging people to do, and I will articulate what I think is wrong about her, what she has done, is that she wasn't clear about providing full disclosure and positioning herself as a trustee. For when people correct their status, not that it was really a bad thing, but there are some people that are real deep into this and want to be their own trustee or whatever, and not use a trustee. Some people need the use of a trustee, with when they're going to be dealing with the government. So
Yeah,
because the trustee is responsible for anything that goes wrong. So if you don't know exactly what you're doing, it's a trap,
Yeah, and that's the importance of learning this stuff yourself. You cannot, we have to stop relying on somebody else being able to do all this footwork and paperwork for us. There has to come a time where we have to be able to do the paperwork and everything ourselves, and get into the process good enough where we can simplify it so it becomes a normal thing. Just like the public education system, it becomes normal when you graduate high school. Okay, now let's think. Mom and dad taught me this. I learned this in here, and mom and dad's livelihood comes from this. And dad, what really wants me to be a barber like him, or a carpenter like him, or whatever. But I kind of like this program here of internship with the United States and Foreign Service or something. You have the ability to make those choices if you're much better educated. But what we have today is a system where people are brought up without that, and they think they can get these public offices, and they do. Granted, that's the way the system works, and they get in these public offices and agencies and departments without really knowing what it's all about, because they're really only concerned about having a job so they can take home a paycheck. And that's the fallacy of our lost spirituality. We have to become more spiritual in everything we do, and we've lost that through this through the hypocrisy of this record keeping system of persons. He is no respecter of persons, And yet so many people claim to be be spiritual people, but don't give a flying fuck. It's very bothersome. And yes, wouldn't it be specific to statute? This is why I tell people they have to learn those statutes and understand the language that's being used. The language that's being used are contract terms and conditions. They're actually a way to learn how to contract yourself. So let's get back into this. Like I said, we're going to be talking. We need to learn how to talk to the president and Congress. So it's a matter of ethics and etiquette. Foreign Intelligence Surveillance Court. Electronic Communications Service Provider is a telecommunications carrier, as that term is defined in Section 153 of Title 47. A provider of electronic communication service, as that term is defined in Section 2510 of Title 18. A provider of a remote computing service, as that term is defined in Section 2711 of Title 18. Any other communication service provider who has access to wire or electronic communications, either as such communications are transmitted or as such communications are stored. Any other service provider who has access to equipment that is being or may be used to transmit or store wire or electronic communications, but not including an entity that serves primarily as a public accommodation facility, a dwelling, a community facility, a food service establishment. So your libraries, your restaurants, your libraries, your homes, or theaters, or anything like that, providing services, doctor's office, dentist's office, things like that. An officer, employee, custodian, or agent of an entity described in subparagraphs A, B, C, D, or E. Guess what? You are considered presumed to be an agent of the entity with that ID or driver's license. That's what that presents. And that is in with an officer, employee, or custodian as it relates to a jus generis, and that entity being a legal entity. Intelligence community has that has the meaning given in the term in Section 3003, Section 4 of this title, which we already read. That was that one we started out with. So let's go back into the next one. Here it is. This is the one I was looking for. This is the one that's going to mention it. I thought we had already read it. The term intelligence includes foreign intelligence and counterintelligence. What happened to domestic intelligence? The term foreign intelligence means information relating to capabilities, capacity, intentions, or activities of foreign governments or elements thereof. Foreign organizations or foreign persons or foreign intelligence or international terrorist activities. So like I said, you are a foreign government, and as relations to foreign government, the term foreign intelligence means information relating to the capabilities, intentions, and activities of that foreign government. Okay? The term counterintelligence means information gathered and activities conducted to protect against espionage, other intelligence activities, sabotage, or assassinations conducted by or on behalf of foreign governments or elements thereof, foreign organizations, or foreign persons or international terrorist activities. And here we have that definition of the term intelligence community includes again, which we already read, such elements. That's where we talked about the data elements. The terms national intelligence and intelligence related to national security refer to all intelligence regardless of the source from which it was derived, and including information gathered within or without the United States. This is why it's so imperative that you understand what you're saying, who you're saying it to, and being very careful about when you do so. You have to understand the language we're using. Is so colorful that it can be interpreted and mistaken in many different ways. Many different ways. That's why it's so important to go over these definitions. The term National Intelligence Program refers to all programs, projects, and activities of the intelligence community, as well as any other programs of the intelligence community designated jointly by the Director of National Intelligence and the head of the United States Department of or agency by the President. Such term does not include programs, projects, or activities of the military departments to acquire intelligence solely for planning and conduct of tactical military operations by United States Armed Forces. You see your public education system in there? National Intelligence Program refers to all programs, projects, and activities of the intelligence community. Is not the public education a part of the intelligence community? If they are the ones providing the intellectual thought process training. If that's what they're providing, which they don't. They're actually posing that they provide education and then indoctrinate you into believing and remembering certain things without using a valid thought process. Just so you know my thoughts on it. And I don't know what's wrong with your connection there, Christopher. I'm going to keep kicking you until you can make her back in. It says you're not connecting. Yes, Poppy Gold says, like Israel X always says, if you can't comprehend and apply the words they use, then you're not going to find freedom. Absolutely. Absolutely. Okay. So that's that section. And then the next section, and you'll find out a lot of these definition sections, folks, are actually rather short. So if you just did spend a little bit of time, you would find out what's going on just by reading the definitions alone. Would open your eyes to so much. When used in this chapter, the term agency means the Central Intelligence Agency. Director means director of the Central Intelligence Agency. And government agency means any executive department, commission, council, independent establishment, corporation wholly or partly owned by the United States, which is an instrumentality of the United States. You guys remember I showed you in 15 U.S.C. 4724, wherein they have a definition in there that says United States business means, and it has United States citizen. So United States citizen is an instrumentality of the United States as a business entity, wholly or partly owned by the United States. So the birth registration, social security card, and identification, all that, is a government agency for data elements of foreign governments and for the collection and dissemination thereof as it relates to the program of economic warfare, the Trading with the Enemy Act. The next one, as it relates to directly the Trading with the Enemy Act. 50 U.S. Code 4302 is a set of definitions. And when we hit previous, it says 4301, designation of chapter. What is the designation of this chapter? This chapter shall be known as the Trading with the Enemy Act. Okay, let me take a break real quick. Okay. So 2.5 hours, and we're finally done with the prerequisites, and we're going to get into this Trading with the Enemy Act. Now, the Trading with the Enemy Act, like I said, is a program of economic warfare, and I did a series of videos on it here about 6 months ago, if you go back and look, called Trading with the Enemy Act, A Century of Trading with the Enemy Act, and it was based on a review of an article from Cambridge University Press. And so when you go back and you look at that, and you understand that the way the Cambridge University Press presents it, the United States, the corporate entity, is the New World Order and the New World Government. Prior to World War II, or excuse me, World War I, they enacted the Trading with the Enemy Act, and this was about the time that they assassinated Duke Ferdinand. Like I was explaining earlier, the German and Austria states, which used to be a collective of states, of about 10 or 12 states, German states, which was in fact the new Holy Roman Empire. People think the Roman Empire fell. It did not. It's still in existence today, and it's just in modern times called Germany. It says the word enemy, as used herein, shall be deemed to mean, for the purposes of such trading and of this chapter, any individual, partnership, or other body of individuals of any nationality resident within the territory of any nation with which the United States is at war, or resident outside the United States and doing business within such territory, and any corporation incorporated within such territory of any nation with which the United States is at war, or incorporated with any country other than the United States and doing business within such territory. So you literally, by this word, have to be in a direct contract with an enemy of the United States, either on American soil or within the jurisdiction of that enemy. Now, if you're not on American soil and you're not within the jurisdiction of that enemy, the jurisdiction that you are in would be considered an enemy if they are an ally of that enemy, and it would be an ally if you were considered an ally with the United States. So no matter where you're at, this here is going to be determined by the trade and the entity that you're trading with. That alone should preclude any concept that it could be used on American soil. Without an ID. That's why they ask you for the ID on American soil. Because they don't know if you're an enemy or not. Well, I'm telling you that the presentation of an ID at the state level or a driver's license that isn't qualified is more harmful, injurious, and damaging, and does provide irreparable harm. Than private credentials if they were brought forth in a proper, constructive manner to be recognized by the United States. Whether or not they're recognized now is one thing, but they can be recognized by the United States, and that's a matter of presentment. Like I said before, Homeland Security redress and Department of State. And that's basically what we're talking about here. Again, you know, they're talking about being at war with the United States or not. That's a Department of State, Bureau of Consular Affairs issue. Okay. The government of any nation with which the United States is at war, or any political or municipal subdivision thereof, or any officer, official, agent, or agency thereof. Such other individuals, or body or class of individuals, as may be natives, citizens, or subjects of any nation with which the United States is at war, other than citizens of the United States. Wherever resident or wherever doing business as the president, if he shall find the safety of the United States or the successful prosecution of the war shall so require, may, by proclamation, include within the term enemy the words ally of enemy, as used herein, shall be deemed to mean any individual, partnership, or other body of individuals of any nationality resident within the territory, including that occupied by the military and naval forces, of any nation which is an ally of a nation with which the United States is at war, or resident outside the United States and doing business within such territory. And any corporation or incorporated, and any corporation incorporated within such territory of such ally nation, or incorporated within any country other than the United States and doing business within such country. The government of any nation, which is an ally of a nation, with which the United States is at war, or any political or municipal subdivision of such ally nation, or any officer, official, agent, or agency thereof. Such other individuals, or body or class of individuals, as may be natives, citizens, or subjects of any nation which an ally of a nation with which the United States is at war, other than citizens of the United States, wherever resident or wherever doing business as the president, if he shall find the safety of the United States or the successful prosecution of a war shall so require, may by proclamation include within the term ally of the enemy the word person.
Well, that's why I want to be an ally with the post office, because I'm not at war with America.
Yep. The word person as used herein shall be deemed to mean an individual, partnership, association, company, or other unincorporated body of individuals or corporation or body politic. Why did they all of a sudden drop person in here? Right in the midst of it. The word person as used herein shall be deemed to mean an individual. Let's click on it since it's highlighted, see if it's going to bring us back to the same place. As used in this subdivision, the term United States means United. Oh no, it comes from 4305B3. See, it's not pulling this as the definition for person. It's dropping the word person in here and pulling it from another definition at 4305B3.
Pretty slick.
Uh-huh. And we'll see that here shortly. The words United States as used herein shall be deemed to mean all land and water, continental or insular, in any way within the jurisdiction of the United States or occupied by the military or naval forces thereof. The words beginning of the war, the words end of the war, the words bank or banks as used herein shall be deemed to mean and include national banks, state banks, trust companies, or other banks or banking associations doing business under the laws of the United States or of any state of the United States. The words to trade as used herein shall be deemed to mean pay, satisfies, compromise, or give security for the payment or satisfaction of any debt or obligation. So let's take a look at this wording, folks. Pay, satisfy, compromise, which means with promise. So that would literally be promissory note, or give security. In other words, provide an asset for the payment or satisfaction of any debt or obligation. And in this fiat money system, the asset is the application. That is the security. Like I said, you go down to McDonald's, you fill out that application, you don't know what you're doing, you fill it out, you hand it back to that employer. He just received a security instrument that he now gets to deposit. Get the fuck out of the yard. You don't need to pull all the way back into the yard. I'll start shoving the dog shit out on your fucking lot. Sorry, folks. My apologies. But anyway, pay, satisfy, compromise, or give security for the payment or satisfaction of. If you're going to pay, satisfy, compromise, or give security for the payment or satisfaction of, what is it? You're going to pay for the payment. You're going to satisfy for the satisfaction. You're going to compromise for the what? Promise. You're going to give security for the what? Security. Understand what's being said here, folks. Pay, satisfy, compromise, or give security for what? The payment. So you mean I'm making a payment for a payment? So there's two payments going on. Understand contracts are equal consideration, equal benefit. And if you're being required to pay something, it's a contract. You damn well better be getting paid in return as well. It's that simple, folks. Draw, accept, pay, present for acceptance or payment, or endorse any negotiable instrument or choose in action. enter into, carry on, complete, or perform any contract, agreement, or obligation. Buy or sell, loan or extend credit, trade in, deal with, exchange, transmit, transfer, assign, or otherwise dispose of or receive any form of property. We'll have to go over this term one of these days, but property is not what you might think it is. E, to have any form of business or commercial communication or intercourse with. So, 50 U.S. Code 43022 definitions as it relates to the United States citizen is a business, and that is what we're dealing with. To have any form of business or commercial communication or intercourse with. The birth registration is the beginning of a communication or intercourse with a form of business or commerce. That's it. But that alone evidences the requirement for need of an identification so that you don't get caught up in trading with an enemy. Does that make sense, guys? Sorry about that, Mitch. Didn't see you back there. And there's Christopher.
Yeah, that makes sense.
Yeah, that's some of the things that people just don't see because they don't bother reading things. And of course, this isn't something that's presented us in our public education, so why would we think about reading it until we get into some kind of problem and have to find out some kind of remedy? And that's why we're going through this, because people aren't taught this. Go ahead.
So in order to perform, I guess, with clean hands and deal with these contracts, say for a truck note, would we have to surrender these things like we've already discussed in order to be able to enforce this?
Well, you're gonna have to understand the contract as they come. And the thing about a truck, when you go to a dealership and you buy a truck, you have to understand that that form they give you, that purchase order, is a purchase order.
Right.
When you look up the definitions and meanings and how things work, you find out that a purchase order is an offer to buy something. They offered you a purchase order. You just bought a purchase order. The purchase order that you just bought is requiring data elements. That's what they're buying. You're buying a car. They're buying the data elements. You give them the right data elements, they can't fuck you on buying the car. You get to use the instrument as a credit device and obtain the automobile on credit, not money.
And that's the private banking stuff that we got to figure out how to.
Yeah, you have to get them to understand there's an accrual method of counting, and that doesn't, the general accounting, generally accepted accounting practices and principles don't allow for cash accounting.
So in regards to what you're saying, whenever we go to a dealership and we're speaking with a salesman, is that who?
We lost you. You cut out Mike. There you go. Are you there? Nope, something happened with your mic. Let me see here. Try now. Nope, something happened to your mic on your end. Drop out and come back in. And we got the Eldon with us. How you doing today, brother? Greatly appreciated. How you been doing?
What's going on, Keith? Doing well.
Slow but sure, going over the Trading with the Enemy Act. We're just finally getting into it after I spent most of the first couple hours going over acquisitions and identification stuff.
Always
Definitions.
always a pleasure to learn.
All right.
Absolutely.
Can you guys hear me now?
We got you back. We got you back.
All right. Awesome.
Wow. You must be in a bad spot, brother. Go ahead and make sure you write your questions down so that when we do get together, we can go over those. But in the meantime, it says your device is not connected. I'm going to kick you again, see if you can get back in. And if you're wandering around the house or something, might I suggest getting near your Wi-Fi device and just hanging out there. In the meantime, we're going to continue on with these definitions. The last section of definitions we're going to look at in 50 U.S. Code is 4552. And I always talk about critical thinkers. And device is not connected. So yeah, if you're in a bad Wi-Fi area and your signal keeps dropping, just make sure you take notes and write questions down so we can get to them later. 50 U.S. Code 4552. For the purposes of this chapter, the following definitions shall apply. Critical component. The term critical component includes such component, subsystems, systems, and related special tooling and test equipment essential to the production, repair, maintenance, or operation of weapon systems, or other items of equipment identified by the President as being essential to the execution of the national security strategy of the United States. And we know the intelligence system is essential, and you are part of that intelligence community and those intelligence systems. And I urge you to start using your critical thinking as a component of that set of systems. Components identified as critical by national security assessment conducted pursuant to Section 113I of Title 10, or by a presidential determination as a result of petition filed under Section 1862 of Title 19. Safeguarding national security. Prohibition on decrease or elimination of duties or other import restrictions if such a reduction or elimination would threaten to impair national security. No action shall be taken pursuant to Section 1821 or pursuant to Section 1351 of this title to decrease or eliminate the duty or other import restrictions on any article if the President determines that such a reduction or elimination would threaten to impair national security. So we're going to move the article from the state to the federal, and we're not going to prohibit or we're not going to decrease or eliminate the duties. We're going to enforce the duties by giving them notice of critical components that are in error and create a fatality to the integrity of the record as it stands. Investigation by Secretary of Commerce to determine effects of national security of imports of articles. Consultation with Secretary of Defense and other officials. Assessment of defense requirements. And under the 5 U.S.C. 301 departmental regulations, the minimum birth registration standards are not met. And 5 U.S.C. 301 is applicable to Department of Defense. So when it comes to the Department of Defense articles, the birth registration, the assessment of defense requirement is not supported. It is not registered in the United States. It remains registered in the state. Therefore, we're going to register it in the United States through the Department of State as a matter of Homeland Security redress for misidentification. Upon request of the head of any department or agency, upon application of an interested party, as the interested party, this is our power, or upon his own motion, the Secretary of Commerce shall immediately initiate an appropriate investigation to determine the effects on the national security of imports of the article, which is the subject of such request, application, or motion. Does that make sense now, John? That what I'm talking about with, or excuse me, John's not here. We lost John. Well, hopefully you're hanging on, John, Don. Does that make sense when I talk about taking the birth certificate from the state and handing it over to the federal government in relations to diplomatic credentials, as it shows along with the high school diploma that I am already accredited through birth and education? Does that sound reasonable? Oops, we lost Don too. Anyway, you can chime in if you want, Mitch. I'm going to assume you think that sounds reasonable, because to me, I don't see any other way of doing it.
Right. Yeah, I agree.
Sorry, I got booted though.
Oh, there you are. So do you agree with me, and that makes sense to take the birth certificate from the state and hand it over to the federal government, along with that redress with Homeland Security and the fact that you were a high school graduate, therefore already accredited?
Well, that's part of the being inherent, right? That comes with our everything they created for the name.
Correct. Yes, Kingfish says you would be surrendering the monopoly board piece to the trustee of the territory, the commander-in-chief, the only one who takes an oath that is within the Constitution. So yeah, it's a matter of handing I'm done playing. Here's your piece back. You can go ahead and play with it, but I've got a whole new game. So yeah, basically the concept. Let's continue on then. It says the Secretary shall immediately provide notice to the Secretary of Defense of any investigation initiated under this section. And again, that's a birth registration article, and it is applicable to the Department of Defense. And under the plain writing, the minimum birth standards are not met, and therefore it needs to be handed over to the Department of Defense and handled, or Department of State, I would think. In the course of any investigation conducted under this subsection, the Secretary shall consult with the Secretary of Defense regarding the methodological and policy questions raised in any investigation initiated under paragraph 1. Any. Upon application of an interested party. Now, this doesn't mean they've got an application out there that I'm going to fill out. I'm going to enter a declaratory judgment, which, once substantiated, is a final judgment. Let's see here. Seek information and advice from and consult with appropriate officers of the United States, and if it is appropriate and after reasonable notice, hold public hearings or otherwise afford interested parties an opportunity to present information and advice relevant to such investigation. That would be all my brothers and sisters and researchers of like kind that have come across all this information and can substantiate it with their sources in each state. Like I say, with the Iowa Administrative Code and the Vehicle Registration Guidelines. So each state is going to have something like that. Each state should have something like that. If there is a state that doesn't, it can easily be implemented under Article 4 of the Constitution, Equal Protections Clause. And this again goes to the sovereignty of the states. Just because all the states gathered up in one union of states doesn't mean an individual state that doesn't have the equal protections of the rest of them can't assert that national sovereignty and maintain it under that Article 4 clause. That's why it's there. Upon the request of the Secretary of Defense shall provide the Secretary an assessment of the defense requirements of any article that is subject of an investigation conducted under this section. So when the minimum birth registration standards are not met, and you acquire that birth registration from the state and present it to the United States, it is due to the fact that the minimum birth registration standards require that the birth be registered in the United States, wherein it is not. Therefore, once you do register it in the United States, you would do so of one of two capacities, and that would be the United States citizen or the American citizen. You cannot serve two masters. 3, by no later than the date that is 270 days after the date on which an investigation is initiated under paragraph 1 with respect to any article, the Secretary shall submit to the President a report on the findings of such investigation with respect to the effect of the importation of such article in such quantities or under such circumstances upon the national security, and based on such findings, the recommendations of the Secretary for action or inaction under this section. So that's what we're looking for, is the amnesty, the armistice, the agreement that we were already accredited, and any further subjection to unlawful searches, seizures, or even request for such ID would be, in fact, irreparable harm and damage. You are not supposed to be requiring your people to present an identification that is specifically for a citizenry. And that citizenry has to qualify. The American citizen qualifies through common law, which doesn't require such identifications. It requires private credentials. If the Secretary finds that such article is being imported into the United States in such quantities or under such circumstances as to threaten to impair the national security, the Secretary shall so advise the President in such report. We're not doing it in that fashion. We're doing it under 4305B2 as a matter of full acquittance and discharge in the interest of the United States, for the account of the United States, and for the person making the same, the third party who has interests, so that no person shall be held liable in any court. And we'll be reading that. Any portion of the report submitted by the Secretary under subparagraph A, which does not contain classified information or proprietary information, shall be published in the Federal Register. The Secretary shall prescribe such procedural regulations as may be necessary to carry out the provisions of this subsection. Adjustment of imports, determination by President, report to Congress, additional actions, publication in Federal Register. Basically the process we just read about. Within 90 days after receiving a report submitted under subsection B, 3A, in which the Secretary finds that an article is being imported in the United States in such quantities or under such circumstances as to threaten to impair the national security, the President shall determine da-da-da. And this, under such circumstances as to threaten to impair the national security is already impaired by a document that creates a false integrity. In other words, that document saying that I'm a United States citizen, a United States business, an official or agent of the federal, state, or municipality, paying taxes, and this and that, is false. I've only presumed it to be true and used it imperfectly and unstably, incorrectly, in error, mistakenly, accidentally, without knowing the full consequences and implications of its use. Determine whether the President concurs with the finding of the Secretary. If the President concurs, determine the nature and duration of the action in the judgment of the president must be taken to adjust the imports of the article and its derivatives so that such imports will not threaten to impair the national security. So from now on, the article is corrected and its derivative transactions can no longer be misconstrued if it's been corrected. If the president determines under subparagraph A to take action to adjust imports of an article and its derivatives, the president shall implement that action by no later than the date that is 15 days after the day on which the president determines to take action under subparagraph A. So, if the president determines under subparagraph A to take action to adjust imports of an article and its derivatives, the president shall implement. In other words, the president shall contract. The president is the one, like I showed earlier, with trade agreements with. He is the one we do the trade agreement with. We communicate with Congress through the contract terms and conditions, and then he executes and we execute. He's the one we're supposed to be trading with. That's the part of the remedy most people aren't going to comprehend. They think remedy is just putting forth their demands. No, you have to have a contract. You have to contract. Equity imputes an intent to fulfill an obligation. The obligation is contracted, so you have to contract. Who with? By no later than the date that is 30 days after the date on which the president makes any determinations under paragraph 1, the president shall submit to Congress a written statement of the reasons why the president has decided to take action or refused to take action under paragraph 1. Such statement shall be included in the report published under subsection E. If the action taken by the president under paragraph 1 is the negotiation of an agreement which limits or restricts the importation into or the exportation to the United States of the article that threatens to impair national security, and either no such agreement is entered into before the date that is 180 days after the date on which the president makes the determination, and such agreement that has been entered into is not being carried out or is ineffective in eliminating the threat to the national security. So within 180 days, he's supposed to take have a valid take such action to have an effect to secure the threat. The president shall take such other actions as the president deems necessary to adjust the imports of such articles so that such imports will not threaten to impair the national security. The president shall publish in the Federal Register notice of any additional actions being taken under this section by reason of this subparagraph. So when the president gets that trade agreement with you, it's supposed to be published in the Federal Register as a trade agreement with the foreign government. If clauses 1 and 2 of subparagraph A apply, and the president determines not to take any additional actions under this section, the president shall publish in the Federal Register such determination and the reasons on which such determination is based. So if he takes actions, he's got to publish in the Register the action he took. If he doesn't take action, he's got to publish in the Register the actions he didn't take and why. Domestic production for national defense. Impact of foreign competition on economic welfare of domestic industries. The program of economic welfare, and is dependent on domestic production of man, of animals, which includes but is not limited to man. Impact of foreign competition on the trafficking of persons. It's been going on since the time that they started instituting identifications like this. This is trafficking in persons. If you don't know what it's for and exactly how to use it, you weren't trained and it's being used against you to your disadvantage, that's trafficking in persons. For the purpose of this section, the Secretary and the President shall, in the light of the requirements of national security and without excluding other relevant factors, without excluding other relevant factors, without excluding other relevant factors, give consideration to domestic production needed for projected national defense requirements. The capacity of domestic industries to meet such requirements, existing and anticipated availabilities of the human resources, products, that's the personal services, raw materials and other supplies and services essential to the national defense, the requirements of growth of such industries and such supplies and services, including the investment, exploration, and development necessary to assure such growth. So that means the investment is supposed to be in the people to ensure the population grows. As long as there's a growth in population, that's all they're concerned about. It's not dying off. Well, wait a minute. Now it is. Now they got a concern. And the importation of goods in terms of their quantities, availabilities, character, and use, as those affect such industries and the capacity of the United States to meet national security requirements. In the administration of this section, the Secretary and the President shall further recognize the close relation of the economic welfare of the nation to our national security, and shall take into consideration the impact of foreign competition on the economic welfare of the individual domestic industries. In any substantial unemployment, decrease in revenues of government, loss of skills or investment, or other serious effects resulting from the displacement of any domestic products by excessive imports shall be considered without excluding other factors in determining whether such weakening of our internal economy may impair the national security. Okay, we're going to have to kick Christopher again and see if he can come back. I don't know what's going on, guys. I really don't. What do you think so far, guys? Any comments yet?
So basically, we have to make a pact with the president so that we don't get bugged, so we're not trading with the enemy.
Yep. It's called an equal station in life, and everybody's been operating. We've discussed this on Lawful Living many times, Don. Resident. You got to be resident first before you can be the prime resident. In other words, the president. But there's an equal station in life. You can still be equal to the president without having to be a resident.
I didn't catch the first part of this, but did you go over the definition of American citizen?
No, I did not. If you happen to have it, I know Mitch would love it.
I do not. I was going to look it up, but I didn't want to miss what you were saying, and I don't have anything that I could write with right now. But give me a second, I'll look it up.
Yeah, I would love that, please.
So then the next part goes on while he's looking that up. Upon the disposition of each request, application, or motion under subsection B, the Secretary shall submit to the Congress and publish in the Federal Register a report on such disposition. Now remember that resident is a federal, state, or municipal official or agent whose resident presence is deemed necessary by the board, and the board consists of the Secretary of Commerce and the Secretary of Treasury. congressional disapproval of presidential. We're going to mute you, Eldon. Where are we at? Congressional disapproval of presidential adjustment of imports of petroleum or petroleum products, disapproval resolution. Okay, so we're not talking about import of petroleum or petroleum products. We're talking about that article that we're going to import into the United States and have it registered with the Department of State as a matter of Homeland Security redress for misidentification. Okay. For purpose to determine disapproval resolution. Yeah, we don't need to worry about the rest of that. So it's a matter, like I said, communication with the right people for the right reason to take care of certain things. Safeguarding national security. And then the next one is that very one, 19 U.S. Code 1351, foreign trade agreements. Remember, we were talking about definitions and all of that. Let me see what was the last. It was the Bipartisan Trade Promotion Authority Act of 2002 under 19 U.S. Code 3801. And now we just got done with the safeguarding and national security at 1862. And now we're going to go to foreign trade agreements under 19 U.S. Code 1351. Authority of President, modification and decrease of duties, altering import restrictions. Okay, so the presumption by that identification is that we've had a duty. Now we're going to have a modification from a United States citizen to American citizen, and it's going to decrease duties because it's going to eliminate duties that were presumed that we were qualified for that were not. I'm not fulfilling the performance of the functions of a public office. Okay? I'm not part of the government itself. I am one of the people. I have a greater and superior priority in all matters, plenipotentiary. For the purpose of expanding foreign markets for the products of the United States, as a means of assisting in establishing and maintaining a better relationship among various branches of American agriculture, industry, mining, and commerce. And that's one of the things I'm going to point out to you, Mitch, is that when they start doing this kind of stuff, they're talking about the United States and all these codes, and all of a sudden they insert the American culture. That tells you that there is an American citizenship of some sort. But again, I agree again with you as it relates to things like the Organization of American States. If you want to start talking American, you're talking about the soil, and the soil is of the continent. There's the Northern American continent, the Central American continent, and the Southern American continent. So they're all Americans. It's a different type of nationality, different type of citizenship. By regulating the admission of foreign goods, into the United States. So admission of foreign goods into the United States isn't necessarily a matter of import, export as we think of a physical transfer, but rather the contractual importation of the words and terms of art for commerce. Okay? So I can exchange, and this would be using commodity money, I can exchange a loaf of homemade bread for a dozen eggs. That's commodity money. If I use paper to write out information that I'm going to be dropping off a loaf of bread on this day, and in exchange, they are going to pay me a dozen eggs on this day. That's entering into the United States. That's entering into a contract that is bound by terms and conditions written down on a piece of paper known as legalese, that has a commercial bonding weight, and in a commercial system is known as a commercial instrument, an instrumentality of the government. Otherwise, I can make my own contract with my neighbor. I don't need an instrumentality of the government to write it down, hand it to him, and say, okay, this is our agreement. Now we hand it back to here to hold the record. And then we just do it.
But even though we just do it, doesn't mean that they're going to follow what we just do.
No.
I mean, look at the Lakota Nation. You know, if people are not familiar with Mount Rushmore, well, Mount Rushmore was the Black Hills, and look how many treaties that were between the Lakotas and the United States, all broken.
Every last one of them.
Every last one of them. Now, there was recently something that just went through on the Supreme Court where they won a lawsuit, and they said, we don't want the money. We want our sacred land. And It wasn't even because they never even claimed any land, really. All they were nomads. They traveled with the seasons.
Yeah,
and
that's part of the problem with the discovery of America. The discovery of America changed this land continent in its entirety. Before that, all peoples North, Middle, and North America, Central America, and Southern America were all nomadic. Every last one was all nomadic. So yeah,
keep looking up the definitions of American citizen. I'm looking high and low. I mean, I can get to the etymology of American, and I can get to the etymology of citizen. I can't find anything. I can't find anything in the United States Code of Federal Regulations. I see 45 CFR subsection 506. It says defines civilian American citizen as any person who is being a U.S. citizen was captured in Southeast Asia during the Vietnam conflict by forces hostile to the United States, or who went into hiding in South Asia to avoid capture or interment of such hostile forces. Then you got 50 U.S.C. 4318. This section addresses claims of naturalized American citizens concerning expatriation. It states that such claims shall not be denied based on presumptions of expatriation if the individual provides satisfactory evidence of uninterrupted loyalty to the United States during their absence and has returned or prevented from returning due to circumstances beyond their control. That's interesting.
Yeah, and they try. See, and that's the thing that both Mitch and I have a problem with is anytime they try to give some kind of definition of American citizen, they're using false terms of words and terms of art of the legalese industry, such as person. An American citizen cannot be a person.
What's interesting what you said about being nomadic before, and I think there's some significant importance to from 1906 until 1966 with Eastern Kentucky University, one from changing the name from Eastern Kentucky State Normal School to several different names in between that time frame to Eastern Kentucky University. And then in the 80s is when the chairman of the Board of Regents of Eastern Kentucky University was unalived, and he was also the banking commissioner.
So colloquially, I think back when people, were proud to be American, so to speak, it's when we thought we were state citizens. That's my understanding. That
Right. And you have to understand again, and this is why I appreciate the fact that you agree with me on the biblical aspect. I'm not a citizen as a national or resident, a state national, nothing. I'm a stranger and sojourner with our Father which art in heaven. I live in this world, but I'm not of this world, and one day I will leave. There is no way you can say I'm a permanent resident.
Yeah, that's exactly right. I mean, if anything, my loyalty, you know, which wouldn't be outside of God, it's still within God's, citizenry, but essentially my loyalty would be to my family. You know what I mean? Um, I think biblically speaking, that your family or your tribe is your nation, but that's
Right.
just my interpretation.
Right, and that's what I'm getting at is we are there is a citizenship as a matter of mankind. Okay, and that's the real citizenship in relations to reality is of the flesh and blood is mankind, not persons. So the citizenship of a person is something that is presented by the very definition citizen. So even American citizen can be conceived as personal. But when we think about mankind and citizenship, um, that's that aspect of the spiritual thing again. It's I'm not I'm not of this world, so therefore I'm just passing through. It's nothing permanent. It's temporarily involuntary, and there's nothing else you can do about it, really.
So I think, essentially to show provenance, if you're claiming to be, I mean, like if I was confronted by the feds, theoretically or hypothetically, I guess, then what I would respond as, I I would say that I'm a non-citizen American, and I would prove, I would, show my evidence as being, a private recording in a family Bible that shows, where I came from and has witnesses, and I think that would be sufficient, you know, um, in the eyes of the Lord, so to speak. I mean, how
Yeah,
they,
well, yeah, and technically, according to them, it would be sufficient as well. It's just that many people get butthurt because they think they should have all this power to direct people and control people and tell them what to do. And when they find a way that circumvents it legally, lawfully, and everything, so that they really aren't needed anymore, they get butthurt because they feel unneeded now. I don't give
Shouldn't
a
it be
fuck.
evident? Shouldn't it be evident enough through the word?
Exactly, and that's why I say, when more and more people start grasping this stuff and start doing things based more on a realistic view of how things actually work, the government itself will shrink.
yeah,
It's
they don't
going
really
to.
have the credibility to call us into question. We give them their credibility essentially, but that's where I feel like we fall short because though you're right and should be protected by law, unfortunately, there's no controlling how criminals are going to act. So if until we can get them under control, aka have enforcement of these laws, then I feel like we're in big trouble, and that's really where I try to figure out how to get through that because that I've been the subject of violence, just trying to stand for what's true and right, and so been arrested a lot recently, and
Yeah, how's
I'm
that
just
been going? I know you've been doing some court appearances.
it's going along. I mean, I'm playing the game, but I think I'm winning. They can always change the rules of their game, but it's they're playing games and they're trying to pull whatever procedural bullshit they can on me and abusive process, but I'm getting through it. They tried to raise competency in that one case, but I'm taking 3 other cases to trial pro per,
Yeah.
and
Well, just be careful out there, and I think Cam's got a good shot on what's going on, and that's that injunction for irreparable harm and damages. That's one of those things I've been talking about. They're not supposed to be talking to you.
you're right. And so just that's what I mean. Like, but them even calling you into question and asking for ID, you're definitely onto something. I've never called it that irreparable harm or whatever, but that's essentially what it is. I mean, they're stealing your energy for their demands, and they're not, paying for their orders. If I did that, I'd be considered a criminal. I'd be a thief.
Yep, absolutely. So
And
let's
so
continue.
I don't want to. Yeah, I don't want to derail the conversation. Interesting stuff, man. Glad to be a part of it.
Yeah. So
Thanks.
when it comes to that term American, we have to understand. Now all of a sudden they start using that term here. Available to those branches of American production which require and are capable of developing such outlets by affording corresponding market opportunities for foreign products in the United States. So we're producing American products to be sold out in the international venue, and in exchange, we're also expecting to be able to produce or purchase foreign products here in the United States. The president, whenever he finds as a fact that any existing duties or other import restrictions of the United States or any foreign country are unduly burdening and restricting the foreign trade of the United States, and that the purpose above declared will be promoted by means hereinafter specified, is authorized from time to time. So, when we find out that a program of economic warfare has been fomented against us as a United States citizen when we were born on American soil, it would be imperative to quit taking those things out against the people and actually using the regulations, statutes, codes, and otherwise as they are meant to be implemented in contracts with commercial entities for their commercial purposes. This is the commingling that goes on as it relates to funds earlier, because we have legal entities being commingled with commercial activities. Now, birth registration was the establishment of a legal entity. In an imperfect usufruct, that legal entity was used as a commercial entity by an agent that didn't know he was an agent. Secret agent man. You remember him, don't you? Johnny Rivers, 1971. Secret agent man. They took away your name and gave you a number. How about that? To enter into foreign trade agreements with foreign governments or instrumentalities thereof, provided that the enactment of the Trade Agreements Extension Act of 1955 shall not be construed to determine or indicate the approval or disapproval by the Congress of the executive agreement known as the General Agreement on Tariffs and Trade. So when we think about this, we have to remember that, hey, if I'm domestic and I was born on this soil, then what are the tariffs? Shouldn't be any. Okay? If I'm not exporting and I'm only exchanging it with my neighbor, then there's no tariff. Tariffs are paid by the exporter. to proclaim such modifications of existing duties and other import restrictions, or such additional import restrictions, or such continuance, and for such minimum periods of existing customs or excise treatment. Excise treatment of any article covered by foreign trade agreements as are required or appropriate to carry out any foreign trade agreement that the president has entered into hereunder. Bear with me. Okay. Excise, this is from LII-WEX, is defined as an indirect ad valorem tax imposed on goods produced or sold within a country. Excise is defined as an indirect ad valorem tax imposed on goods produced or sold within a country. Okay. So if we're dealing with something that wasn't produced or sold, but rather exchanged, as a matter of trade, see what happens again? We had United States and they started talking about America. We're in here talking about foreign trade agreements, and they're talking about excise treatment as a purchase, a buying or a selling. That's not necessarily the same thing as a trade agreement, folks. Okay? They're treating you as if though you're internal, as if though you're part of the United States. No proclamation pursuant to paragraph 1B of this subsection shall be made, increasing by more than 50% any rate of duty existing. Any rate of duty existing. It's the rate of duty that exists. It's the application of that duty to an individual by an assumption or presumption that is the problem. I don't care what their rate is. Okay, let's get over that, and let's understand that it has to be applicable first and foremost before I should worry about it. I don't worry about it because I know it doesn't apply to me. Except that a specific rate of duty existing on July 1st, 1934, may be converted to its ad valorem equivalent based on the value of imports of the article concerned during the calendar year 1934, determined in the same manner as provided in subparagraph D2. And the proclamation may provide an ad valorem rate of duty not in excess of 50% above such ad valorem equivalent. Again, just a bunch of babble to me. Transferring any article between the dutiable and free lists. Oops. Does that say free list? Break time. Oh my God. What up, guys? You are reading it, right? Yeah, Christopher, I don't know what's going on, but you're in a bad place or something because says your device is not connected and just won't connect up. Sorry. We'll keep kicking you until you can find a better place or something. Keep trying. Always appreciate you coming up.
What I think it is his permissions on his browser. That's what it seems like. He might have to go in and make it allow
Seems
permission.
odd. He was up earlier.
Yeah, he was up earlier. And if you didn't hear that, Christopher, hopefully you'll hear it now. Mitch is saying it might be on the permissions on your browser. Check the permissions on your browser.
It sounds like his browser keeps cutting off his microphone access. So it's his permission to access the microphone through the browser.
Okay, there you go. That makes sense. That makes sense. Check your mic settings. There you go. Look at that. There he is.
Okay, so should I leave the mic settings alone and just keep it running?
Yeah, if you're working now, then no problem. But if you end up having that same problem again, check your permissions.
Okay. Sorry about that, guys.
No, you're fine. You're fine. So what do you think? Transferring any article between the dutiable and free list. Did you know they had such lists? One is a dutiable list and one is a free list. How about that?
I didn't know that.
Everybody talks about that do not detain list. Why do you suppose that would be? Because you're not dutiable? Interesting stuff, huh, guys? Okay.
Absolutely.
Oh, yeah.
In order to carry out a foreign trade agreement entered into by the president before June 12, 1955, or with respect to which notice of intention to negotiate was published in the Federal Register on November 16, 1954, decreasing by more than 50% of any rate of duty existing. Yeah. See, the duty has to be existing. It can't be presumed. So you have to have an actual and factual assignment, appointment, election, whatever. It has to be mutually consented to. D. In order to carry out a foreign trade agreement entered into by the president, any rate of duty below the lowest of the following rates, the rate 15% below the rate existing January 1st. In the case of any article subject to an ad valorem rate of duty above 50%, the rate 50% ad valorem. In the case of any article subject to a specific rate of duty, the ad valorem equivalent of which has been determined by the president to have been above 50% during in order to carry out a foreign trade agreement entered into by the president. See, the dutiable rate, in assessing a foreign trade agreement, you would have to accept some kind of duty, okay? Again, equity imputes an intent to fulfill an obligation. So with a foreign trade agreement, you take upon a certain obligation, but you make sure it is very certain. And so when it comes to these rates, these dutiable rates, that's where the fee schedule comes in. If you want me to sit down with one of your investigative officers in a interrogation room, say for an hour, it's going to cost you $10,000. You want me to let one of your P.I.G.S.C.U.N.T.S, people in government servitude can't understand normal thinking standards, understand the term P.I.G.S.C.U.N.T as I use it. People in government servitude can't understand normal thinking standards. And so when I run across people like that and they want to throw me in handcuffs, I'm likely going to charge them $5,000 just for putting the handcuffs on me. Now, putting the handcuffs on me means that they've already stopped me and taken the time to do some kind of communication of some sort. That itself is going to be an initiating stop of $10,000. So, you just let them know what kind of fees they're facing for those kind of things. You contract them. If I happen to be in this territory and one of the officers in that territory, who we all know can cause irreparable harm and damage by his discernment and not knowing the law, doesn't in fact know the law, and takes my documentation, diplomatic documentation, and doesn't heed it and throws me in jail, not only am I going to have my compensation, but in that fee schedule, there's going to be certain consequences for people that do things like that. You're not allowed to do that. And if you do, and you arrest me for, say, driving without a license, and it carries a $650 fine in the state of Texas, I don't know where it's at. I don't care. We're just giving a presumption, a scenario. And come to find out that's a false accusation. Now what you've done is you've accused me of doing something that I'm not qualified to do. You've accused me of driving. That's a false accusation. And you assess that penalty under the statute for $650 or whatever. That's now your penalty. Along with that, you also kidnapped me for those commercial purposes. Now you're going to have to deal with the kidnapping charges. See, your puny little fucking commercial charges don't mean a motherfucking thing to me. But when you start kidnapping me to try to force me into your contractual bullshit, ain't going to work no more. And I'm not saying I'm all this and I'm all that and I'm going to enforce this and I'm going to do that, because I don't know what's going to happen. But I guarantee you, when they arrest me for any kind of bullshit like that, it ain't going to go the way they think it's going to go. You can keep me in jail as long as you want. And it may not even go the way I think it's going to go. Like I said, I don't know if I can enforce this. But I know damn good and well I am no longer going to act like a bitch-ass slave and subject myself to some bullshit because you try to put fear in me. You can't do it anymore.
I'm going to sing my same song and do my same dance.
Yep. So, let's go ahead.
Yeah, just real quick, I was just going to say, what enforcement would look like in my eyes is like, say they misinterpreted the law or whatever and came and arrested you, and then ironically, what's memorialized in law is a continental marshal or a constitutional sheriff could go enforce a habeas corpus and get you out of a municipal, county, or federal,
Right. That's why we're supposed to be working with those federal people. And the constitutional marshal or the continental marshal. Yes. Yes.
It's interesting how it's all kind of falling together now.
Yep. Slow but sure, brother. Slow but sure. So 50 U.S. Code Chapter 53 is the Trading with the Enemy Act. And as we read earlier, 4301 designation of chapter and 4302 definitions. We read both of those. Designation of chapter known as Trading with the Enemy Act. And the definitions we all read through. Enemy as used in hereafter, individual. We read this short little part. And then we got acts prohibited. So what are the acts that are prohibited? Well, first of all, it applies to persons, not men, and those persons in the United States. For any person in the United States, except with the license of the president granted to such person. Does that sound like the license granted to such person through a trade agreement, as we just previously talked? Wouldn't that be a proper licensing of equal station of a nation as a whole, coming forth as a government leader and not a mere resident? Or to the enemy, for any person in the United States, except with the license of the president granted to such person or to an enemy. Except with license of the president granted to an enemy. Well, why would the president grant a license to an enemy? Or ally of enemy. As provided in this chapter, to trade or attempt to trade. Not buy or sell, to trade. Not buy or sell, to trade. to trade. As we saw earlier, such individuals, such other individuals or body or class of individuals. Read this earlier. Remember? About them banks. There's nothing in here about purchase. Okay? So understand the terms they use are very different. And this is not talking about buying and selling, as in purchasing. It's talking about trades or attempt to trade, either directly or indirectly with, to, or from, or for, or on account of, or on behalf of, or for the benefit of any other person, with knowledge or reasonable cause to believe that such other person is an enemy or ally of enemy, or is conducting or taking part in such trade directly or indirectly for or on account of or on behalf of or for the benefit of an enemy or ally of enemy. For any person except with the license of the president to transport or attempt to transport into or from the United States, or for any owner, master, or other person in charge of a vessel of American registry to transport or attempt to transport from any place to any other place, any subject or citizen of an enemy or ally of enemy nation, with knowledge or reasonable cause to believe that the person transported or attempted to be transported is such subject or citizen. So again, it has to be with absolute knowledge and intent. For any person other than a person in the service of the United States government or of a government of any nation, except that of an enemy or ally of enemy nation, and other than such person or class of persons as may be exempted hereunder by the president or by such person as he may direct, to send or take out of or bring into or attempt to send or take tangible form of communication except in the regular course of the mail, and it shall be unlawful for any person to send, take, or transmit, or attempt to send, take, or transmit out of the United States any letter or other writing, book, map, plan, or other paper, picture, or any telegram, cablegram, or wireless message, or other form of communication intended for or to be delivered directly or indirectly to an enemy or ally of enemy. Provided, however, that any person may send, take, or transmit out of the United States anything herein forbidden, if he shall first submit the same to the president or to such officer as the president may direct, and shall obtain the license or consent of the president under such rules and regulations and with such exemptions as shall be prescribed by the president. So again, we have the second time they mentioned licensed by the president. How many people have done their research to find out that you could be licensed by the president and not by the state?
My first time.
I haven't. This is the first time I see that.
Yeah, see? Learning something new. Got to do it, folks. Whenever, during the present war, the president shall deem that the public safety demands it, he may cause to be censored under such rules and regulations as he may from time to time establish. Communications by mail, cable, radio, or other means of transmission passing between the United States and any foreign country, he may from time to time specify, or which may be carried by any vessel or other means of transportation touching at any port, place, or territory of the United States and bound to or from any foreign country. Any person who willfully evades or attempts to evade the submission of any such communication to such censorship, or willfully uses or attempts to use any code or other device for the purpose of concealing from such censorship The intended meaning of such communication shall be punished as provided in section 4315 of this title. Offenses, punishment, forfeiture of property. Whoever shall willfully violate any of the provisions of this chapter or any license, rule, or regulation issued thereunder, and whoever shall willfully violate, neglect, or refuse to comply with any order of the President issued in compliance with the provisions of the chapter shall, upon conviction, be fined not more than $1 million, or if a natural person, be in prison not more than 20 years, or both. Now, if you have one license with the President and you are pulled over by an officer of the law and he writes you a citation and the prosecutor writes a case up and the clerk signs that issue to assign a trustee to the case and assigns the judge as the trustee, and they demand that you go to that court, make sure you submit that fucking fee schedule and let them know that if you wish to do this again, this is your only goddamn notice. I'm letting you off the hook on the penalty of 20 years in prison, but I still want a fucking fee. Now, I'm going to show you 18 U.S.C. 1589. And this is relative to trafficking persons at 1580. And at 1589, it talks about forced labor. Okay? And forced labor says, whoever knowingly provides or obtains the labor or services of a person by any one of or by any combination of the following means: by means of force, threats of force, physical restraint, or threats of physical restraint to that person or another person; by means of serious harm or threats of serious harm to that person or another person; by means of the abuse or threatened abuse of law or legal process; or by means of any scheme, plan, or pattern intended to cause the person to believe that if the person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint. So let me remind you again, when the officer pulls you over alongside the road, he's already provided physical restraint. Shall be punished as provided under subsection D. Subsection D says whoever violates this section shall be fined under this title. Notice it doesn't say how much. But it does say in prison not more than 20 years or both. So your fine is $1 million. It coincides with the previous code. Acts prohibited. $1 million. $1 million. Excuse me, $1 million. Okay? 20 years or both. Whoever violates this section shall be fined under this title, in prison not more than 20 years or both. If death results from a violation of this section, a term of years or life or both. Let's see what this other one says. Does it say the same thing? No. However, it goes on to civil liability, hearing, judicial review. A civil penalty of not to exceed $50,000 may be imposed by the Secretary of the Treasury on any person who violates any license, order, rule, or regulation issued in compliance with the provisions of this chapter. When we look at this one, this is forced labor. And when it talks about abuse or threatened abuse of law or legal process, this is from the same one, C.O.W.A.R.D.S. So let's go down and look at C.O.W.A.R.D.S. C.O.W.A.R.D.S says in this section, the term abuse or threatened abuse of law or legal process means the use or threatened use. So the use or threatened use of a law or legal process literally means abuse or threatened abuse of law or legal process. You guys comprehend that? You guys fully understand what's being said here?
Yes.
So anytime they use or threaten to use a law or legal process, it means it is abuse or threatened abuse. Merely the term abuse or threatened abuse of law or legal process, meaning the use or threatened use, is saying it means it's abuse. Whether administrative, civil, or criminal, in any manner or for any other purpose for which the law was not designed, in order to exert pressure on another person to cause that person to take some action or refrain from taking some action.
So would that mean that you were under duress?
Absolutely. And that's the same language here. You gotta understand the English language is so colorful. It can use a multitude of terms and conditions in various different places that will make it sound totally different when in fact they're almost identical. So, any property, funds, securities, papers, or other articles or documents, or any vessel, together with its tackle, apparel, furniture, and equipment, that is the subject of a violation under paragraph 1, shall, at the discretion of the Secretary of Treasury, be forfeited to the United States government. And again, it's important to understand the term property is not what you think it is. We will talk about that some other time. But just to put it in a light premise, property is the rights and interest to the enjoyment of possession and use of a thing. So the possession and use of the roadways is my property because I have a right to its possession and use as a private man. Nothing more, nothing less. That is my property. Okay? It's not claiming ownership, claiming possession and use, the beneficial right of enjoyment of possession and use for one's benefit. The penalties provided under this subsection may be imposed only on the record. You guys understand this? The penalties provided under this subsection may be imposed only on the record. After opportunity for an agency hearing in accordance with sections 554 through 557 of Title V. What is Title V? Employees. The penalty for this subsection may be imposed only on the 5 U.S.C. 552A on individual. Everybody's claiming to be an individual and maintaining a record, and that's an employee of the federal government. Okay? Judicial review of any penalty imposed under this subsection may be had to the extent provided in Section 702 of Title V. Imposed under Section 702 of this, or Section 702 of Title V. Judicial review of any penalty imposed. The penalty imposed is under Title 50. It's a military penalty. And guess what? It's imposed under employees, Section 702, in administrative courts with an admiralty maritime flag. It is a military venue. It is for military contracting. And it is all about the Trading with the Enemy Act, a program of economic warfare. C, forfeiture. Upon conviction. Upon conviction. Not at the side of the road when the officer pulls you over and says you don't have a license, we're towing your car. Nope. Upon conviction. any property, funds, securities, papers, or other articles or documents or any vessel, together with tackle, apparel, furniture, and equipment concerned in any violation of subsection A, may be forfeited to the United States. So where is the authority to take it first with intent to be forfeited to the United States and then don't forfeit it to the United States? Auction it off for sale instead. Huh? State leaves all interest behind and leaves it in the impound lot, and the impound lot is the one that sells it for storage fees, to recoup storage fees. None of it ever goes to the state or the United States. What goes to the state is the investment in the court program. That's the papers, the securities and papers. But the actual vessel, the automobile that gets towed, that's different. And it's not supposed to be done unless upon conviction. Fifth Amendment takings clause. It's a violation every time. Statute of limitations. Time for commencing proceedings. For commencing. What is a commencement? In general, an action, suit, or proceeding for the enforcement of any civil fine, penalty, or forfeiture, pecuniary or otherwise, under this section, again, this is the military code, shall not be entertained unless commenced within 10 years after the latest date of a violation upon which a civil fine, penalty, or forfeiture is based. Within 10 years, huh? Wow. Commencement. See, that doesn't sound like 3 days offer and acceptance, does it? Huh, guys? You think there's something else that they're trying to subject you to according to a presumption or assumption in there? Oh, yeah. This is the safety and concern of the community. This is the military safety and concern of the community. They say every person has a duty to their fellow man, and I will assess that as true and correct.
Are you sharing that on the screen?
Should be. That's what I've got up right here.
Oh, the threat.
Oh, I'm sorry. I'm sharing the wrong page. I'm sorry. My apologies. Thanks for the catch.
You were saying commencement, and I was like, well, wait a minute. I don't see anything.
Yeah. I'm sorry. I thought I was on this one. I was still on the 1859. 1589, 18 U.S.C. 1589. That abuse or threatened abuse of the legal or lawful process.
Yeah.
So, commencement. For purposes of this paragraph, the commencement of an action, suit, or proceeding includes the issuance of a pre-penalty notice or finding of violation. Time for indictment. No person shall be prosecuted, tried, or punished for any offense under subsection A unless the indictment is found or the information is instituted within 10 years after the latest date of the violation upon which the indictment or information is based. Yep. So that's your penalties. For offenses, punishments, forfeitures, and stuff. And let's go back to the acts prohibited. For any person, except with the license of the president, to transport or attempt to transport into or from the United States, or for any owner, master, we already read that one. C is where we're at, I guess. For any person, where we at? Transmit. Where were we at? I think it was right here, wasn't it? There we are, yep. Because this is why we have a duty to our fellow man, okay? This is why I agree that we have a duty to our fellow man. Whenever during the present war, the president shall deem that the public safety demands it. If we don't want war on our soil, we need to learn how to be diplomatic. We need to learn how to have that, the ethics, morals, and etiquette to prevent warring even with our own neighbor. So that when they come accost you while you're walking across a church parking lot and try to accuse you that you might be a predator and stalking one of the children on the lot, after they've seen you several times over a number of years, a course of years, walking back and forth and back and forth and back and forth, and never once having any interactions with any of them, but just minding my business and going from point A to point B, you can explicitly express that to them. Hey, you have nothing to worry about despite his insane fears. I suggest you put a leash on him, not me. He may cause to be censored under such rules and regulations as he may from time to time establish communications by mail, cable, radio, or other means of transmission passing between the United States and any foreign country. Now, any foreign country, I don't like this here because when we're talking about communications, it's just a foreign government. Like I said, me getting on this device, a communication device, a telecommunication device, and speaking to my brother Russ down in Kentucky is one foreign government. But me even talking to the neighbor next door would be a foreign government. Okay. Shall be punished as provided in 4315. Yep, that's where we got that. So we read that. And oops, I lost my screen share. Pull up screen again. And now we're going to get into
each one of those foreign governments would have a central intelligence agency. Their own mindset.
Correct. Yeah, the brain is your central intelligence agency. That's where you collect all your information, everything. It's your own sound mind. Now, like I said, in regards to the birth certificate and the Social Security card and the state ID and driver's license, this is what we're talking about. We're talking about mitigation of identity theft. And it can't be stolen if you don't have one. You know what I mean? 12 CFR 334.90 duties regarding the detection, prevention, and mitigation of identity theft. Remember, we were talking about all those banks, and that's why we're talking about banking. Because what happens in banking is, in fact, that you're, oops, I got to bring that back up. Oops, do it this way. Your identity, you're handing it over to them, and it is being used for their benefit. In other words, what they're doing is they're taking all the information, the data elements that you're giving them, and they're converting them on their side of the record and using them as an asset. And this is the problem. It creates a debit in your name. And that's where the debt sits. So duties regarding the detection, prevention, and mitigation of identity theft as it relates to that hypothecation of customer securities we talked about earlier. Remember, we looked at that hypothecation of customer securities? That's what the banks are doing. They have a bank account, and then you as a customer come in and subscribe for a connected account. And that is listed as a minor account. Because you are incompetent and didn't know how to contract with a private banker, and instead opened an account under a bank as an official or an agent, otherwise known as a resident, by presenting them an ID that said you were such a resident. That's the problem. You fix that and learn how to give a directive so that anything that's deposited, it's considered for its value, and they are obligated to give credits in exchange. It's a conversion of a definitive money to a credit source so that all the documentation considered fiat money can be collected up in a file and the credits issued therefrom. That's all it is. It's like writing a check, cashing it. Now you no longer have a check, but you have the credits on the account. Why would you still need the check if you have the credits converted on the account that can turn around and, well, I still have $350 sitting here that I can go ahead and write this guy a check for $250. So I got a check for $800 for something, deposited in the bank. I got $350 left. I used $450 in credits on other things, but then I've got $350 of credits sitting there. But I've got a checkbook, and this guy needs a check for $250. So a check and check is just a matter of converting it. So once I give this man his check for $250, he can take it to his bank account and deposit it, and it gets converted to credits. That's automatic. The problem is where those credits go and come from. Okay, let's see here. Scope. This section applies to a financial institution or creditor that is an insured state non-member bank, state savings association, whose deposits are insured by the Federal Deposit Insurance Corporation, insured state licensed branch of a foreign bank, or a subsidiary of such entity. Okay? So the financial institution or creditor is one thing. So what is the opposite of the creditor? We saw that earlier. It's the debtor. So if you go fill out an application for an account at a bank and they consider themselves a creditor, it doesn't matter how much money you have in that bank account. If you've got $1 million, they still consider themselves a creditor, and you are, of course, the opposing party, the debtor. Understand the difference between cash accounting system and accrual accounting. Something I learned recently, very important. Definitions. For purposes of this section in Appendix J, the following definitions apply. Account means a continuing relationship established by a person with a financial institution or a creditor to obtain a product or service for personal, family, household, or business purposes. And includes an extension of credit, such as the purchase of property or services involving a deferred payment. Purchase of property. Remember, I told you the property is the rights and interests of enjoyment in possession and use of a thing. It is not the thing. It is your right and interest in the possession and use of that thing. Okay, this is what the banks are doing, such as the purchase of property. They're purchasing your rights, titles, and interests, and you don't know it. You're selling your rights, titles, and interests and don't know it. And because that contract reflects that you sold your rights, titles, and interests, the bank has them rights, titles, and interests because you didn't clarify it that, no, this isn't for that. You didn't qualify the contract terms and conditions yourself because you just opened a bank account. You didn't care. Buyer beware. You just bought something. You just sold something too. Every instance where you believe you're a creditor, You better understand that you are also a debtor. And every time you think that you bought something, you actually sold something too. They work hand in hand. A deposit account. The term board of directors includes, in case of a branch or agency of a foreign bank, the managing official in charge of the branch or agency, and in case of any other creditor that does not have a board of directors, a designated employee at the level of senior management. As I said, you're also a creditor, right? So if the bank deems you to be a creditor because you've got credit on account, but you don't have a board of directors, a designated employee at the level of senior management is running your account, not you. Covered account means an account that a financial institution or creditor offers or maintains primarily for personal, family, or household purposes. Oops, wait a minute. Did they drop that business purpose? Account, business purposes. Covered account, or household purposes, not family, not business purposes. That involves or is designed to permit multiple payments or transactions, such as a credit card account, mortgage loan, automobile loan, margin account, cell phone account, utility account, checking account, or savings account, and any other account that the financial institution or creditor offers or maintains for which there is a reasonably foreseeable risk to the customer or to the safety and soundness of the financial institution or creditor from identity theft, including financial, operational, compliance, reputation, or litigation risks. Says credit has same meaning as in 15 U.S.C. 1681 AR5. Credit and creditor have the same meanings in section 1691 of this title. Credit means the right granted by a creditor to a debtor to defer payment of debt. The term credit means the right granted by a creditor to a debtor to defer payment of a debt.
You sharing the right screen?
Like I showed you before, the United States is an obligation, and other security of the United States is, in fact, the debtor for all debts, public and private. Okay? That means the right granted by a creditor. The people, as the creditor unto that United States, are the ones that granted them all powers, including the right to defer a debt in those constitutions, federal or state. No ifs, ands, or buts about it. The people are, in fact, the creditors. Okay? To a debtor to defer payment of a debt or to incur debts and defer its payment or to purchase property or services and defer payment therefore. Incur debts and defer its payment. Then why are they demanding payment? Huh? See what credit really means? You ain't got no credit if you've been going around paying all your bills, saying, oh, I'm building up my credit. I'm paying all my bills. You build up credit by using the right to defer payment of a mammon money. Okay?
You're just building up the banks.
Yep. The term creditor means any person who regularly extends, renews, or continues credit, which is credit is the ability granted or the right granted by a creditor to a debtor to defer debt. Okay? Renews or continues to defer debt. Why would you continue to renew or defer debt? Owe no man anything but to love one another. For to love one another is to fulfill the law, and all glory goes to God. He is the true creator, and the spiritual merits, or the merits of my actions, are to his spiritual credence. It is only by his inspiration that I do what I do. Any person who regularly arranges for the extension, renewal, or continuation of credit. That would be the bank too. Don't they do the same thing? Aren't these the things that we perform the functions of? We're all similarly situated doing the same kinds of things, but don't know how to clarify our part in it. Or any assignee of an original creditor who participates in the decision to extend, renew, or continue credit. Do you participate in the decision to extend, renew, or continue credit? Absolutely. The term person means a natural person, a corporation, government, or governmental subdivision or agency, trust, estate, partnership, cooperative, or association. Remember what we were talking about earlier, that familia? It's ridiculous how these people think. G, any reference to any requirement imposed, that's that imposition, the disposition we were talking about earlier. See, you're dispositioned automatically. That's an imposition. United States citizen is an imposition to American citizenship. Okay? And that is an imposition to your right of being a prophet unto the nations. So sanctified and ordained accordingly already in the scriptures. Any reference to any requirement imposed under this subchapter or any provision thereof includes reference to the regulations of the Bureau under this subchapter or the provision thereof in question. The Bureau. What is the Bureau? The Bureau is the Bureau of Consumer Financial Protection. Everything is about that commerce. That's why that legal entity is created. And this is 15 U.S. Code 1691A, definitions, rules of construction. Term applicant means any person who applies to a creditor directly or for an extension. That applicant, the application is the security that they're working with. You do it everywhere you go. You fill out a registration application for your children to apply public education to them. You go down to the bank and you open up an account. You filled out an application to open up that account. That application is the security instrument. So let's see here. Let's go back to 50 U.S.C. Chapter 53, Trading with the Enemy, as it goes to 4304 is licenses to enemy or ally of enemy, insurance or reinsurance companies, change of name, doing business in the United States. Okay. Licenses to enemy or ally of enemy, insurance or reinsurance companies. Change of name. Now, a lot of people are going to think and go straight to the court thing, name change decree. No. No. Change of name within the documentation by gathering up all these insurance policies and hypothecating the security of the customer. Hypothecating the application of the customer and putting it in your name to invest in the investment markets. not the customer's name, but the insurance company's name. Why would you invest in 50 customers and invest each one individually under each different name when you invest all 50 of them one time under one name? It's efficiency, that energy efficiency. It's your personal services that being converted and you don't know it, but they get to do it and they're doing it and you don't know it. Every enemy or ally of enemy, insurance or reinsurance company, and every enemy or ally of enemy doing business within the United States. So you got enemy or ally of enemy insurance or reinsurance company, and every enemy or ally of enemy. So you have an enemy or ally of enemy, and you have an enemy or ally of enemy insurance or reinsurance company. Now let me ask you, why would you need insurance if you're not an enemy or an ally of an enemy? Because that's what this here is saying. That's why you need insurance, is because you're considered an enemy or an ally of an enemy. That's the presumption. And if that's the case, it's the insurance or reinsurance company and every enemy or ally of enemy doing business in the United States. Why is the United States allowing enemies and allies of enemies to do business in the United States? Through an agency or branch office or otherwise, may, within 30 days after October 6, 1917, Trading with the Enemy Act, apply to the president for a license to continue to do business. And within 30 days after such application, the president may enter an order either granting or refusing to grant such license. The license, if granted, may be temporary or otherwise, and for such period of time, and may contain such provisions and conditions regulating to business, agencies, managers, and trustees, and the control and disposition of the funds of the company, or of such enemy or ally of enemy, as the president shall deem necessary for the safety of the United States, and any license granted hereunder may be revoked or regranted or renewed in such manner and at such times as the president shall determine, meaning that it shall not be permanent, but needs a renewal time. I think things are falling in line pretty well here. Don't you think, guys?
Oh yeah.
I mean, everything I'm reading so far tells me it's a pretty tight little ship here, and that they have certain guidelines, and if you stay within that certain guidelines, you're okay. Doesn't matter if they call you an enemy or an ally of the enemy. You can still license with them and have those international protections afforded by Congress and President and the communications therewith. It's a matter of diplomacy, folks. So,
Well, you don't need insurance if you have assurance.
absolutely. Like what I say, go ahead.
I'm actually dealing with the with an insurance company as of right now. My truck was stolen on Tuesday. Here, I'm here in Houston, Texas, and after it got stolen, of course, I had to reach out to the insurance company that I insure with, or that I'm insured with, and reach out to the financial institution and tell them what happened, what's going on. But yeah, just reading this and getting a better understanding of what, I guess, what's actually going on.
Yeah, it's quite a trampoline set of exercises. You know, up and down and flips and arounds and twirls and everything. It's been a long travel for my research, but it's going to take some more time, and I don't know if I'm expressing it to everybody properly or not. I hope I am. I think I am. I'm doing my damnedest to make sure that I am. But I can explain it to you, but I cannot comprehend it for you. That's the main problem we have.
Right.
But when it comes down to it, it's a matter of giving people notice, being equitous about it, having the etiquette, and just standing on simple terms and not pudging. So as we go on, it says, provided, however, that reasonable notice of his intent to refuse to grant a license or to revoke a license granted to any reinsurance company shall be given by him to all insurance companies incorporated within the United States and known to the president to be doing business with such reinsurance company. Provided further that no insurance company organized within the United States shall be obligated to continue any existing contract entered into prior to the beginning of the war with any enemy or ally of enemy insurance or reinsurance company. But any such company may abrogate and cancel any such contract by serving 30 days notice in writing upon the president of its election to abrogate such contract. Now, abrogate and subrogate, relative terms. One means to add on to, one means to take away from. Doesn't mean to switch positions, as many people believe. And what's happening again is that Scripture, you're supposed to be not adding unto nor taking away from the word of God, lest you be found a liar. As we saw earlier, the record is the one that holds the liability, the obligation. And it is the record that is in error. It is the record that is the person. He is respecter of no persons. He doesn't care about the record, neither do I. It's false. I don't care what you want to presume it to be. My yea be my yea, my nay be my nay. If you have anything to say it, and we'll talk about it. But don't sit there and try to tell me you're a United States person, you're a United States citizen, you're a United States business, because that's what you believe. Better do your research and learn how to tell me exactly what is true, because as soon as I find a lie, I'm opening my mouth and I'm going to show you. So, but any such company may add to and cancel any such contract by serving 30 days notice in writing upon the president of its election to add to the such contract. For a period of 30 days after October 6, 1917, and further pending the entry of such order by the president after application made by an enemy or ally of enemy insurance or reinsurance company, within such 30 days as above provided, the provisions of the president's proclamation of April 6, 1917, relative to agencies in the United States of certain insurance companies. Why do you think they keep asking you to telling you got to have insurance? As modified by the provisions of the President's Proclamation of July 13, 1917, relative to marine and war risk insurance. It's marine insurance for Admiralty Maritime war risks. Carried on land as an inland marine insurance program for reinsurance. And you are a common carrier of an insurance policy. You're a common carrier of an insurance policy. You're not a common mail carrier. You're a common carrier of an insurance policy, meaning that you're a person reasonably presumed to be eligible as a contract participant according to the Commodities Exchange Act. Shall remain in full force and effect so far as it applies to such German insurance companies. Remember, I told you World War II was about the German countries, right? Everybody thinks it was about World War II was about German countries. World War I, somebody assassinated Duke Ferdinand of Austria to prevent them and Germany from consolidating their efforts and recreating the German states that the world has been destroying over decades, centuries. People think the Roman Empire fell. No, it didn't. It merged into the German states, renamed itself, continued on, and the world has been trying to destroy them ever since. World War I was fomented under German insurance companies. And the conditions of said proclamation of April 6, 1917, as modified by said proclamation of July 13, 1917, shall also during said period of 30 days after October 6, 1917, and pending the order of the President as herein provided, apply to an enemy or ally of enemy insurance or reinsurance company. Anything in this chapter to the contrary notwithstanding. So tell me why I'm required to have insurance. Anybody?
Because you're deemed to be an enemy or an ally of an enemy?
Absolutely. That's the only presumption that can be laid. How can that exist if you've got a birth certificate or if there's a birth certificate, birth registration on file for yourself? And you had to use that in order to get the identification.
Right.
So it must be presumed that you are an enemy or ally of an enemy because it was not registered in the United States as appropriate, and therefore you got a state ID and not a diplomatic credential. It shall be unlawful for any enemy or ally of enemy, insurance or reinsurance, to whom license is granted to transmit out of the United States any funds belonging to or held for the benefit of such company, or to use any such funds as the basis for the establishment directly or indirectly of any credit within or outside of the United States. See the problem? Nobody in these venues wants to admit that you're a creditor because it's showing and reflecting that you're an enemy or an ally of an enemy through the identification. That identification is evidence that you are either a federal, state, or municipal officer or agent, or you are not. And if you're running around with an ID, whether it be a state ID with a picture on it or a driver's license with a picture on it, rather than private credentials with biometrics on it, then there's a distinct difference, and they know it right up front. Oh, here's another imposter. Congress shall lay and collect taxes, duties, imposts, and excises. And that impost is you. You're an impost. You are the imposter. Know thyself. Or for the benefit of, or on behalf of, or on account of an enemy or an ally of an enemy. For a period of 30 days, October 6, 1917, and further pending the entry of such order by the President after application made within such 30 days by an enemy or ally of an enemy. So the applicant is already deemed to be, because otherwise, why would you need to apply? Okay. Other than an insurance or reinsurance company as above provided. So like he said earlier, you give them assurance. So you're technically supposed to be licensed insurance agents. I urge everybody to read the Postal Service Reform Act of 2022. And when you read that, it's not a very long act. I urge everybody to read it. It's not very many pages. And when you read that and you find out that 95% of what it talks about on there is buying and selling insurance. And then you wonder why they call it the Postal Service Reform Act and why I'm telling you, you are considered a common carrier. It shall be lawful for such enemy or ally of enemy to continue to do business in this country, and for any person to trade with, to, from, for, on account of, on behalf of, or for the benefit of such enemy or ally of enemy. Anything in this chapter contrary notwithstanding. Provided, however, that the provisions of section 4303 and 4315 of this title shall apply to any act or attempted act of transmission or transfer of money or other property out of the United States, and to the use or attempted use of such money or property as the basis for the establishment of any credit within or outside the United States to, or for the benefit of, or on behalf of, or on account of an enemy or ally of enemy. Okay? If no license is applied for within 30 days after October 6, 1917, or if a license shall be refused to any enemy or ally of enemy, whether insurance or reinsurance company or other person. So now we see that we don't have to be an insurance or reinsurance company. There are other persons that can make application, which would be those that are irreparably harmed, even though we're not insurance or reinsurance companies. Or if any license granted shall be revoked by the president, the provisions of section 4303 and 4315 of this title shall forthwith apply to all trade or to any attempt to trade with, to, from, or for, by, on account of, or on behalf of, misproduced by. That's wrong, by in this context, folks. Should be by as a preposition and not by as a verb. Okay, these are all prepositions: to, from, for, on account of, or on behalf of. These are all prepositions. Okay, so by is not right. That should be by as a preposition. Or for the benefit of such company or other person. Provided, however, that such refusal or revocation, anything in this chapter to the contrary notwithstanding, it shall be lawful for a policyholder or for an insurance company, not an enemy or ally of enemy, holding insurance or having effected reinsurance in or with such enemy or ally of enemy insurance or reinsurance company, to receive payment of, or for such enemy or ally of enemy insurance or reinsurance company to pay any premium, return premium, claim, money, security, or other property due. Or other property due. And remember, property is the rights and interests in the enjoyment of possession and use of a thing, or which may become due on or in respect of such insurance or reinsurance in force at the date of such refusal or revocation of license. And nothing in this chapter shall vitiate or nullify then existing policies or contracts of insurance or reinsurance, or the conditions thereof. And any such policy holder or insurance company, not an enemy or ally of an enemy, having any claim to or upon money or other property of the enemy or ally of enemy, insurance or reinsurance company, in the custody or control of the alien property custodian. Now we see a level. that must reflect in the record as the custody or control of the alien property custodian. Now, how does such a person hold my property? How does somebody else hold my rights, titles, and interests, property? How can somebody else be a custodian of property? Only if they're holding a record that somehow shows that I presume it gave up rights, titles, and interests to the property. Wouldn't that be like the SS5, Russ? Yeah, I hear you. Hold on. Hereinafter provided for, or of the Treasurer of the United States, make application for the payment thereof, and may institute suit as provided in section 4309 of this title. We're going to be taking a look at that as far as the remedy, folks. 4309 of this title. So remember that. And then we're going to see during the present war, no enemy or ally of enemy. I'm gonna mute you there, Chris. Okay, during the present war, no enemy or ally of enemy, and no partnership of which he is a member or was a member at the beginning of the war, shall for any purpose assume or use any name other than that by which such enemy or partnership was ordinarily known at the beginning of the war, except under license from the president. Such enemy or partnership. So they're or partnership. So we understand that there's a partnership upon the enumeration of birth. Okay. And the use any name other than that. That's the legal name that was established through a enumeration at birth. Think about that, folks. And I'm going to take a break. You guys go take we're going to take a 5-minute break, and we'll be right back. I got to let the dog out and go grab me a bite to eat. Something to munch on while we're going through the rest of this. I'll be back shortly.
I have a question.
Okay. Okay, we got everybody with us still? Russ, Mitch, and Christopher, you still with us?
Yes, sir.
All right.
Hey, Keith, I had a question,
Sure.
and I'm not sure if this is something you can answer at the time, but so for example, the truck that was stolen, because it was stolen, and there was a contract in place. I'm not sure if I was maybe understanding this is a part of what we're learning here today, but would there be any way that I could possibly rescind that contract and, or not even rescind, but get the money that has been paid into that contract? Or is there any way that I would be able to help myself if the insurance company doesn't I guess help me in the way that I'm looking forward to being helped?
Absolutely. Known as unconscionable contract. And what happens is unconscionable is an adjective that means without a conscience, unscrupulous, so unfair or unjust that it shocks the conscience. The adjective is frequently used in the context of contract law for contracts that have grossly oppressive and unfair terms. When a court finds a contract unconscionable, it is unenforceable. See unconscionability. Unconscionability is a defense against the enforcement of a contract or a portion of a contract. If a contract is unfair or oppressive to one party in a way that suggests abuses during its formation, a court may find it unconscionable and refuse to enforce it. So, did you use a false identification, a false birthright identification to enter into that contract?
I would say yes.
That itself would make the contract itself unconscionable because you weren't conscious at the time of the American citizenship and the ability to communicate with the president for that same kind of licensing that would afford you the protections at the international level rather than a local level that abuses and threatens abuse of them for a purpose that is not meant to be used.
Okay, so I would just have to, I guess, litigate that properly in a way that I could articulate that to the financial institution.
Correct. Sorry,
And
but as far as I understand it, as an independent being and not having a board of directors, I'm not allowed to hire an attorney. But I do understand that since I undertook this insurance policy, you are kind of abrogating those things and adding on to that contract, and you get to present a board of directors to do anything in these courts. That's not to my advantage. Sure, you're going to pay that insurance policy, but then you're going to sit there and convince me that the rest of my life, as I'm paying insurance that I'm not required to have or pay, you're going to jack the price up.
right.
See, a man understands the indentured servitude system in a proper way, and he assures his fellow man that if something goes wrong, I will compensate. I will do this or this or this to cover the expenses. You know, the indentured servitude is also part of the remedy for common law crimes. Whereas you murder a guy and he can no longer perform household duties and protections and stuff. So you could effectively, in a utopic type society where a crime like that might happen, and it's not totally utopic, but it's kind of gearing that way. Somebody gets out of line, kills somebody, and rather than putting him on death row at the state's expense, you let him live freely, but he's now got to live as the head of the household, not being the head of the household. He gets to live in that household with everybody else running it and telling them or telling him what they need him to do as an indentured servant to fulfill the position of the father that he destroyed. So And they need him to go out and work a full-time job, bringing in the money that the man he murdered was bringing in. He needs to do that. And then when he's not at work, you don't get to go home. And no, they still need a father at home to take care of the kids. They still need him in that house as a matter of a household servant. This is why we have to understand the word steward. We're stewards in his house. It's his house. Set thine houses in order. So anyway, it's the insurance companies, and you're not even qualified. You're not. Again, this is my interpretation through my research, that you have to be of certain capacities, be required to take upon it, and that's because you're part of the internal organization. You're either an official or an agent, one or the other. That's the only reason those laws, which apply to them, would require you to partake, is because you are part of them. If you're not, then they don't apply. And you can't be part of them except for certain qualifications. You have to be of age and maturity. You have to be elected. You have to have certain competencies. You have to have the ability to fill an office of some sort to fill those competencies. If you don't have that stuff, then you're not qualified. And they're not qualified to bring the charges against you.
Okay. And I guess my next question would be, how would one litigate this? Because there's a certain time frame that the insurance company has before they file the claim and take care of the financial instrument that's been conducted with the financial institution to get that truck taken care of and protect the consumer's rights. How would I get that started? That, I guess, that journey
Well,
of
who stole it?
I don't even know.
So it wasn't the police,
Right?
it wasn't the bank on a repo. Okay.
No.
So that would be the motor vehicle registration. Those are registration plates, not license plates. And it was registered in the motor vehicle theft prevention program. So I would go to the D.U.M.B and talk to them about that and say, hey, listen, I understand through the motor vehicle theft prevention program, you're actually liable. And this insurance policy needs to have a claim against them, I believe.
Okay. And what if the truck wasn't registered at the time? Like there wasn't any registration?
Then it's not applicable. Was it registered?
It's been registered, but there was no renewal of registration. You know, yearly you get a registration.
Expired. So it was expired, right, and then stolen.
Right.
Okay.
Right.
Well, as a matter of interest, you could still put forward the motor vehicle theft prevention concept, in that it would be inherently important in regards to the Trading with the Enemy Act, that you wouldn't want some enemy or ally of the enemy going around in that motor vehicle causing mayhem. So it's kind of imperative that they find that motor vehicle.
And in the case that they don't find the vehicle,
you're still going to have that fallback on the insurance policy paying out. Is the insurance saying they're not going to pay?
No, insurance did say that they would pay.
Okay. Yeah, you're just going to disconnect the identification from that motor vehicle then. That way it just doesn't come back on you. Give them notice. Hey, it was expired. So if it comes back, I have to understand it wasn't in the motor vehicle theft prevention program, but at the same time, you can't hold it against me because it wasn't registered either. It's a voluntary program, and whatever damages that motor vehicle might cause in the future is no longer your liability. It's been stolen.
Okay.
So we finish up with whenever during the present war, in the opinion of the president, the public safety or public interest requires The president may prohibit any or all foreign insurance companies from doing business in the United States. Or the president may license such company or companies to do business upon such terms as he may deem proper. So basically, it's all up to the president. And again, that's why I believe we're supposed to be talking to Congress and the president. So let's go back. Creditor has that same meaning. Customer means a person that has a covered account with a financial institution or creditor. Financial institution has the same meaning as in 15 U.S. Code 1681 again. Identity theft has the same meaning as in 16 CFR 603.2. Not found. Red flag means a pattern, practice, or specific activity that indicates the possible existence of identity theft. Service provider means a person that provides a service directly to the financial institution or creditor. So, when we talk about service provider, understand that the utility company, the water company, the cable company, they call themselves service providers. And they provide services to financial institutions and creditors. You understand what this statement says? Service provider means a person that provides a service directly to the financial institution or creditor. Okay? State Savings Association has the same meaning as in Section 3B3 of the Federal Deposit Insurance Act, 12 U.S.C. 1813. Now, this is a set of definitions that we're going to look at as regards to deposit. 1813. And it's got that, but we're going to go down here to deposit. The term deposit means the unpaid balance of money or its equivalent received or held by a bank or savings association in the usual course of business and for which it has given or is obligated to give credits. Okay? Oops. I keep forgetting to switch my screen. Deposit. Definition of deposit under 12 USC 1813. The same code they just gave us here. Periodic identification of covered accounts. Each financial institution or creditor must periodically determine whether it offers or maintains covered accounts. As a part of this determination, a financial institution or creditor must conduct a risk assessment to determine whether it offers or maintains covered accounts described in paragraph B32 of this section, taking into consideration the methods it provides to open its accounts, the methods it provides to access its accounts, and its previous experiences with identity theft. And this is an important aspect to understand here, that identity theft, that's what it's all about. The wrong identity. Establishment of an identity theft prevention program. Each financial institution or creditor that offers or maintains one or more covered accounts must develop and implement a written identity theft prevention program. Everyone. That is designated to detect, prevent, mitigate identity theft in connection with the opening of a covered account or any existing covered account. The program must be appropriate to the size and complexity of the financial institution or creditor and the nature and scope of its activities. Elements of the program must include reasonable policies and procedures to identify relevant red flags for the covered accounts that the financial institution or creditor offers or maintains and incorporate those red flags into its program. This is your duty. You have to do this. You have to identify relevant red flags for your accounting. Is it truthful and accurate? If it's not, somebody's going to misconstrue it, and if you use it in the wrong way, they're going to make sure they get to use it for their benefit, and it's never going to be exposed to you. They will let you have that bank account as long as you want and not say a word. Detect red flags that have been incorporated into the program of the financial institution or creditor. Respond appropriately to any red flags that are detected pursuant to paragraph D.2.2 of this section to prevent and mitigate identity theft. And ensure, not insure, but ensure the program, including the red flags determined to be relevant, is updated periodically to reflect changes in risk to customers and to the safety and soundness of the financial institution or creditor from identity theft. I think this is the important part here as it relates to the identity and giving notice to these financial institutions and the integrity of the record and how powerful it can be if everybody had this knowledge. Because then you can respond to your own red flags and correct them right from the start before you even open that account. Instead of opening a regular holder's account, you open up a trust account in the name of the estate. Keith, Lord, and Little Estate, a state trust account. And you do that with pretty much any financial institution. I would prefer to do it with the Postal Service as a savings bank. Just saying. Administration of the program. It is an administrative program, nothing else. You have to be internal to be administrated therein. Each financial institution or creditor that is required to implement a program must provide the continued administration of the program and must obtain approval of the initial written program for either its board of directors or an appropriate committee of the board of directors. Involve the board of directors, an appropriate committee thereof, or designated employee at the level of senior management in the oversight, development, implementation, and administration of the program. And it's just like that banker with a covered account. It has to be managed by a senior management. Train staff as necessary to effectively implement the program and exercise appropriate and effective oversight for service provider arrangements. That's your job right there. You're supposed to provide the appropriate and effective oversight. You're the one that's supposed to be knowing your red flags and how people might be stealing your identity. Know thyself. Know that that's not your identity. That was a state identity, and it's been induced into us to believe that we can use that without any detriment, when in fact it is held to our detriment in every instance, because it is what a charging instrument does, is allows them to charge you. Whereas if you're the true creditor, you allow them, in your capacity, knowing your boss, to grant them the ability to defer the debt to a later time, as they're the debtor. Okay? Guidelines. Each financial institution or creditor that is required to implement a program must consider the guidelines in Appendix J of this part and include in its program those guidelines that are appropriate. Okay. Okay, and that was the end of that one. 4304. So let's go back. We have Chapter 53 of the Trading with the Enemy Act. And 4305, suspension of provisions relating to ally of an enemy, regulation of transactions in foreign exchange of gold or silver, property transfers, vested interests, enforcement, and penalties. Well, that's a mouthful, and that's what we've been talking about all day. Right? This is the one where we're going to find the B2 section. We're going to get on to B2 real quick. 2. And then 3. This is the one where we saw earlier. It says it's going to give the definition of United States. But as we start out, it says the president. The president, if he shall find it compatible with the safety of the United States and with the successful prosecution of the war, may by proclamation suspend the provisions of this chapter so far as they apply to an ally of an enemy, and he may revoke or renew such suspension from time to time, and the president may grant licenses, special or general. I'm not here as a matter of general appearance. I'm here as a matter of special appearance under special license from the president that you have pulled over a diplomatic sojourner without just cause and have demanded him to be in the presence of this court to abuse or threaten abuse of a law or legal system. It'd be $1 million, sir. Temporary or otherwise, period of time and containing such provisions and conditions he shall prescribe to any person or class of persons to do business. Remember, to do business. The other one was to trade. This one is to do business. And that's where we get the title or the definition in Title 26 of trade or business is to the performance of the functions of public office. Provided in subsection A of section 4304 of this title, and to perform any act made unlawful without such license in section 4303 of this title, and to file and prosecute applications under subsection B of 4310 of this title, and to file and prosecute applications. Like it said earlier, it is the record that's liable, right? Are you guys understanding what I'm telling you here? The language is specific, and it says, and to file and prosecute applications. Again, when they do a mortgage foreclosure, they're foreclosing on the address. When they file charges in a court, they're filing charges on the documentation. And so here it says, and to file and prosecute the applications. That is the security. That's what they're filing against. They're filing against the security instruments, not you. Under subsection B of 4310 of this title, and he may revoke or renew such licenses from time to time, if he shall be of opinion that such grant or revocation or renewal shall be compatible with the safety of the United States and with the successful prosecution of the war, and he may make such rules and regulations not inconsistent with law, as may be necessary and proper to carry out the provisions of this chapter. And the president may exercise any power or authority conferred by this chapter through such officer or officers as he shall direct. If the President shall have reasonable cause to believe that any act is about to be performed in violation of Section 4303 of this title, he shall have the authority to order the postponement of the performance of such act for a period not exceeding 90 days, pending investigation of the facts by him. B. And I'll leave it there and take a minute to actually eat. If you guys want to join in the conversation, please feel free. I'd love it while I take my time to eat. Panel is open for a minute.
Well, I can say that this has been a huge help with assisting me in the understanding of what trading with the enemy act is.
Hey, I really appreciate it when you back up. Go back up into my yard, because there's all kinds of dog shit. Okay. Thanks for waiting, guys. And we are back at it with 50 U.S.C. 4305B. And it's got 1, A and B subparts. And then it gets into 2. And this is the part that we're interested in. But we will read the rest of this first. During the time of war, the president may, through any agency that he may designate, and under such rules and regulations as he may prescribe, by means of instructions, license, or otherwise, investigate, regulate, or prohibit any transactions in foreign exchange, transfers of credit or payment between, by, through, or to any banking institution, and the importing, exporting, hoarding, melting, or earmarking of gold or silver coin or bullion, currency, or silver or securities, and investigate, regulate, direct, compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to transactions involving any property in which any foreign country or national thereof has any interest, by any person with respect to any property subject to the jurisdiction of the United States, and any property or interest of any foreign country or national thereof shall vest when, as, and upon the terms directed by the President in such agency or person as may be designated from time to time by the President, and upon such terms and conditions as the President may prescribe, such interest or property shall be held, used, administered, liquidated, sold, or otherwise dealt with in the interest and for the interest of and for the benefit of the United States. And such designated agency or person may perform any and all acts incident to the accomplishment or furtherance of these purposes. And the President shall, in the matter herein above provided, require any person to keep a full record of, and to furnish under oath, in the form of reports or otherwise, complete information relative to any act or transaction there referred to in this subdivision, either before, during, or after the completion thereof, or relative to any interest in foreign property, or relative to any property in which any foreign country or any national thereof has or has had any interest, or as may be otherwise necessary to enforce the provisions of this subdivision, and in any case in which a report could be required, the President may, in the manner herein above provided, require the production, or if necessary to the national security or defense, the seizure of any books of account, records, contracts, letters, memoranda, or other papers in the custody or control of such person. I think this is important. Why we understand what that birth certificate is and what it means to you if you have it in your possession and what you can do with it. Like I said, it's evidence of eligibility of American citizenship. So let's get into the meat. The meat is this paragraph right here. Any payment conveyance, transfer, assignment, or delivery of property or interest therein made to or for the account of the United States, or is otherwise directed pursuant to this subdivision or any rule, regulation, instruction, or direction issued hereunder, shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation of the person making the same, and no person shall be held liable in any court or in respect to anything done or omitted in good faith in connection with the administration of, or in pursuance of, and in reliance on this subdivision or any rule, regulation, instruction, or direction issued hereunder. And it must be made to or for the account of the United States. Not the state of Iowa, not the state of Florida, not Utah, Alabama, no. Made to or for the account of the United States. Simple. Let's see here. Okay, here's the next one. I meant to do this with the other banking one. My apologies. But we had duties regarding the detection, prevention, and mitigation earlier, and then we touched on definitions in 12 U.S. Code 1813. And I meant to hit this one here, which is 12 CFR 1022.3. And again, it's banks and banking, consumer financial protection, fair credit reporting, regulation V. Okay. And what we're looking at here is the identifying information. Remember, I spoke about the biometrics. Identifying information means any name or number that may be used alone or in conjunction with any other information to identify a specific person, including any name, social security number, date of birth, official state or government issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer identification number, unique biometric data such as fingerprint, voice print, retina, or iris image, or other unique physical representation. Unique electronic identification number, address, or routing code. Telecommunication identifying information or access device. Then when it comes to identity theft, means a fraud committed or attempted using the identifying information of another person without authority. That's the state's identification information, and you were granted authority to use it. So how can you be in the wrong? Identity theft report means a report that alleges identity theft with as much specificity as the consumer can provide. That is a copy of an official valid report filed by the consumer with a federal, state, or local law enforcement agency, including the United States Postal Inspection Service. including the United States Postal Inspection Service. How many times am I going to have to tell you it's all about the Postal Service? The Postal Service, the Judicial Officer Department, is a neutral and independent forum within the United States Postal Service, comprising of the Judicial Officer, the Administrative Law Judge, and the Postal Service Board of Contract Appeals. The filing of which subjects the person filing the report to criminal penalties relating to the filing of false information, if in fact the information in the report is false. Okay? This is relative to Deuteronomy 19, wherein they discuss that if you bear false witness, then you yourself, as the bearer of false witness, are subject to the same penalties of that which you falsely bared witness to. So if you say I'm a child pedophile and you're bearing false witness, then you're supposed to be sentenced to jail for child pedophilia, not me. Okay? You charge me with a traffic offense. That's not a valid traffic offense. That offense goes against your record, not me. See, that's the way it's supposed to be in the scripture, and that's the way it's supposed to be in this law. But yet they've constructed a law that is for thee and not for me, and that's the attitude they hold. Got to go in England and Wales, getting late. Many thanks for the attention to detail. We trust remedy will prevail. I hope so as well, man. That's what we're working on, is providing people with a way to contract their own remedy as a trade agreement with their president. So let's continue on. I think that was it for this one. Okay, and the next one I've got here, 16 CFR 681.1, duties regarding the detection, prevention, and mitigation of identity theft. Remember, we were just talking about them red flags. Okay, this is what you have to do. This is your priority. You have to know yourself. If you don't know yourself, then you don't know how to distinguish yourself from that person. And you're brought up in this world induced to believing that you're the person. And we hear it all the time. We hear people talking that person term as if though it applies to the being. No, the person is merely a descriptor of the real thing. Like I've said many times, I am not the noun. I am the verb. I am the thing that lives. In that I have a soul. Living soul. That's an adjective. So we have to think about the language we're using and what it really means. And when it comes to this, regarding duties regarding the detection, prevention, and mitigation of identity theft, this is your own injunction. This is what you've got to do to provide an injunction prior to having a protective order of some sort. And this is why I say the people bringing their children up into this public education system and giving up all the responsibility of this stuff, their children are never going to learn this stuff either. So if you're out there learning this stuff, remember, you've never found this stuff in the public education school books. You're never going to find it in the public education school books. It's for a higher education, much above and beyond high school, of which they give you an accreditation as if though that diploma really means something. Well, make it mean something. Do some research beyond that public education and make sure that you know what you're saying so that you can mitigate the risks before they happen. This section applies to financial institutions and creditors that are subject to administrative enforcement of the Federal Fair Credit Reporting Act by the Federal Trade Commission. So why do you need a trade agreement? Maybe you're finding out Definitions. For purposes of this section in Appendix A, the following definitions apply. Account. Account means a continuing relationship established by a person with a financial institution or creditor to obtain a product or service for personal, family, household, or business purposes. An extension of credit, such as the purchase of property or services involving deferred payment. A deposit account. Why are we talking about deferred payments? If I've got credit, then why do I need to defer a payment? Okay. Okay. So let's talk about the injunctive relief. This is Title 15, which is foreign trade. So the trade agreement within foreign trade is your injunctive relief. If you have a trade agreement in place, sorry, contract is a law. They can't supersede that contract. They can't violate your right of private contract. And if you got a private contract with the president, I'll be damned if they ain't warring against the Constitution and the president then. Think the president's going to be very happy with that? Jurisdiction and service. Several courts vested with jurisdiction of civil actions arising under this chapter shall have power to grant injunctions according to the principles of equity, and upon such terms as the court may deem reasonable, to prevent the violation of any right of the registrant of a mark registered in the Patent and Trademark Office, or to prevent a violation under subsection A, C, or D of section 1125 of this title. False designations of origin, false descriptions, and dilution forbidden. False designation of origin. I did not and was not born in the United States. That would be a false designation of origin. My origin is in heaven, and I am merely just a stranger and sojourner with our Father which art in heaven, in these lands as with him. I'm only sojourning through. Okay? Oops. Guess I better show you. 15 U.S. Code 1125. False designations of origin, false descriptions, and dilution forbidden. Okay? Any person who on or in connection with any goods or services or any container for goods, uses in commerce, any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, which is likely to cause confusion, or to cause mistake, or to deceive as to affiliation, connection, or association of such person with another person, as to the origin, sponsorship, or approval of his or her goods, services, or commercial activities by another person, or in commercial advertising or promotion misrepresents the nature, characteristics, qualities, or geographic origin of his or her or another person's goods, services, or commercial activities, shall be liable in civil action by any person who believes that he or she is or is likely to be damaged by such act. Irreparable harm. As used in this subsection, the term any person includes any state, instrumentality of a state, or employee of a state, or instrumentality of a state acting in his or her official capacity state, and any such instrumentality or employee shall be subject to the provisions of this chapter in the same manner and to the same extent as any non-governmental entity. So don't tell me the law is for me and not for thee. It is for you equally as it is for anybody else, even if it's just a presumption. So what's the address? It's a matter of how you address somebody, right? In a civil action for trade dress infringement. Did Mom address you funny? In a civil action for trade dress infringement under this chapter for trade dress, not registered on the principal register. The person who asserts trade dress protection has the burden of proving the matter sought to be protected is not functional. I've got 93 cases, 94. That are evidence of proving that the protection is not functional, because what it does, in fact, is targets me for penalties. Importation. Any goods marked or labeled in contravention of the provisions of this subsection shall not be imported into the United States or admitted to entry at any customs house of the United States. The owner, importer, or consignee of goods refused entry at any custom house under this section may have any recourse by protest or appeal that is given under the customs revenue laws. Customs revenue laws. And this is, again, I'll mention the Labor Code, because martial law chiefly affects the collection of public revenue. Martial law chiefly affects the police and the collection of public revenue or public taxes and revenue. Article 10. Or may have the remedy given by this chapter in cases involving goods refused entry or seized. So we're not talking about goods, we're talking about the article. So we create the remedy, because there is no remedy. Dilution by blurring, dilution by tarnishment. Injunctive relief, subject to the principles of equity. The owner of a famous mark that is distinctive, inherently or through acquired distinctiveness, shall be entitled to injunction against another person who at any time after the owner's mark has become famous, commences use of a mark or trade name in commerce that is likely to cause dilution by blurring or dilution by tarnishment of the famous mark, regardless of the presence or absence of actual or likely confusion of competition or of actual economic injury. What do you think the United States citizen does? It causes an actual economic injury to the United States itself for misidentification, for not having that distinct element. Number 2, definitions. For purposes of paragraph 1, a mark is famous if it is widely recognized by the general consuming public of the United States as a designation of source of the goods or services of the marks of the owner. So every time you sign something, that's the mark of the owner, and you do it on a public documentation, then I'll be damned if it doesn't become widely recognized by the general consuming public. That's where you're applying it, is in the general consuming public. In determining whether a mark possesses the requisite degree of recognition, the court may consider all relevant factors, including the following: the duration, extent, and geographic reach of advertising and publicity of the mark, whether advertised or publicized by the owner or third parties. You're the third party. In this situation, you are considered the third party. In my opinion. The amount, volume, and geographic extent of sales of goods or services offered under the mark. The extent of actual recognition of the mark. And whether the mark was registered under the Act of March 3rd, 1881. Which has to do with trademarks. Trademark Act of 1881, yep. So, Trademark Act of 1881, or the Act of February 20th, 1905, or on the principal register. So, like I said, the minimum birth registration standard says it's not registered in the United States like it's supposed to, but it needs to be on the principal register. And this is just a registration into the entry into the principal register of the United States, so it can be recognized as the American citizen for the substantive private rights. For purposes of paragraph 1, dilution by blurring is association arising from the similarity between a mark or trade name and a famous mark that impairs the distinctiveness of the famous mark. So what we're talking about here is the dilution of taking the family, the given name with the family name, and it has been diluted and blurred by being presented in a legal fiction, legal entity styled as first and last name. That's dilution. Okay. In determining whether a mark or trade name is likely to cause dilution by blurring, the court may consider all relevant factors, including the following: the degree of similarity between the mark or trade name and the famous mark, the degree of similarity between the given name and family name and the mark, the degree of inherent or acquired distinctiveness of the famous mark, the extent to which the owner of the famous mark is engaging in substantially exclusive use of the mark, the degree of recognition of the famous mark, whether the user of the mark or trade name intended to create an association with the famous mark. Now, this goes to Article 1, Section 8, Clause 8 of the Constitution, and the recognition, again, of creator, author, content. They have no right to take a given name and a family name and convert it to a legal fiction, a legal entity, and then not explain what's going on anywhere, and have people growing up to be adults using this stuff to their own detriment without being taught, so that we could have a good, solid, strong nation. We've got a nation full of stupid people that don't know what's going on, and nobody's explained it to them, and they're charging each other with being stupid. Well, of course, because you're all fucking stupid. I used to be stupid too. I used to be a bitch-ass slave. I used to be a fucking fool. Any actual association between the mark or trade name and the famous mark. Okay? These are all the extent to which the owner of the famous mark is engaging in substantially exclusive use of the mark, the degree or inherent acquired distinctiveness of the famous mark, the degree or similarity between the mark or trade name and the famous mark. They're all mine, is what I've been taught and induced to believe. Come to find out, it was a creation of the state that's been diluted, and I've been believing that that legal thing was for me. No, it's for the United States, and if I happen to come along and want to use it for them, I would be subject to the penalties and offenses otherwise, but I get to charge them for my time for using it as well. But we don't ever know that, and we don't ever do that, and therefore we don't take upon that choice. But if you did have that choice, I still tell you to beware. I wouldn't use it. I'd create your own, even if you have to change your name. For purposes of paragraph 1, dilution by tarnishment is association arising from the similarity between a mark or trade name and a famous mark that harms the reputation of the famous mark. When I look at those documents from the local courthouse and it says last/firm name, and then it's got LITT in all uppercase, and then the obligor, and it's identified by a number, and the LITT is the first 4 letters of my last name, and then the obligor is the social security number without dashes. That tells me that there's a tarnishment somewhere, and that's what harms my true, real reputation as a man, a spiritual living soul, a manly living soul. But that's because I was induced into the same thing as everybody else is to believe that person. He's no respecter of persons, but yet we are induced into it, and we live it throughout our entire lives. And that's a tarnishment. Like I said, I was a fucking fool. Exclusions. The following shall not be actionable as a dilution by blurring or dilution by tarnishment under this section. Any fair use, including a nominative or descriptive fair use, or facilitation of such fair use of a famous mark by another person other than as a designation of source for the person's own goods or services. Okay? So anybody using it in any fashion other than you for your purposes and for your goods and services, it's a tarnishment. They're not supposed to be doing that. Okay? Advertising or promotion that permits consumers to compare goods or services, or identify and parodying, criticizing, or commenting upon a famous mark owner or the goods or services of the famous mark owner. All forms of news reporting and news commentary. Any non-commercial use of a mark. Exclusions. Any non-commercial use of a mark. All forms of news reporting and news commentary. So, the tarnishment of the hospital announcing the birth of Keith Orland Little in the local newspaper is a tarnishment that is on the record, that can be pulled up and used as evidence as tarnishment, showing that you were in fact induced into believing that you were in fact that Keith Orland Little has in fact printed and publicized in that news article, and just like everybody else believed that was you. Come to find out, it's not. And that was done when you were born, before you had a chance to legitimately learn everything and become age of majority and make that discernment for yourself, where it was imposed upon you while you were a minor, while mom and dad were your parents, and not paying attention to the real thing that was going on. See, you're allowed the system to kidnap your children in that very step. Going to that hospital and bearing children. Ain't another animal on this planet that goes to a hospital to bear children. And yet mankind seems to think it's imperative. You got to go to the hospital to have children. No, you don't. No, you don't. That's the last place I would go. Burden of proof in a civil action for trade dress dilution. Under this chapter, for trade dress not registered on the principal register, the person who asserts trade dress protection has the burden of proving that the claimed trade dress, taken as a whole, is not functional and is famous. And if the claimed trade dress includes any mark or marks registered on the principal register, the unregistered matter taken as a whole is famous separate and apart from any fame of such registered marks. Okay? How do you prove something is famous? How do you prove it's not functional? Additional remedies. In an action brought under this subsection, the owner of the famous mark shall be entitled to injunctive relief as set forth in section 1116 of this title. The owner of the famous mark shall also be entitled to the remedies set forth in sections 1117 and 1118 of this title, subject to the discretion of the court and the principles of equity, if the mark or trade name that is likely to cause dilution by blurring or dilution by tarnishment was first used in commerce by the person against whom the injunction is sought after October 6, 2006. This is the Electronic Records Act, folks. October 6, 2006, the Electronic Records Act, where everything is converted from definitive paper forms to an electronic book entry system, a credit system. The mark or trade name that is likely to cause dilution by blurring or dilution by tarnishment was first used in commerce by the person against whom the injunction is sought. So the injunction is sought against the Social Security Administration. Tarnishment was first used in commerce when mom was an informant and signed up for Social Security and a birth registration, none of which is valid. In a claim arising under this subsection, by reason of dilution by blurring, the person against whom the injunction is sought willfully intended to trade on the recognition of the famous mark. There is no other reason but to authorize the individual to perform the commercial and legal functions of the operations so desired. It's the only reason they give you that ID, that Social Security card, birth registration, and then follow up with an ID or driver's license. The only reason for that process is intended trade on the recognition of a mark. And by reason of dilution by tarnishment, the person against whom the injunction is sought willfully intended to harm the reputation of the famous mark. So we can't claim any of this stuff because we really can't prove it. But we can prove that by the record, particularly if you've been pulled over and been assessed fines, fees, penalties, and all this, particularly for holding insurance and all this kind of stuff that you're not required to. You can also use that as evidence of tarnishment, dilution, not real. It's a blurring of the reality. United States citizen is a blurring of the reality that I was actually, in fact, born on the soil as an American citizen, first and foremost, if I so choose that. But that was circumvented by the administration and execution of certain documents that created birth registration and Social Security account assignment. Ownership of valid registration, a complete bar to action. The ownership by a person of a valid registration under Act of March 3rd, 1881, or the Act of February 20th, 1905, or on the principal register under this chapter, shall be a complete bar to an action against that person with respect to that mark. That is brought by another person under the common law or statute of a state. How's that for your do not detain? I got to take another break, guys. What's up? What do you think? Stop me. I'm going too far.
That's good stuff, man. You're killing it. I hope you're taking good care of yourself too.
Yeah, I think I got a little bit of a cold going on, but I don't know what the hell the deal is there. I ain't been sick in years, other than lung cancer. So what do you guys think? Christopher? Russ? Okay, well, maybe they fell asleep. Okay. Well, let's get back to it. Okay, and then B seeks to prevent dilution by blurring or dilution by tarnishment. Seeking to prevent the dilution by blurring or by tarnishment. And like I said, I've got 94 cases on there showing that things have been blurred and tarnished. Okay, so I do have a reason to seek to prevent that. Assert any claim of actual or likely damage or harm to the distinctiveness or reputation of a mark, label, or form of advertisement. So B is my avenue. Excuse me. B is my avenue. As a matter of prevention, future irreparable harm for it, that's the injunction process. Then we have savings clause. Nothing in this subsection shall be construed to impair, modify, or supersede the applicability of the patent laws of the United States. Now, notice that's not capitalized. That does not mean the laws on trademarks and patents. It means the obvious laws of the United States. Okay? Cyber piracy prevention. A person shall be liable in a civil action by the owner of a mark, including a personal name, which is protected as a mark under this section if, without regard to the goods or services of the parties, that person has a bad faith intent to profit from that mark, including a personal name, which is protected as a mark under this section, and registers, traffics in, or uses a domain name that, in the case of a mark that is distinctive at the time of registration of the domain name, is identical or confusingly similar to that mark. In the case of a famous mark that is famous at the time of registration of the domain name, is identical or confusingly similar to or dilutive of that mark, or is a trademark, word, or name protected by the reason of Section 706 of Title 18, or Section 22, wow, that's a big section there, 220506 of Title 36. So let's take a look at those. First, we got, 18 U.S. Code 706 is red cross, which would entail your humanitarian rights. Okay, so nothing too much there. Exclusive right to name, seals, emblems, and badges. Okay. Exclusive right of corporation. The name United States Olympic and Paralympic Committee. Interesting there, guys. I'm going to drop this one in the chat for everybody. We're going to take a look at that one sometime. Because it's got exclusive right to names, seals, emblems, and badges. And it starts out right at the top. The name United States Olympic and Paralympic Committee. Why are we talking about Olympics and Paralympics? Wow. I'll have to take a look at this. It's not very long, but I'll do that some other time. Let's get back. Okay. In determining whether a person has a bad faith intent, described under subparagraph A, a court may consider factors such as, but not limited to, the trademark or other intellectual property rights of the person, if any, in the domain name. The extent to which the domain name consists of the legal name of the person or a name that is otherwise commonly used to identify that person. The person's prior use of any of the domain name in connection with the bona fide offering of any goods or services. The person's bona fide non-commercial or fair use of the mark in a site accessible under the domain name. The person's intent to divert consumers from the mark owner's online location to a site accessible under domain name that could harm the goodwill represented by the mark, either for a commercial gain or with the intent to tarnish or disparage the mark, by creating a likelihood of confusion as to the source, sponsorship, affiliation, The person's offer to transfer, sell, or otherwise assign the domain name to the mark owner or any third party for financial gain without having used or having an intent to use the domain name in the bona fide offering of any goods or services, or the person's prior conduct indicating a pattern of such conduct. This is why I say it's important to understand your interactions with other people. I have a hard time getting along with people because I've been very studious about making sure that I check out their personality first. I pay attention to people's personality. People with a personality I don't like, it's because I don't see the spiritual part of it. The person's provision of material and misleading false contact information when applying for the registration of the domain name. The person's intentional failure to maintain accurate contact information, or the person's prior conduct indicating a pattern of such conduct. The person's registration or acquisition of multiple domain names, which the person knows are identical or confusingly similar to marks of others that are distinctive at the time of registration of such domain names, or dilutive of famous marks of others that are famous at the time of registration of such domain names, without regard to the goods or services of the parties, and the extent to which the mark incorporated in the person's domain name registration is or is not distinctive and famous within the meaning of subsection C. So for any one of these reasons, or through any one of these means, somebody can use a trade name similar to yours in bad faith and get all kinds of money. And if you find out they're using it in such a way, you can make a claim against them. Bad faith intent described under subparagraph A shall not be found in any case in which the court determines that the person believed and had reasonable grounds to believe that the use of the domain name was a fair use or otherwise lawful. So when it comes to the courts, knowing that they're using a name that wasn't permitted by me, wasn't consented to by me, because I didn't know they were using a firm name and connecting it to a obligor number, which is quite similar, and it kind of dilutes and pollutes and defames the true given name and family name that's associated with the Social Security number by making a false claim of a firm name with an obligor number showing like a Social Security number. And it is quite familiar. It is quite similar. So I would urge people to comprehend that that's the exact same thing that's going on in the courts. And they ain't supposed to be doing it. In any civil action involving the registration, trafficking, or use of a domain name under this paragraph, a court may order the forfeiture of cancellation of the domain name or the transfer of the domain name to the owner of the mark. So what it's saying is if you find a domain out there that's using your name similarly and it's causing a problem and you can prove bad faith, then you can take over that domain and bring it into good faith if it's a valid domain. It is property. You have a right in that because of the name. A person shall be liable for using a domain name under subparagraph A only if that person is the domain name registrant. So it has to be registered. Or that registrant's authorized licensee. Just like we've been talking about with that trade agreement with the president. It's either a registrant in the Federal Register or a licensee, both of which get a notice in the Federal Register. Okay? As used in this paragraph, the term traffics in refers to transactions that include but are not limited to sales, purchases, loans, pledges, licenses, exchanges of currency, and other transfer for consideration or receipt in exchange for consideration. This is your fiat currencies. That's trafficking. Okay? And trafficking in persons is the exchange of the personal paperwork. The ones with the marks on them. 2, the owner of a mark may file an in rem civil action against a domain name in the judicial district in which the domain name registrar, domain name registry, or other domain name authority that registered or assigned the domain name is located. An in rem civil action against the local district court for their in rem civil actions against that very mark. And you have a record that they've used it against you, the one that is in fact has the rights, titles, and interest in it and is superior to all else. The domain name violates any right of the owner of a mark registered in the Patent and Trademark Office or protected under subsection A or C. Now, the thing here we have to realize is even though it may not be registered in the Patent and Trademark Office, if it's causing harm, damage, and injury, then you still have a claim. Okay? The court finds that the owner is not able to obtain in personam jurisdiction over a person who would have been a defendant in a civil action under paragraph 1. How could you not be able to obtain personal jurisdiction over a person who would have been a defendant in a civil action? It is your person. In fact, by name. Not by document, but by name. And again, like I said earlier, in order for I guess it was on another panel yesterday or earlier this morning. In order for a court to obtain personal jurisdiction, they must first serve the defendant in the state in which the court sits, and the defendant must voluntarily appear in court. So they have to give you a diplomatic channel of notice, and then upon that notice, which they're supposed to send you a summons and a waiver of personal jurisdiction, you can then waive jurisdiction and go to court. However, one of the things for waiver of jurisdiction is appearance in court. They presume that to be a waiver of jurisdiction by voluntarily appearing in court is a waiver of personal jurisdiction. So if you go to court and ask them contest jurisdiction, it ain't going to work. They're going to say, no, we have personal jurisdiction. And they do, because you showed up. Okay? Through due diligence, was not able to find a person who would have been a defendant in a civil action under paragraph 1 by sending a notice of the alleged violation and intent to proceed under this paragraph to the registrant of the domain name at the postal and email address provided by the registrant to the registrar. So it is the registrar that's working for the notice and the postal service. Okay? And they're saying that you're a registrant. Okay? Publishing notice of the action as the court may direct promptly after filing the action. The actions under subparagraph A2 shall constitute service of process. It will. See, they don't have to have anybody receive anything. For it to constitute service of process, you just publish a notice or send a notice. They don't care if anybody received it or not. In an in rem action under this paragraph, a domain name shall be deemed to have its situs in the judicial district in which the domain name registrar, registry, or other domain name authority that registered or assigned the domain name is located. County of birth. The county of birth. The situs in the judicial district in which the registrar holds that document, the birth documents. County of birth. The document sufficient to establish control and authority regarding the disposition of the registration. Remember we talked about disposition earlier. They entered it into a disposition right away. Okay? And the use of the domain name are deposited with the court. The remedies in an in rem action under this paragraph shall be limited to a court order for the forfeiture or cancellation of the domain name or the transfer of the domain name to the owner of the mark. This is the only remedy. This is why we're talking about the injunctions and remedies above and beyond this stuff for any kind of emotional damage or irreparable harm and damage that needs to be compensated for would be another action. And you can do them in this two actions in one, but it would be a separate action. This, for this remedy, is for the name alone. And this is it relates to that name change. Okay. Upon receipt of written notification of a filed, stamped copy of a complaint filed by the owner of the mark in a United States District Court under this paragraph, the domain name registrar, domain name registry, or other domain name authority shall expeditiously deposit with the court documents sufficient to establish the court's control and authority regarding the disposition of the registration and use of the domain name to the court. And not transfer, suspend, or otherwise modify the domain name during the pendency of the action, except upon order of the court. The domain name registrar or registry or other domain name authority shall not be liable for injunctive or monetary relief under this paragraph, except in the case of bad faith or reckless disregard, which includes a willful failure to comply with any such order, any such court order. The civil action established under paragraph 1, and the in rem action established under paragraph 2 and any remedy available under either such action shall be in addition to any other civil action or remedy otherwise applicable. That's why I say you can there's a different action, but you can file them together because they require different remedies. They're just different actions in remedy. The in rem jurisdiction established under paragraph 2 shall be in addition to any other jurisdiction that otherwise exists, whether in rem or in personam. So the state can have an in rem jurisdiction, and you establish your own in rem jurisdiction. Okay. The next one I have is permanent injunction. And this is what I was talking about earlier as it relates to the permanent residence. How can I be a permanent resident if I'm not going to be here permanently? I can get a permanent injunction that would be an injunction for the permanency of my stay in this world. And it says here, a permanent injunction is a court order requiring a person to do or cease doing a specific action that is issued as a final judgment in a case. Okay, this is why the declaration, declaratory judgment is so important in understanding how that weighs out. The declaratory judgment is a determination of a party's rights, titles, and interests in the proceedings. And that declaratory judgment becomes final when it's accepted as true and correct. And declaratory judgment is not a motion. It is something you enter into the court. The court makes a determination as whether the facts and the comments in the declaration are true and correct. And there's not really much they can do but just say, well, there's an error. Otherwise, they have to render it as a final judgment. And that's based on your own words. You're the one making the final judgment by declaring yourself. Knowing the truth and how to declare that is the way to do it. Because they can't rebut it. Then it stands. My yea is my yea. My nay is my nay. You can't say anything against it unless you can prove I am in fact in error. So even if you do it, all they can really do is tell you you're in error. Most of the time, they're not going to tell you where that error is. Hopefully you can get them to tell you and then fix that error, but that's all they can really do. They're not supposed to be fomenting these kidnappings and stuff. So a court will issue a permanent injunction only where money damages will not suffice. A court will issue a permanent injunction only where money damages will not suffice. So a permanent injunction would be for your right to express yourself as a matter of freedom of transit or right to travel. By granting a permanent injunction against the police departments and issuing some kind of traffic citations, say, because we've got the licensing thing figured out and they know you're a diplomatic agent or a diplomatic envoy, and therefore anytime that they bring up a traffic violation that's going to bring up money damages, there needs to be a permanent injunction, because otherwise they would just sit there and keep putting traffic citations against you and you would just have to pay them off. So the permanent injunction is only where money damages will not suffice, because if you have a traffic citation and they just say, well, we're going to ignore that because there's no other recourse for you, then you just have to keep paying the tickets. Well, the permanent injunction prevents that, because it recognizes it as an irreparable harm and damage to paying tickets that you're not required to pay to begin with. Not only are you not required to pay, but now that you know that payment means the deferment of a debt for payment at a later date. Failure to comply with an injunction may result in being held in contempt of court, which in turn may result in either criminal or civil liability. And this part here is where they're supposed to be holding these offenses against themselves. This is for their criminal and civil liability. That's what this contempt of court here is. It's if somebody in their internal mechanism fails to comply with that trade agreement. Now they're held in contempt of court. There's a balancing test that courts typically employ in determining whether to issue an injunction. The Supreme Court in Weinberger versus Romero-Barcelo laid out a 4-step test that a plaintiff must pass to obtain a permanent injunction. That the plaintiff has suffered an irreparable injury. That the remedies available at law, such as monetary damages, are inadequate to compensate for the injury. That the remedy in equity is warranted upon consideration of the balance of hardships between the plaintiff and the defendant. And that the permanent injunction being sought would not hurt public interest. The injunction being sought is to prevent the local police officers from pulling me over in my automobile because I travel around freely without any plates. It's none of their business. I have placards that say private property, and that should be enough to tell them to leave me the fuck alone, but they don't. So it doesn't matter what kind of monetary injunction has. Their belief that I am subject to the code already is the irreparable harm that's instituted already. They're trained to pull people like me over, whether I have a right to travel around like I say I do or not. They are trained to question everything so much that it puts fear in people. In eBay Inc. versus Merck Exchange LLC, the Supreme Court further clarified that the decision to grant or deny permanent injunctive relief is an act of equitable discretion by a U.S. district court, reviewable on appeal for abuse of discretion. What do you think, Mitch? Is that the abuse of discretion that we're talking about with these administrators?
Hello.
Greetings, Brandon. How you doing today?
Just fine.
Good.
I never bonus. What's on the screen?
Well, we're going over the Trading with the Enemy Act. And what we have here is a section of the U.S. Code as a definition known as permanent injunction.
Oh, Corner Law School.
Yep.
I never been on this panel before.
Yeah, I think this is the first time I've seen you. Brandon Looney Tunes. I've seen you on a couple other panels.
Yes, okay. I'm Brandon Looney Tunes.
But yeah, basically this is an informational panel. We don't do any of the drama and stuff, so hopefully you'll be able to hang out and learn some stuff and have any input. Feel free to just let me know.
Yeah. I never met any of you guys before.
I don't know if you have or not. We're familiar with some of the panels I've seen you on, but
yeah.
Can't say for the other guys.
That's actually my username right there.
Yep. Okay, so let's get back into it here. Because in all of these cases, there's going to be some kind of balancing test. And this one here says, in balancing the damages to the plaintiff and the defendant and the public interest, the courts balance the relative harm and benefit to both the defendant and the plaintiff if the injunction is granted. A leading decision, Boomer versus Atlantic Cement Company, ruled against a permanent injunction against a cement company in a nuisance claim by the homeowners in a neighborhood. In reaching the decision, the court factored in the factory's apparent inability to develop improved abatement methods and the defendant's $45 million capital investment in the factory, both of which are factors by which the defendant would be hurt significantly. I don't know who wrote this, but this is crappy. Capital, they got a period, and then they go to lowercase to start a new sentence. No, it's and the defendant's $45 million capital investment in the factory. So that period is not supposed to be here. And then they've got a comment that says both of which are factors by which the defendant would be hurt, significantly hurt by the injunction. So somebody was high or something when they wrote this. But it should read, in reaching the decision, the court factored in the factory's apparent inability to develop improved abatement methods and the defendant's $45 million capital investment in the factory, both of which are factors by which the defendant would be hurt significantly by the injunction. Okay, so they're saying that the defendant would be hurt significantly by the injunction. And you can't have an injunction that would significantly hurt somebody else. So in our situation with the courts and the identification, the injunction for misidentification is an estoppel on the court's actions on those identification matters. Anything that would require somebody to identify to the courts would be would not be any kind of factor where it would hurt the court. Other than that, they would miss out on business that they would normally acquire only in bad faith. Okay, so it wouldn't be any harm or damage to the court, whereas it would be a positive and influential benefit to a standard of living, even as it relates to our substantive rights, to just be let alone. And that's all we're asking, is just to be let alone. We're not out here causing any kind of problems or anything. And while we're doing this, the court is actually causing us problems, and it is causing irreparable harm and damage. So we have to think about this stuff and understand that if we can get out of the hate and drama and fear and everything that's got us all confused, and think about this stuff in an appropriate manner, where we can see how it's feasible to just approach them in a competent manner of communication, saying, "Hey, I found out this, and this. In this, and this, it causes this, and this, which is very harmful to do these, and these. And I've come up with a remedy of this, and this, and this is how it's going to affect you, and you, and we all get along." That's what we're looking for. We don't want to have to sue these people in the courts, but if we have to, we'll go to that extent. What we want is just merely a correction of the record, to be let alone to our own device and not be caused harm, damage, and injury just because we're not associating with somebody that wants us to associate for their benefit. We don't have to do that. Okay? Finish off this part. It says, also in some jurisdictions, courts take into consideration good faith of the parties. If it seems that the defendant is acting in good faith by doing all that it can to abate the nuisance, the court may reflect those efforts in the terms of its order. In contrast, if the court believes the defendant is acting in bad faith, the court will show little sympathy and rule in favor of a permanent injunction. Okay? The next one I got is the irreparable harm. We saw this with Cam yesterday or the day before, I think it was. Irreparable harm is a legal term that refers to harm or injury that cannot be adequately compensated or remedied by any monetary award or damages that may be awarded later. Irreparable harm is a necessary requirement for a court to grant a preliminary injunction or temporary restraining order. Okay? So we do have to represent the idea or present the idea that it's causing harm, bring evidence that it has caused harm, and that it's irreparable in that fashion. By continuing to make me continue on with an ID as a state employee or agent, it is causing harm and damage, and that is irreparable without a proper remedy. Without a proper remedy in law or in statutes and codes, then I have to create a remedy. The creation of the remedy is a trade agreement privately with the president and the consent of the Congress. The movement or party seeking the injunction usually has to prove that they will suffer irreparable harm if the injunction is not granted. This is because the purpose of an injunction is to prevent harm before it occurs. And once harm has occurred, it may be too late to adequately compensate the injured party. And then they also have irreparable injury. Irreparable injury is a type of injury in which no financial compensation can solve, nor any actions can reverse the harm or make whole again. When an irreparable injury exists, the court can order equitable relief to remedy the harm. A common example of an irreparable injury is cutting down a tree, as that tree is irreversibly damaged and cannot be made whole again. Okay? So this is your thing here. Say what?
Talking to my dog Spunky.
Oh, okay. Well, we're gonna mute you up unless you got a specific question or something.
I've never been on this panel before.
So, Chris, when it comes to your truck, the irreparable harm is that you can't get your truck back.
Yes.
So we have I guess irreparable injury. Sorry, irreparable injury. And the problem with that being able to be fomented here is that there's really no way to recover that unless you find the one that stole it. So if you find the guy that stole it and he's already parted it out and everything, now you've got a claim. But you can't claim this irreparable injury until you find the one to make the claim against. Does that make sense?
Okay. Yeah. No, I understand that.
Okay. Okay. So let's the next one. This is the policy manual of the U.S. Citizenship and Immigration Services. And the Chapter 3 title says children born in the United States to accredited diplomats. This is why I'm talking about the diploma and those high school credits and being accredited already.
I'll be right back, you guys.
You bet. So we're already accredited under the education and the fact that we were born on this American soil. So let's take a look. The child of a foreign diplomatic officer accredited by the U.S. Department of State, and that's where you get your accreditations from, is U.S. Department of State, who is born in the United States may voluntarily register for lawful permanent residence. Okay, I can voluntarily register as well for amnesty as a stranger and sojourner. If you can voluntarily register for lawful permanent residence, you can also register for other things. You just have to be ingenuitive, and this is a matter of creating your remedy. I can't take upon lawful permanence or lawful permanent residence because I know one day I will be leaving this place. Okay? Background. Foreign diplomats enjoy certain immunities under international law. Certain. They are not plausible or implied or possible or considered. They are certain. They have already been discerned, and they are certain immunities under international law. The spouse and child of a diplomat and generally enjoy similar immunities. Children born in the United States to accredited foreign diplomatic officers do not acquire citizenship under the 14th Amendment since they are not born in the United States and subject to the jurisdiction of the United States. You understand that now, Mitch?
I pretty much understand, and
Yeah.
I'm the Looney Tunes. I am the Looney Tunes man.
Okay.
And I pretty much do have a YouTube channel.
Okay.
I'm almost at 4,000 subscribers.
Yeah, I think I'm right about 34 or something.
I'm at 39.
Yeah, you got more than I do.
On the back
anyway.
chat, on the private chat, I put in my channel.
Okay. Yep, I see that. All right. So the thing here, Mitch, is that we are in fact accredited, and what it's saying is the children born in the United States to accredited foreign diplomatic officers do not acquire citizenship under the 14th Amendment. So what do those diplomatic officers and agents in the United States do when it comes to the legal and commercial entities? They use the international forum. You don't need the 14th Amendment, folks. Understand that. They do not acquire citizenship under the 14th Amendment. And therefore, they are not born in the United States nor subject to the jurisdiction of the United States. And I wasn't born in the United States either.
I was.
And I'm not subject to the jurisdiction thereof either. And I'm sorry to bust your bubble, Brandon, but you cannot be born in the United States. The United States is a corporate entity. And if you were born in that corporate entity, I feel sorry for you.
Why do you feel sorry for me?
Because you shouldn't be making those kind of claims. It's part of the delusion of the citizenship. But anyway, back to it. So as you see, born in the United States and subject to the jurisdiction of the United States, these children do not acquire that citizenship under the 14th Amendment. DHS regulations, however, have long allowed these children to choose to be considered lawful permanent residents from the time of their birth. They do not acquire it, but DHS regulations, however, have long allowed these children to choose to be considered. This is the laying of the presumption. We choose to be considered as a United States citizen. Okay? We're the ones doing it. Lawful permanent residents. They teach us the name and address. And we pick up on it and say, okay, yeah, we'll do that. It's easy. No one ever teaches us another way. And like I said, I'll show it again. When I do an address, my address is totally different. Get rid of my thing here and bring me up full screen. And as you can see, it says Brother Keith, full colon stop, care of, semicolon, Joyce, full colon stop. Then it's got the street name with the street number, Waterloo, Iowa, with the zip code. Notice there's no brackets, don't need a bracket. United States of America. And you'll notice there's 5 lines there rather than the 3-line address that you're normally used to filling out. It's 5 lines. And notice there's no last names. So what are these? Those are given names. There's no last name and there's no first name. Those are given names, and this is not expressing any trust. It's just a foreign address that'll get it to my doorstep. So, once we come out of that indoctrination of what we've been taught to remember and believe, and get above and beyond that education and learn extracurricular things that are going to help enhance our lives, then we should start taking those on as a task. So, registration as a permanent resident under this provision is entirely voluntary, but it does involve an application process. So you have to apply for it, and it is voluntarily. Okay, so you don't have to be a permanent resident. This registration process is necessary and available only if both parents were foreign diplomats when the child was born. What? This registration process is necessary and available only if both parents were foreign diplomats when the child was born. If we're foreign diplomats, and we're subject to that foreign law because we're foreign diplomats and therefore not subject to the United States law, what makes you think that now the United States can require it as necessary? This registration process is necessary and available only if both parents were foreign diplomats. Remember what we talked about earlier, foreign. You are foreign to one another. Okay? If one parent was an accredited diplomat, but the other was a U.S. citizen or non-U.S. citizen national, then the child was born in the United States and subject to the jurisdiction of the United States and is a citizen. So any claim to U.S. citizen by either parent means that children born thereunto are presumed also automatically by record to be United States citizens. Why do you think everybody is a United States citizen today? Everybody claims to be a United States citizen.
I'm in the United States as well.
I wish I could help you, Brandon. I really wish I could. C, legal authority. 8 CFR 101.3, creation of record of lawful permanent resident status. For person born under diplomatic status in the United States. Can't be born in the United States, folks. 8 CFR 2.
Why can't you be born? Well, how come you cannot be born in the U.S.?
Because the United States is a corporation. You think the United States is what they taught you in school when you looked at that map and they said this is a map of the United States? That's not real. That's a lie. They lied to you, brother. That's a false organizational name placed upon a map of American soil.
Did you say the U.S. is dangerous to go?
Say what?
Do you say the U.S. where I live is not a good place to live?
What I'm saying is you live on American soil. And the United States is a corporation. It is nothing more than a commercial entity. And if you want to claim that you were born in the United States, I'm sure you could say that, but by the record and by the definitions, it is impossible to be born in the United States. Just saying. It's
Did
a
you-
fallacy. It's a fallacy of the language, brother.
I did put my channel in the back chat.
Yep, I saw that. I'll check it out later. Next one is D, eligibility requirements. Now, wait a minute. This registration process is necessary and available only if both parents were foreign diplomats when the child was born. This registration process is necessary and available only if both parents were foreign diplomats. But if one parent was an accredited diplomat, but the other was a U.S. citizen or U.S. or non-citizen U.S. national, then the child was born in the United States and subject to the jurisdiction of the United States and is a citizen. Don't use the process if you're a citizen of the United States as one parent or the other. If either parent claims that they're a United States citizen, then the baby will be claimed as a United States citizen. And then down here it says to register permanent residence as a child born in the United States to a foreign diplomatic officer accredited by the Department of State, the applicant must meet the following eligibility requirements. The applicant must voluntarily seek to register permanent residence. The applicant was born in the United States. If you were born in the United States,
That's me.
and are a citizen of the United States and subject to the jurisdiction thereof, you're already granted permanent residency. So why would you need to apply? See, some of this stuff just doesn't make sense to me. You know what I mean?
Yes.
The next one, the applicant maintained continuous residence in the United States since birth. And like I said, Iowa is not in the United States. Iowa is a state or a republic, and the state of Iowa is in the United States only in the territorial, special maritime territorial jurisdictional sense. It is not in the United States in a geographical sense because the state of Iowa doesn't exist in a geographical sense. Iowa does, but the state of Iowa does not. Okay?
Yeah.
So the applicant maintained continuous residence in the United States since birth. Again, an impossibility because you cannot reside in the United States. You cannot reside in a corporate contract. Okay? The applicant is physically present in the United States at the time he or she files the application. Now, if the location of the debtor under UCC 9-307 says the United States is located in the District of Columbia, you would have to go to the District of Columbia and apply in physical presence. Okay? The applicant is physically present in the United States at the time he or she files the application. So I can't file it from here. Okay? I have to be physically present in the United States, which is located in District of Columbia. Now, I want to know where the District of Columbia is. That's at 10 square miles. And that is rented by a foreign corporation. Wait a minute. You mean if you're born in the United States, you were actually born in a foreign corporation? Uh-huh. See the problem with that? The applicant had a parent who was listed on the Department of State's diplomatic list. Remember the diplomatic list? That was the sanction, the administrative list and the free list, also known as the blue list, at the time of applicant's birth. The applicant lost or waived his or her diplomatic immunity. Remember, you got a high school diploma, right? Did you turn around and waive that when you walked into the D.U.M.B and got a state ID? Mm-hmm. Yep. In my opinion, that's exactly what happened.
Yeah, and that is in your opinion.
Then it says voluntarily seeking the benefit. This is automatically established by the applicant applying to register permanent resident status in the United States. Voluntarily seeking the benefit. This is automatically established by the applicant applying to register permanent resident status in the United States. Born in the United States, the applicant must establish birth in the United States. This goes to have birth registration standards and the minimums that are not qualified because it's not registered in the United States. It is, in fact, registered in the state in which you were born, telling me that if I'm born in Iowa, then I obviously wasn't born in the United States.
That's me. I was born in the United States.
What state were you born in?
Ohio.
So you're born in Ohio and the United States? You were born twice? You were born twice in two different places?
I was born once.
Well, you just said you were born in Ohio and born in the United States. That means you were been born twice.
I live in the U.S. and I was born in Ohio.
So you're born in Ohio and you live in the United States. Where's the United States?
No, the U.S. That's where I live.
Where is the United States?
Why do you? No one ever says me that before.
Okay, well, let's take a look. Because under UCC 9-307, it says location of debtor. Okay, so understand under location of debtor, we go down to H, and it says location of United States. And it tells us the United States is located in the District of Columbia. That's the 10 square miles of land rented by a foreign corporation. So were you born in Ohio or were you born in District of Columbia? As you say,
Ohio.
United States. So you were born in Ohio and not the United States.
The state.
This doesn't
Ohio
say.
is the state of the U.S.
No, this doesn't say the United States is located in Ohio.
It's located in Columbia.
Right. It says it's located in District of Columbia. And never will you find anywhere it says Ohio is located in the United States, except in the false education system, because that is a misnomer that Iowa, as a republic, a place of soil of the land, is located in a fictional boundary called the United States, which is in fact located in the District of Columbia. If the United States is located in the District of Columbia, then it does not expand beyond the District of Columbia. Therefore, when they told you in school that map says this is the United States, that was a lie. Here it clearly says United States is located in District of Columbia. Nowhere else will you find anything but a map describing the United States the way it does today. But literally, the language itself says the United States is located in the District of Columbia, and you will find nowhere else where the United States is described in this manner. None.
None.
So let's go back.
Is any other people here?
There's 4 of us. And it says, continuous residence in the United States, generally absences that would not affect the status of any other LPR, do not break the continuous residence of an applicant under this program. Some additional guidelines are applicable to this particular type of case. Temporary or extended absences from the United States do not break continuous residence if the diplomatic parent remained accredited. Readmission to the United States as an A or G non-immigrant at the end of an absence does not break an applicant's continuing residence. And departure of the applicant's diplomatic parents does not break the applicant's residence of the applicant remains in the United States. Parent with full diplomatic immunity at time of the applicant's birth. The diplomats accredited to the United States and having full diplomatic immunity are listed on Department of State's diplomatic list, the blue list that we were talking about earlier. If either parent was listed on the blue list when the applicant was born, the applicant is eligible to apply for this benefit. Both parents do not have to be listed for the applicant to be eligible.
Yeah, the eligible.
Not all diplomats or employees of certain designated international organizations admitted to the United States as an A or G non-immigrant have full diplomatic immunity and appear on the blue list. For example, the immunities that apply to a foreign consular officer are not the same as those that apply to diplomats. In order to determine eligibility to register for permanent residence based on being born in the United States in diplomatic status, the applicant must submit official confirmation of the diplomatic classification and occupational title of his or her parent at the time of birth.
Yeah, time of birth. Where were you born at?
And remember, this is only for people that are applying for diplomatic or for permanent residence. I was born in Iowa.
Was you even born in the U.S.?
I was born in Iowa.
I was born in the state of Ohio.
So then the next one, it says, USCIS confirms with the Department of State whether the applicant's parents was on the blue list at the time of the child's birth. If an applicant did not have a parent on the blue list at the time of his or her birth in the United States, then the applicant is a U.S. citizen because the applicant did not have full diplomatic immunity and was therefore subject to the jurisdiction at the time of birth. How fucking ridiculous is that, folks? Let's talk about this. How can a child be subject to the jurisdiction of the United States at birth? How can a child be subject to corporate law at birth? The fuck is wrong with this society that anybody would believe that? Is it not until the age of majority where one becomes susceptible and claims that he's of age of majority and therefore competent to contract, that contracting entity would have any jurisdiction?
Many people say I have the best streams.
Well, we're not talking about your streams, Brandon. We're here talking about Trading with the Enemy Act, brother. Okay? Thank you. I hate to sound mean and stuff, but it's just not the place for people like that. My apologies. Anyway. Applicant lost or waived diplomatic immunity. Now, what happens when you go get that state ID? That's not the Department of State that you got it from. So by getting that state ID or driver's license, It's a waiver of that jurisdiction. It's a waiver of that immunity. It's a waiver of that diplomatic immunity. And no, your person is not born in the United States. There's no registration in the United States of that person. It's not registered there yet. Your business person is born in the state you were born in. Okay? And that's where the registration is. It is not in the United States. There is no birth registration in the United States. However, you can register it in the United States by registering it on the Federal Register as a trade agreement in the name of, as a removal from state jurisdiction. You now have a contract with the president, and the contract is law. And if you think the state is going to violate the president's contract, you're wrong. See, it's no longer just a matter of my contract. It's a matter of president contract. And that's done through, again, the House and Senate of Congress and presidential agreement. It's an international trade agreement that you have a right to make yourself rather than being presumed to be under the international trade agreements of the United States.
The
Okay?
right to self-determination is fundamental.
Correct. Absolutely. So, because the applicant went and, or because the guy went and instead of using his diploma, he went and got a state ID, he lost and waived his diplomatic immunity and became subject to the civil community and its fines, fees, penalties, and offenses. The lowest jurisdiction there is. Because an LPR cannot be immune to the laws of the United States, applicants who retain diplomatic immunity at the time they apply to register permanent residents must submit with their application a completed and signed request for waiver of certain rights, privileges, exemptions, and immunities, a Form I-508. So you have to give up certain rights, privileges, and stuff in order to do this. Why would you do that? You know you don't have to waive any rights to receive the benefit of a right. Yet that's what they're asking you to do here. However, if at the time an applicant applies to register lawful permanent residence, the applicant has lost diplomatic immunity as verified by USCIS through the Department of State, then the applicant does not need to submit Form I-508 with the application. E-documentation and evidence. Remember, we talked about that December 6, 2006, October 6, 2006, the Electronic Records Act. An applicant should submit the following to establish eligibility for lawful permanent residence as a person born in the United States to an accredited foreign diplomatic officer. Application to register permanent residence? Nope. See, again, you don't want an application to register for permanent residence. I'm not going to live here forever. I'm passing through. So mine isn't a matter of application to register. It's a matter of registering a trade agreement to keep my own fucking shit, to be left alone, the right to be let alone, the right to enjoyment of possession and use of my things. Okay? So none of this stuff is really required, even when it comes down to the 2 passport-style photographs. Copy of government-issued identity document with photograph. Copy of birth certificate. Why would I want to try to come up with all this shit? Sounds like I just got to reconfirm my some kind of fucking bitch-ass slavery. Not going to do it. Official confirmation of the diplomatic classification and occupational title of the applicant's parents at the time of the applicant's birth. I don't know what it was. I don't know what my parents did when I was born. I can't even remember what I was doing. My own damn self. What makes you think I know what my parents were? You see the idiocy that they ask you for? And people are willing to say, oh, well, let me go ask my dad. That's hearsay. You putting it down for your dad, that's hearsay. If they want to know that information, they're supposed to be asking dad and mom. They are specifically asking you for hearsay, and you're saying, okay. Adjudication. Adjudication. This has to do with judicial concerns. Again, the Postal Service. A decision on registration of those born in the United States in diplomatic status does not involve any consideration of admissibility or discretion. If the applicant meets all eligibility requirements, an officer must approve the application. USCIS may require the applicant to appear in person for an interview if needed. If approved, USCIS assigns the following code for admission. Born under diplomatic status in the U.S., DS1. Code of admission. Nothing else. The effective date of permanent residence is the applicant's birth date. Then it's got all the footnotes. Okay, the next one is 8 USC 1101 as it relates to what we just went over there as to permanent residence. And what we're going to look at here is a few terms. First one is 12, I believe. 13, 14, 15, where is 11? The term diplomatic visa means a non-immigrant visa bearing that title to a non-immigrant in accordance with such regulations as the Secretary of State may prescribe. Okay? Non-immigrant visa bearing that title and issued to a non-immigrant. (15) The term immigrant means every alien, except an alien, who is within one of the following classes of non-immigrant aliens. A, an ambassador, public minister, or career diplomatic or consular officer who has been accredited by a foreign government, recognized de jure by the United States, and who is accepted by the President or by the Secretary of the State and members of the alien's immediate family. How's that one suit you, Mitch? You like that one?
Yeah, that's good stuff, man.
Recognized de jure by the United States. Okay. The next one is G. A designated principal resident representative of a foreign government recognized de jure by the United States, which foreign government is a member of an international organization entitled to enjoy privileges, exemptions, and immunities as an international organization under the International Organization Immunities Act. Accredited resident members of the staff of such representatives and members of his or her or their immediate family. I don't know that there's much else to discuss now, huh? I mean, when you put it all together and you find out that, yeah, I got a high school diploma, and those were high school credits. That means I was accredited, and I was born on the American soil. I'm domestic, and it's the United States that's a foreign corporation that's renting a portion of that land that we belong to. Yeah, they're the foreign entity. So yeah, I am the de jure. and domestic. And I have the true plenipotentiary powers if I just learn them and assert them. This government that wants to take care of everybody and profess that it's doing a good job providing benefits, and of course they've got all those different agencies and everything to take care of those things. I'm neither needing of those benefits nor qualifying of those benefits. Again, he's a respecter of no persons, and the only way to receive one of those benefits is through persons. So, let's see here. Remdog says, I believe the birth certificate refers to a child. No matter how old you are, the birth certificate always refers to a child. Yes, it's a definition of a person of some sort, and the birth certificate recognized as a minor, infant, a juvenile, a child, all kinds of things. But again, you have to understand those are nouns that predicate certain business or legal activities. And when we learn thyself, when we separate from that, we join with the natural world and become more apparent in our presence as somebody real and logistical, rather than just a bitch ass slave that's going around to get along, doing everything to get along. You know, they have no interest in their own real life and doing things of any grave nature or expanding any boundaries. They're comfortable with what they've got. And of course, the comfort is always, or for the most part, sitting back on the couch and watching the boob tube, you know, somebody else's dramatic, exciting life, because theirs is so amazing, you know. So let's get back into it. The next one I've got, international diplomatic protocol and etiquette. I just ran across this. It's a National Association of Secretaries of State. And this was a conference they held this last summer. And this is what we're talking about, is learning the international affairs and being able to deal with them on our own individual local level. I don't know what I had this up for, other than just to show you a piece of information that I ran across. And I'm going to be, you know, working on this as well. That, like I said, it's a matter of diplomacy, and we have to learn how to be diplomatic ourselves. We have to learn how to communicate in the international forum, because they didn't teach us that in that high school or in the school system. This is it's amazing that we're in 2025 and this information has not only been around, but very available for a number of decades, and nobody's picking it up. It's amazing how long it took for people to realize how degrading it is to have an administrative system that's not paying attention to the reality of the law and is using the law for their own private gain and unjust enrichment, and it's pathetic. So when I get this sorted out for myself, and I've got something comprehensively developed that has proven my ability to move forward and correct certain things, I will put it out. So in the meantime, this is just a presentment of information that I've gathered to show a walkway of how to get some kind of remedy. I don't know if it's going to work or not. The way it sounds in my mind and feels in my heart, I have great great expectations. I will call them expectations. I have great expectations that it will work, and there may be certain things along the way that I'll have to deal with, and it may take a while. But I have great expectations that it will work. It just seems to be so sensical and reasonable and simple, in fact. But again, here we are, decades into things that people have been claiming that they're just doing their job, and that's all that's doing is making things more and more difficult. As we continue on, generation after generation, saying, "Well, I know what I'm doing," without actually looking at what the reality is, we end up with a base of people that, just like our education has an average of reading comprehension of 8th grade, we have a base of people in the workforce that have nothing more to worry about than just doing their job. They don't want to think about anything extra and going the mile that they're supposed to do to make sure that in that job they have integrity. And that's the problem. Nobody really gives a shit about the integrity. They just know that they've got a job to do. They're doing the job the best they can, and that's all that matters. Well, it's time to start quit allowing people that are just doing the best they can, and start demanding the best that we deserve, because it's gotten the standards of care and administrative enforcements and stuff is just way out of alignment with what it should be. My God, they claim 95% success rate in these defenses or these prosecutions, and that means you only have 5% of people that are able to defend. Where else in history, in any sporting arena or any other competitive market of any kind, do you have that kind of a rate? Does that not sound like the true monopoly? Anyway, so let's get to the next one. And this is a 37-page document here. Now, I'm not going to read the whole thing, but this is the last thing I've got up. And we could, I guess. We've only been on 7.5 hours. Still got another 4.5 hours to go. I thought it would take me a little bit longer than that to get through this, but I figured about a 12-hour Zoom. But I never planned or intended on reading this whole thing. But it's here, and we can if we need to, if we want to. Foreign Service Institute, U.S. Department of State. Mission statement. The Foreign Service Institute develops the men and women our nation requires to fulfill our leadership role in world affairs and to defend U.S. interests. Established in 1947, the Foreign Service Institute is the United States government's primary training institute for employees of the U.S. foreign affairs community, preparing American diplomats and other professionals to advance U.S. foreign affairs interests overseas and in Washington. Foreign Service Institute provides more than 600 courses to include training in some 70 foreign languages, as well as in leadership, management, professional tradecraft, area studies, and applied information technology skills to some 100,000 students a year, drawn from the Department of State, more than 40 other government agencies and military service branches. Foreign Service Institute provides support to all U.S. government employees involved in foreign affairs, from State Department entry-level specialists and generalists to newly assigned ambassadors, and to our Foreign Service national colleagues who assist U.S. efforts at some 270 posts abroad. Few things are as anxiety-provoking for the first time embassy or mission employee or family member as the notion of diplomatic protocol. Protocol can sound both stuffy and mysterious at the same time. And most of us believe we have had little experience in our non-government lives to prepare us. In fact, the rules and processes of diplomatic protocol are based in pragmatic thinking, common sense, and good manners. Areas where we all have had some experience. Protocol makes the job of representing our nation easier by facilitating our work as a mission team, making our relationships and interactions within the diplomatic and host country communities more predictable, and by providing a basic social framework and hierarchy to follow. We've designed this booklet to help you begin to master the basics of diplomatic protocol. Whether you are an employee or spouse, you have few spouse have few representational responsibilities or are running your post-protocol office. This booklet is a good starting point for you. The booklet's 4 main sections deal with international culture, U.S. mission culture, the host country culture, and entertaining. A bibliography and diplomatic glossary are included at the end of the text. Our sincere hope is that you take the time to read through Protocol for the Modern Diplomat and make a point of adopting and practicing this art and craft during your overseas assignment. We believe doing so will make you more personally effective overseas and thereby make our mission more effective. Protocol is not an end in and of itself. Rather, it is a means by which people of all cultures can relate to each other. It allows them the freedom to concentrate on their contributions to society, both personal and professional. And protocol is, in effect, the frame for the picture rather than the content of it. Okay? In the related atmosphere, in the relaxed atmosphere of American society, many of the rules of social behavior that were routine a generation ago are today largely ignored, if not unknown. I think that's a very true statement. It's like chivalry. The social behavior of a chivalrous society lapsed long ago, and then the relaxed atmosphere of the American society, it's gone and gone by the wayside as well. Okay. American casualness is often interpreted as rudeness in other societies. What does it say if the representatives of the world's most powerful nation are indifferent to the appropriate respect owed to representatives of other nations or to ranking members of their own staff abroad? This can be taken as a personal or national insult. There is rarely an entirely private situation in which one's behavior is not being observed. International culture at gatherings that include representatives from the host country as well as from other countries, the timeless formality of international diplomatic culture remains in place. It ensures that each country will be respected uniformly and without bias. The necessary respect is expressed most visibly through spoken courtesies. Below are some tips on how to address and introduce diplomatic representatives. And like we were talking about earlier, when it comes to addressing people, and you address them and don't require an address, you address them appropriately by the language. I don't know what's going on here. All of a sudden, I lost my background. Background doesn't want to come back up. Hmm. We're running at 7.5 hours right now. I was thinking it's going to take about 12 hours, so we're actually going to end up running short here because I'm just about done here. But as we're looking, get back to it here. Although guidelines exist, proper forms of address vary greatly from culture to culture. Be sure to check local customs, but a few general rules follow. The spirit of formality among diplomatic representatives usually means not addressing others by their first names as quickly as is done in the United States. One should rely on courtesy titles until invited to do otherwise. Socially, one can refer to a spouse by his or her first name or as my husband or my wife rather than Mr. or Mrs. Smith. When dealing with household employees, however, you should still refer to your spouse as Mr. or Mrs. Smith. Ambassadors are addressed as Mr. or Madam Ambassador or Ambassador Jones. Only by special invitation or long friendship should one address an ambassador by first name, and then only when not in the public eye. The indirect address refers to the ambassador as the ambassador, with his or her spouse as the ambassador and Mr. or Mrs. Jones. Or if the ambassador's spouse is a woman who kept her maiden name after marriage, the ambassador and his wife, Mrs. Smith. An ambassador of the United States may continue to be addressed as Mr. Adam or Mr. or Madam Ambassador after retirement or after returning from his or her duties abroad. In some French-speaking countries, the wife of an ambassador may be referred to as Madam Ambassador. Therefore, in those countries, refer to a female ambassador by her last name, Ambassador Jones, to avoid confusion and ensure that she receives her due respect. And the rest of it's gonna talk to you about how to address people by their titles, chiefs of mission, ministers, and others, government titles. And so what I'll do is I'll copy this, and I'll drop this in both the public chat and the private chat. And this is the homework now. And I'm going to tell you that it's going to go above and beyond It's going to go above and beyond the Department of State here that I'm talking about in Homeland Security. Because as I mentioned earlier, we're dealing with the American states, which is North America, Central America, and South America. And when we're talking about this diplomacy, it's not at the United States level, it's at the international level. And at the international level, we're not looking at anything else than the Organization of American States. And when you look at that and find out about diplomatic transit, which we will be going over here in the short future as well, we understand that we're looking at a grander scale of that right to travel and all of these things that deal with the legal and commercial entities that again, you have to have a good comprehension and be able to manage your own plenipotentiary powers either individually or get together with a group of people that can handle it together for each and every individual that then joins that group. And this is the thing about coming together in these forums and doing this research and showing people what it is and where it's at and giving your interpretations and discernments and hoping people will rise up. See, I make a challenge out there to anybody throughout this entire world, all you bankers, lawyers, judges, all you professionals, you English majors, all the people out there that think that I might be saying something wrong, please stand up and correct me. Because if you honestly have something that shows I'm wrong, then bring it forth. I challenge that. I'm not afraid of the truth. So when you bring something at me and make me review something that I've said and say, oh, well, I guess I was wrong in that, I have no problem with that. That's the problem most people have. So when I talk about things like the minimum birth registration standards are failed, they fail, I mean it. You show me, because it says born in the United States, and we see that United States is located in Washington, D.C., so I'd have to be born in Washington, D.C., that perimeter at most, or at minimum, excuse me. And the fact that it's supposed to be registered in the United States and it's not shows that I was born outside of the United States and not in the United States. And that since there's no birth registration in the United States, it's not been registered in the United States. So it fails twice, one of which cannot be corrected. I cannot go back and be born in the United States. So I was not born in the United States, failure. It's not registered in the United States, failure too. I can correct the one to provide some kind of remedy for the first failure. Since I'm not born in the United States, I can still remedy a trade agreement with the United States as a matter of diplomacy already accredited. And that's what we're talking about. So that brings us, I certainly thought we would have some more interaction on this. I was hoping we'd have a full panel. But it is what it is. And that, of course, would have helped drag it out. I'm sure other people on the panel would have helped bring in some more information. But again, it is what it is. And hopefully we'll be able to expand upon it more further next time. Again, in the meantime, I did do a 4-part series on the Trading with the Enemy Act in accordance with a Cambridge University press about 6 months ago. So if you go back, there is a playlist, Trading with the Enemy playlist. Just check it out. There's 4 videos on there. I'll put this on that playlist as well. And check out those other 4 videos as it relates to the Trading with the Enemy Act and what Cambridge University says about it. Because I've dropped some things in here in relations to it as far as it's a program of economic warfare. It's fomented for the causes of war, but it's expanded beyond the war fields to times of peace on domestic soil against the very people that are supposed to be protected by it. It's a matter of foreign property acquisition, and everybody is foreign to the United States. So anyway, that brings us to the end of it today. My apologies, it wasn't 12 hours long as I thought. But what do you guys got on the way out? Well, I guess they're not listening either. This has been a wonderful show. Anyway, so you guys know me. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see everybody next time. Bye now.